Your Lordship, the present matter was a dated matter, Your Lordship. It was to be listed on 6th, Your Lordship, but it was not listed on 6th. There is a Your Lordship, the petitioner is a senior citizen. He has not been given with any retirement benefits, Your Lordship, from past 5 years.
Next week.
Your Lordship, I request for a date, Your Lordship.
Some date he will give that. Yes. Yes, madam. 37.
Number 4, my lords.
Lord, for respond number 4.
4. Praise for a short accommodation, my lords. There is
Court
some.
moved. Who has?
Please, petitioner has moved, my
You have moved.
lords. Senior is out of station, my lords.
Objection for adjournment.
Please, my lords.
Next week. At the request of so and so.
Please.
Mr. Fadke.
One matter, man. It was ordered to be posted last week. I thought it will come at least yesterday. It is covered by the judgment, man. 10 years is over. After he read, he now 70. Order is in my favor.
Third, next week.
With the Lordship's kind permission,
Ah.
Lord, State Commission has passed an ex parte order, my lords.
Commission.
State Commission, House only. Subsequent to which an execution has been filed and a warrant has been issued. My lords, a joint development agreement, my lords, in which I am the owner. I have terminated the contract. The builder has cheated everyone, including me, my lords.
Day after.
Much.
ನಮ್ ಕೋರ್ಟ್ ಮೊದ್ಲೇ ವೀಕು ಅವುಗಳ
ನಮ್ದೇ
ಐಟಮ್ಸ್ ನೀವು
ದರ್ಶನ
ಮುರಿದು ಹೋಗ್ಬಿಟ್ರೆ ಅವ್ನು ಮಾಡಿ ಕೊಡೋರು ಯಾರು Yes. All your contentions we summarized and we have considered and dismissed.
Thank you, Your Honorable Chair.
Why they are not coming to this court? ಅಂದ್ರೆ ಆರ್ ಎಫ್ ಎ ನಮಗೆ ಹಿಯರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಹಂಗಾಗಿ ಅವ್ರು ಏನಾರ ಮಾಡ್ಲಿ ಅಂತನೋ ಏನೋ because other day this is third consecutive absence. Furnishing of PF copies to issue notice to steps to be taken within 1 week, failing which IA stands rejected. IA stands rejected and also appeal stands dismissed. Yes. The steps and compliance within 1 week, failing which IA also stands rejected and IA and appeal both stand rejected. Yes.
For the appellant, my lords, I pray for a week's time to take fresh steps, my lords.
First steps for
Fresh steps for respondent number 6, my lords.
My lord, on humble submission, my lord. My lord, this is suit for partition and separate possession. My lord, as per our information, my lord, R6 is was a tenant in that item property, my lord. He was not a family member, my lord.
not a member.
As per
I'll
our
ascertain, my lords, I'll ascertain.
No, ascertain and tell us, pass out. Otherwise you will go on protracting the proceedings. Yes, pass out, pass out. If he is tenant, why he should be? Yes. Early hearing allowed, application in for early hearing allowed. Call this matter in the second week of February 2025. Please. All right.
But I beg to appear for the petitioner's counsel.
You need not beg at all. Your most valuable right, please do not use such words.
Great. No,
Yes.
no, I'm not on record there.
All right, you can say I seek permission, etc.
Great. Now, my lord, the rejoinder is also filed. The pleadings are complete.
Ah,
And Lord may set it for hearing, Lord, any date convenient to your lordships. The rejoinder is also filed, objections are also filed, and interim order is also granted. The IA may not survive for consideration. The interim order is also granted.
Since the interim order has been granted, counsel for the petitioner submits that IA may not survive for consideration. IA number so and so and so consideration. And accordingly, the said IA is disposed of.
And rejoinder is also filed, my lord, as per the orders of this honorable.
We'll call this in the second week of January. Yes,
Ah.
this matter in the third week of January.
Great. There's some urgency because the appointments are stayed.
It's not, you are already enjoying that.
I am not in employment, my lord. I am not in employment. The entire appointment process is stayed, including my appointment.
First week of January. All right. Next,
Lords, interim order may kindly be extended.
interim order to continue.
Right.
Till then. Time for compliance was granted on as many as 4 occasions. First off. The objection of serious idena? ಕೊಡಿ ಯಾಕೆ ಅವಶ್ಯಕತೆ ಇದೆಯಾ? State Bank of India. State Bank of India. Yes. Good evening. How can registry raise an issue as to who is a necessary party, who is a proper party? For the parties to argue if they want. They are just pointing out. Hold on. 4 opportunities granted by the coordinate bench of this court having not been utilized, we have reason to believe that the petitioner is no longer interested in prosecuting this petition and therefore dismiss it for non-prosecution. Yes, Mr. George.
Please, Manoj. The course of the day, I'll comply with your subjection. I need to affix a welfare stamp.
Office objections raised on IA 2 of 2024 additional grounds. Please. Objection.
Objection, I have welfare stamp, in the course of the day, I shall do it. Manoj.
ಮತ್ತೆ ಅದ್ರ ಸಲುವಾಗಿ ಒಂದ್ಸರಿ ಮತ್ತೆ ಮೂವ್ ಮಾಡೋದು ಇದೆಲ್ಲ ಬೇಡ.
Next week.
Objection. Stamp ಇದೆಯಾ? Office objection is complied with in the open court with leave. What is this matter?
This is a challenge to the order passed by the Armed Forces Tribunal. Your lordship could
Order
kindly have
passed
it
by?
next week, my lords.
The Armed Forces Tribunal,
Ah.
has passed the order, my lord.
AFT order.
Please, my lord, against which an SLP was filed. SLP is dismissed. Thereafter, my lord, in other case, my lord, the Honorable Supreme Court told, my lord, it should be considered by the High Court after the Armed Forces Tribunal, my lord.
They should not directly go
They should
to,
not,
like Chandra Kumar.
please, they'll have one more benefit here. Therefore, my lord, after that order, my lord, the petitioners approached this court, my lord. Then now, my lord, my learned friend, after filing of objections, my lord, he's raised some other grounds, my lord. I'll just file a formal reply to that also, my lord.
You want time?
Please.
Please.
Learned DST seeks time
My
for
lord,
this matter.
it's my learned friend is,
No,
he's also
Kindly
seeking.
have it next week.
Please, my lord.
Both the sides seek time. First, call this matter in the second week of January.
Please.
Await Marna. Await Marna. Service-
In fact, the counsel who is appearing for one of the respondent, he himself was the applicant. He is the applicant for all the persons before Kate. He can as well take notice, my lord, instead of.
Yes. Learned 4 to 7. Counsel Basuraj Patela. Yes. Patel appears for unserved respondents. That is respond 4 to 7. Yes. Yes. Firstly,
Objections, if any, you may file with.
yes, first, objections, if any, may be filed within 4 weeks. Yes. Anyway, officer.
3 to 7, not May 40.
Let me show. 3 to 7 party madilva.
Well, those are the persons, my lord, who are the applicant before the tribunal. Therefore, they are not necessary, my lord, they are not necessary parties, my lord.
The explanation offered for the offered having been accepted, office objection is overruled. Yes. Yes, Mr. Kulkarni, furnishing of the issue notice to Avan for second time.
Petitioner by me, my lords.
Second time, how many times you want?
No, my lords. Union of just the respondents are already served. They are there on record actually. Last time it was heard and then they decided.
You
interim
can
order.
apply for PMG, na?
Please.
Learned DSG on request appears for
All the-
respondents. Copy diya?
Them, my lord.
Objection ಹಾಕ್ಬೇಕಾ ಇಲ್ಲ ಅಥವಾ argument ಮಾಡ್ತೀರಾ?
We're ready with the short point is that, my lord, the material witness has filed the charge sheet is what my learned friend says, my lord. The material witness could not have filed the charge sheet is there, my lord. Since he being a witness, he should have not filed the charge sheet. The short point is that, my lord. So what,
ಇಲ್ಲಿ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. Charge sheet under 173,
no, my lord, in the
Huh?
disciplinary authority.
charge memo.
Charge memo, I'm sorry,
Ah.
it's charge memo. He could not have filed it, my lord. Therefore, my lord, my
He
humble
could not
submission.
have, he could not have issued it.
He could not have issued it. He could not have issued it. My humble submission is that, my lord, if your lordship may fix a date, my lord, on that point, my lord, I'll just argue, my lord, we'll withdraw the charges framed against him, my lord, and we'll file.
ಫಿಕ್ಸ್ ಮಾಡೋದು ಇಷ್ಟೇ ಆರ್ಗ್ಯುಮೆಂಟ್. ಬೇರೆ ಆರ್ಗ್ಯುಮೆಂಟ್
ಇಲ್ಲ,
ಇದೆಯಾ?
ಬೇರೆ argument ಇದೆ, my lord, if your lordship may give me some more time, my lord,
Call this matter week after next at the request. of
Interim order is there, it may be issued.
Entry matter ಇದೆಯಾ?
ಇದೆ.
ಇದೆ, Swami. After hearing both
Call this
sides.
matter in the second week of February 25. First of, interim order granted shall continue.
I am grateful.
Okay. Yes.
That is a case of drugs controller. Deputy drugs controller. Promotion to the post of additional drugs controller from the cadre of.
Which other day, Mr. Varun Kumar has a.
Yes, my lords.
Let
Yeah,
it go
I
before some
understand.
other judge. Call this matter before a bench in which case DJ is not there. Immediately, okay. Because he said, why so much haste is being shown? Therefore, they are entitled, they make form their impressions. And there are many judges in this court, not only Dixit. All right, send it before some other judge. Yes,
My lords, we have already filed the objections also.
all right, well, next. ನಾವು ಕ್ಲಿಂಗ್ ಆನ್ ಆಗ್ಬಾರ್ದು ಯಾವ ಮ್ಯಾಟ್ರಿಗೂ. ವೈ ವಿ ಶುಡ್ ಕ್ಲಿಂಗ್. ಆಲ್ ರೈಟ್, ನಾವಿಲ್ಲ ಇನ್ನೊಂದ್ ಕಡೆ ಹೋಗಿ ನೆಕ್ಸ್ಟ್ ಅದಕ್ಕೂ
My lord, I remember,
ಅಷ್ಟೇ ಅದು.
I remember when a question was put to the Nariman, senior Nariman, he said, even if the court calls me in the midnight, I'll come and assist them. That was the Not in a case where when court wants to hear the matter. I want December.
ಅಲ್ಲ ಅಲ್ಲಿ ಏನಾಗ್ತದೆ ಪಾರ್ಟೀಸ್ ಏನೇನೋ ಇಂಪ್ರೆಷನ್ ಫಾರ್ಮ್ ಮಾಡ್ತಾರೆ. ಅವಾಗ ಲಾಯರ್ಸ್ಗೆ ಆಪ್ಷನ್ ಇರಲ್ಲ. ನೀವು ಇದನ್ನ ಹೇಳಲಿಲ್ಲ, ನಾವು ನಿಮ್ಗೆ ಹೇಳಿದ್ವಿ, ನೀವು ಇದನ್ನ ಹೇಳ್ಬೇಕಿತ್ತು, ಹಿಂಗೆಲ್ಲ ಮಾತಾಡ್ತಾರೆ.
ಅಲ್ಲ ಅವ್ರು 100 ಹೇಳ್ತಾರೆ, ನಾವ್ ಹೇಳ್ಬಾರ್ದು.
ಬಟ್ ಎನಿವೆ
ನಾವ್ ಏನ್ ಹೇಳ್ತಾರೋ ಅದ್ ನಾವು ಕೇಳ್ಬೇಕು ಅಷ್ಟೇ.
ಪ್ರೊಫೆಸರ್ ಫೆಲ್ಟ್ ದಟ್ we were eager to hear this matter ಅನ್ನೋ ರೀತಿಯಲ್ಲಿ ಹೇಳಿದ್ರು ಅವರು. But why there are many judges, not one judge here. That there are far better judges, at least than me. So
Not immediately.
not immediately. Okay. Much okay.
This
Yes.
matter, my lords, the petitioner claimed reservation.
Whether he is handicapped plus vertical and horizontal both.
Both he is eligible, my lords. And in
If
the.
suppose horizontal is removed,
No.
this is IAS,
Yes,
IRS
yeah,
section,
this is,
na?
my lords, this IRS income tax. Even if he doesn't claim the horizontal reservation, he is entitled for vertical
The
reservation.
scheduled caste candidate.
He-
Huh.
Yes.
What I was thinking. No.
ಹೇಳಿದ್ರು.
ಅವ್ರು ಈಗೇನು ಡಿಸೆಂಬರ್ ನಲ್ಲಿ ಇದೆಯಾ, ಯಾವಾಗಿದೆ ಅದು? ಟ್ರೈನಿಂಗ್
4th December, the training is starting, my lord.
ಟ್ರೈನಿಂಗ್ ಹೋಗಲಿ, ನೀವು ಯಾವ ಇಕ್ವಿಟಿ ಕ್ಲೇಮ್ ಮಾಡಂಗಿಲ್ಲ.
ಇಲ್ಲ, ಇಲ್ಲ. I will not claim, my lords. Let him go
Oh,
for.
equity. Nothing will happen. Alright, it's all right. IRS, he is a
5th
member of
December.
scheduled caste, very meritorious. And even if horizontal reservation is ignored, he will fit into the regular, the vertical reservation itself. Very meritorious candidate. All right, all right. Yeah, nothing, what is going to happen? He will be trained along with rest of the people. No equity, nothing. Navin post ಕೊಡ್ತಾ ಇದ್ದೇವೆ. Very good.
My lords, the facts are like this, my
Okay.
lords.
Having heard learned counsel appearing for the parties and having perused the petition papers, we are of the considered opinion that no prejudice would be caused to anyone should petitioner be permitted to undergo training. ಎಲ್ಲದು?
Indian Revenue Service within bracket income tax commencing on 5th December
One
at
second.
National Academy of Direct Taxes.
ಯಾವ page ಹೇಳಿ? Page ಹೇಳಿ.
That is not mentioned, my lords.
Training. ಮುಂದಿನ ಹೇಳಿ.
To commence on 5/12/2024.
ಎಂತ ಟ್ರೈನಿಂಗ್ ಅದು?
Indian Revenue
IRS
Service within bracket IT.
Bracket
Group A.
income tax, IT dash group A
Training,
be
National Academy of
which
Direct
schedule-
Taxes,
at National,
Academy of Direct Taxes at Nagpur.
at National Academy of Direct Taxes at Nagpur, which is scheduled to commence
On
from 4th
5th
of
December.
Eh?
5th December.
5th of December 2024. First off, this shall be subject to the rider that no equity shall be claimed by the petitioner whatsoever
By my attending the training.
by virtue of attending the training in question. First, ordered accordingly,
Great.
subject to outcome of the petition. All.
My lord, name of R2,
Ah,
Vishnu D Bhatt is shown. It is not, it is
But-
only Vishnu Bhatt,
sorry,
my
my
lord,
Vishnu Bhatta.
because D is to be deleted. I am filing the appearance today.
Ah,
My lords, that was error of my
no,
colleague.
Sala. Not, sorry.
Vishnu.
Great.
But he is a scheduled caste candidate and most meritorious. Yes. Yes.
This is a counseling matter
Ah.
where my lords, this is with regard to
teacher.
teachers, my lords.
On par with the registrar's
Par
office.
with, now my lords, last date of hearing, I made a submission, let them participate in the counseling.
Correct.
Let us see if how many of them are satisfied with the posting.
Yes.
Now out of the 50 persons, my lords, 3 persons, my lords, did not come in the final list also, so they are not disturbed.
They are-
Remaining people, my lords, insofar as the petitioners only status quo may be ordered, where their postings, rest of the counseling, my lords, will give effect to except the petitioners.
The interim order being confined to the petitioners shall continue.
It could be disposed of
Huh?
because matter is pending before the tribunal. disposal, similar.
The lordship reason is, he has just handed me over the list.
We are not disturbing them.
Having heard learned counsel for the petitioners, we are of the considered opinion that the interim order granted by this court in terms of another order in WP number so and so, sub-registrar's order rather.
Please, it is referred
So
to.
and so. This petition is disposed of. Continuing the interim order till the main matter is taken up by the state administrative tribunal for consideration. Consideration. First, we make it clear that the relief granted by this court is confined to parties via nominates.
Please.
Obliged.
Next, this court.
In this matter, I appear for the petitioner. Lot of the, for keeping him the, lot of the petitioner under suspension. Reason assigned is lot of the.
Compliance ಏನು
Lot of the compliance is not only color photograph ಹಾಕ್ಬೇಕು ಅಂತ ನೋಡ್ಸಿ.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಾಲ್ಕಿದಾವ
ಅಲ್ಲ ಒಂದ್ ಮೆಮೊ ಹಾಕ್ಬೇಕು ಅಷ್ಟೇ ಸಣ್ಣ ಇನ್ ದಿ ಕೋರ್ಸ್ ನೋಡ್ಸ ಅರ್ಜೆನ್ಸಿ ಇಸ್ ದಿಸ್ ನೋಡ್ಸ್.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರ ಅಲ್ಲಿಲ್ಲ
ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ ಅಷ್ಟೇ ಸ್ವಾಮಿ ಫೋಟೋಗ್ರಾಫ್ ಪ್ರೊಡ್ಯೂಸ್.
ಲೆಜಿಬಲ್ ಕಾಪಿ ಆಫ್ A2. A2 ಲೆಜಿಬಲ್ ಇಲ್ವಾ?
ಎಲಿಜಿಬಲ್ A2 is legible, readable. Readable.
ಏನು?
Readable notes, legible.
Legible. ಎಲ್ಲಿದೆ? ಪೇಜ್ ನಂಬರ್?
Page number 23 notes.
3. ಟೈಪ್ ಹಾಕ್ಯಾರಲ್ಲ 23. ಯಾವ ಪೇಜ್ ಅದು? 2-3 ಪೇಜ್.
Page number 23 notes, annexure A2 notes.
Annexure
A2 notes.
the office objections, all office objections being insignificant or overruled. Yes, what is this matter?
Lot of the matter is not keeping suspension of lot of this petitioner. Reason assigned by the lot of the government is not he failed to stop the encroachment on the forest land. But it is the allegation. Lot of where lot of 3 to 4 years lot of the arachid tree have been grown. Not this man is not posted only on not on 16/3/2024 by not assigning the additional charge.
324.
Yes, not. But he's made a scapegoat not in this matter. That is the.
324. If encroachment has happened years ago.
And I'm not.
All right, 16/3 ಆದ್ಮೇಲೆ.
Yes, what he has informed to the not the higher authorities. Annexure A6 notes.
ಏನಂತ ಹೇಳಿ?
ಇದು ಕ್ಯಾಟಲ್ ಪ್ರೂಫ್ ಟ್ರೆಂಚ್ ಹಾಕ್ಬೇಕು ಫಾರೆಸ್ಟ್ ಸುತ್ತಮುತ್ತಲು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ನೋಟ್ಸ್ ಪೇಜ್ ನಂಬರ್ 34 ನೋಟ್ಸ್ ಟೈಪ್ಡ್ ಕಾಪಿ ನೋಟ್ 34 ನೋಟ್ಸ್ ಲಾಸ್ಟ್ ನೋಟ್ ದಿ 2-3 lines notes.
This you sent on 11/7.
Yes, notes. Earlier to not this. Apart from that, not even earlier to that also not I have given not information to the higher authority. And notes when I approached the KAT notice the without considering the interim order notice the.
Why do you want to suspend him? He came in March. And the encroachment has been there since years, even by the records. And he said, we have to take all these precautions, actions. So you want to suspend him?
I'm sorry, my lord, the copy is not served or it is
Copy
served, I don't know. Copy kodli, I will take instruction.
Call day after.
Copy.
What is
Copy ಎಲ್ಲ ಸರ್ವ್ ಮಾಡಿ ಹಾಕಿ.
Allah, but we have not received.
call after 2 weeks.
ಅಲ್ಲ ಸರ್ವ್ ಮಾಡಿ ಹಾಕಿ.
ಕಾಪಿಗೆಲ್ಲ ಅಷ್ಟು ಫ್ರೂಗಲ್ ಆಗಿ ನಡ್ಕೊಂಡ್ರೆ ಕಾಪಿ ಕೊಡ್ಲಿಕ್ಕೂ ಮತ್ ನಾವ್ ಹಿಂಗ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಏನಾರ ಒಂದ್ ಹೇಳಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡ್ಬೇಕಾಗತ್ತೆ. ಈ 10 ಕೇಸ್ 10 ರೀಸನ್ಸ್ ಇರ್ತಾವ ನಮ್ಗೆ. If you are frugal, we can also be frugal in giving justice.
While filing the.
Do you want to give copy or?
I will key now only my lord. Kindly have it my lord afternoon my lord. Now only.
Yeah. Post day after, if copy of the petition is furnished to the learned EGA and acknowledgement is filed in the registry and not otherwise. Frugality, vijrambisbadu. Yes. Yes, brother.
Filed a suit. Contempt application certified following the order passed by the Honorable Court on 14/9/2023.
ಏನಂತ ಇತ್ತು ಆರ್ಡರ್?
On 14/9/2023, The background of the case is this, my lord.
Order ಏನಿತ್ತು
Order dated.
ಬ್ಯಾಕ್ಗ್ರೌಂಡ್ ತಗೊಂಡು ನಾವೇನ್ ಮಾಡಿ
Found so as
not his
adopted.
writing history.
Has filed a memo, even date, and submits that appellant has identified site number 893 and 909 or one for allotment of Saryam Vishweshwaraya layout as a suitable alternative site for the appellant. He prays that BDA may be directed to allot the said sites if they are not already allotted. Memo be taken on record. So and so learned advocate for BDA seeks time to complete instructions having regard to the facts and circumstances of the case.
Correct.
It deems fit.
What is
My lords, on 14/9/23, the order was passed.
correct?
Prior to that, on 18/8/2023, my lord, the alternate site committee had already resolved to allot that particular site to another person, my lord.
On
So-
which date?
On 18/8/2023, my lord, I produced the alternate site committee report also along with my objection statement on annexure R5, my lord.
No sites are available there.
But the other two sites are available, my lords. Another site we already suggested, commissioner's affidavit has also been filed.
How many sites are available now?
Two sites are available. It's been reserved for the appellant, my lords.
What do you say?
As on that day, no allotment was made, my lord.
You want site or you want case? You want site, your client is here because he wants his goat back.
No, my lord.
Do you want goats
No,
or?
the background of the case is this, my lord.
What background? We are asking you now. They are saying there are two sites. You are here for sites or you want to argue just?
No. We have identified two sites. We have filed memo to that extent. As on that day, those sites were not allotted. Subsequent,
August itself.
no, my lord, your lordship may kindly see I have produced the sale deed along with my application. Therein they have clearly
We'll
stated.
hear the main matter itself some other day.
No, my lord, since 2015 we are struggling.
ಅವ್ರು ಸೈಟ್ ಕೊಡ್ತೇವೆ ಅಂತ ಹೇಳ್ತಾರೆ. ನಿಮ್ ಕ್ಲೈಂಟ್ ತಗೊಳಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ನಮ್ದು-
ನೀವು ಹೇಳ್ತೀರಿ ಅವ್ರು ನಿಮ್ ಕ್ಲೈಂಟ್ ಏನ್
ನಮ್ದು 19 ಗಂಟೆ ಜಾಗ without notification, they have utilized while.
They are giving site now
No, in
and we'll keep the petition also appeal also pending now.
in ಬೇರೆ ಕೆಂಪೇಗೌಡ ಲೇಔಟ್ ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Now we are asking to give
Something,
sites in our layout only. In their affidavit, they have
ಅದು
said
ತಗೊಳ್ಳಿ ನೋಡೋಣ. At least ಯಾವ್ದು ಬರ್ತದೆ
ನಮ್ದು actual land has been acquired by 19.5 guntas. Now they are saying that it is 15 guntas. In the memo, it is very clear, they have wrongly calculated and they have wrongly mentioned that it is 15 guntas. In their calculation, let them file the clarified memo.
ಏನಂತ?
Side ಒಂದು layout ಇದು ಮಾಡಿದ್ದಾರೆ ಒಂದು. In that, they have wrongly calculated and they stated that it is 15 guntas.
ಎಷ್ಟು ಗುಂಟಾಸ್ ಕೊಡ್ತೀರಿ?
Actual calculation is made is 19.5 guntas. In their own calculation, it is wrong calculation is made.
What I would suggest,
Want relief or you want to argue?
my lords,
At least your temptation to argue. Yes.
the
What do you
appellant's right for this balance 4 guntas may kindly be reserved. Let him take these two sites, my lords. One is in Vishweshwaraya layout in the same area.
ಫೈಟಿಂಗ್ ಮಾಡ್ಕೊತ ಕೊಡ್ಬೇಕಾ?
ಅಲ್ಲ ಅದು
ಅದು ಎಷ್ಟು ತಗೊಂಡ್ರಿ? ಅಟ್ ಲೀಸ್ಟ್ ಮೊದಲಿಗೆ ಫಸ್ಟ್ ತಪ್ಪು ಎಲ್ಲಿ ತಗೊಂಡಿರಿ ಅಲ್ಲೇ ಕೊಡಬೇಕು.
ಒಂದ್ ಸೈಟ್ ಅಲ್ಲೇ ಕೊಡ್ತಾ ಇದೀವಿ ಸರ್. ವಿಶ್ವೇಶ್ವರ ಲೇಔಟ್ ಅಲ್ಲಿ ತಗೊಂಡಿದೀವಿ. ಒಂದ್ ಸೈಟ್ ವಿಶ್ವೇಶ್ವರ ಲೇಔಟ್ ಅಲ್ಲೇ ಕೊಡ್ತಾ ಇದೀವಿ. ಅಲ್ಲೇ ಪಕ್ಕದಲ್ಲೇ
ಡೈಮೆನ್ಷನ್
ಡೈಮೆನ್ಷನ್ 40/60.
46.
ಇನ್ನೊಂದು
19 ಗುಂಟಾಸ್ ನಲ್ಲಿ ಎಷ್ಟು ಸೈಟ್ 40% ಆಗ್ತದ 45% ಆಗ್ತದ?
it is as per the government resolution of
55%.
50,
Amended rule 55%.
55% of the land that can be developed is 50% of 100%. 55% ಅಲ್ಲಿ 40% ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ, which comes to 11,989 square feet per acre of agriculture land. ಇವರು ತಗೊಂಡಿರ್ತಕ್ಕಂಥದ್ದು admitted position pursuant to survey conducted by the BDA as per the directions of this honorable court. We have used 15 guntas of land. For 15 guntas of land, around 4,500 square feet is liable to be given by us, out of which for which we have reserved two 40/60 sites, one in the same area as Vishweshwara layout in which we have used his land. The other one is in Kempegowda layout, another 40/60 sites. We have
Rate in.
Swami, as on current rate, Swami, it comes to guideline value rate is 1,84,46,550.
ಅಲ್ಲಿ ಇದರ ಕೆಂಪೇಗೌಡದಲ್ಲಿ
ಅದ ಎರಡು ಸೇರಿ ಇದರಲ್ಲಿ 4,460 per square feet guideline value as on the date I filed the affidavit of Vishweshwara layout. In 3,474 guideline value rate per square feet in Kempegowda layout.
ಅಲ್ಲಿ ಎಷ್ಟು?
3,474 guideline values.
ಇನ್ನೊಂದು
ವಿಶ್ವೇಶ್ವರ ಲೇಔಟ್ ಅಲ್ಲಿ 4,460.
ಮತ್ತೆ ಆ ವೇರಿಯೇಷನ್ ಈಸ್ ವರಿಡ್.
ಅಲ್ಲ, ಅವರು 4 ಗುಂಟೆಯನ್ನು ನಾವು
ಪ್ಲಸ್ ಆ ಗುಂಟೆ ನಾಟ್ ಓನ್ಲಿ ಪ್ರೈಸ್. ನೀವು ಒಂದು ಈಕ್ವಲ್ ಡೈಮೆನ್ಷನ್ ಪ್ರಶ್ನೆ ಯಾವಾಗ ಬರ್ತದೆ ಅಂದ್ರೆ ಈಕ್ವಲ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಇದ್ದಾಗ. ನಂಬರ್ 1. Number 2, there is dispute about aerial extent also. ಅದನ್ನ ಬೇಕಾದ್ರೆ ನಾವು ಅಡ್ರೆಸ್ ಮಾಡೋಣಂತೆ.
May I submit it like this, my lord? What we take is, my lord, agricultural undeveloped land, my lords. Then what we now give, my lord, is a developed site after
Correct.
taking into consideration, my lords, all the development costs, the civic committee that we lose, the road area, everything that we lose, my lord.
Correct.
That
You
there is
have-
an elaborate calculation. I can place it before your lordship. This issue has been much debated by this honorable court in several matters, my lord. We have gone by several directions issued by this honorable court, as well as the resolution passed by the government of Karnataka, my lord. There is a circular to that effect.
At least in 3 judgments,
Please, my lord.
your BDA has suffered orders at the hands of the bench in which I was a
Correct, my lords. Correct.
member.
Correct.
Where you have given resolution, you have given saying we will give 50% somewhere, and in other places you said 100%. There are 3 resolutions. Perhaps somebody who is briefing
My lord.
has not, but otherwise we can, from memory, I can recall those orders also.
May I submit
Next
this?
date
my
I
lord?
will give him so that he can argue that matter.
May I submit this, my lords? This,
And you are before the Supreme Court?
my lords, in Arunachalam case, this entire issue started with
Correct.
Arunachalam case.
Correct.
In the matter, my lords, I have filed a revision petition, my lords, and the matter is stayed. Notwithstanding that, my lord, the ratio placed decision decided by this honorable court, even though we have filed a review petition, the ratio decided by this honorable court is that equivalent in valuation, my lord.
492 square feet out of 4,000 square feet, and for me, opponent is prepared to accept the value of the land in the form of demand draft. ದುಡ್ಡು ಕೊಟ್ಬಿಡಿ. ದುಡ್ಡು ಕೊಟ್ಬಿಡಿ. ಅವ್ರು ಮೇವು ಹಾಕಿದ್ದಾರೆ. ದುಡ್ಡು ಕೊಟ್ಟಿ. You have said that we will accept the demand. You have given.
We will calculate it and my lords, we will place the award amount for the consideration of your lordships. Because we thought, my
But
lords,
one side for remaining ಏನಿದೆ in terms of DD you have to give that ಅಂತ order ಆಗಿದೆ. Coordinate bench has ordered that.
if it is acceptable to the my lords, I will go ahead and do it.
Later on.
Let him pick, there are 2 sites we have suggested, my lords. One is Vishweshwar, one is Kempegowda layout. Let him choose one site, my lords. And for the balance, my lords,
ಇಲ್ಲ
we'll-
ಎರಡು ಸೈಟ್ ತಗೊಳ್ಳಿ. ಅದೇ ಅದು ಡಿಫರೆನ್ಷಿಯಲ್ ಏನಿದೆ ಅಮೌಂಟ್
for that, my lords, we have objection because pursuant a survey done by us, as per the orders of this honorable court, we identified only 15 gundas having been used by us, my lord.
ಅದು ನೋಡೋಣ.
Wrong
We
calculation.
have filed an
We will ask
affidavit.
them to correct that.
That may kindly be heard is my,
Some advocacy.
Sorry, ma'am.
You don't want to learn advocacy skills.
Sorry.
Yes.
that I may kindly be heard on the 4 guntas of land, my lords. I may be kindly heard. As far as 15 guntas of land, my lord, if one site is taken and the other one is for compensation, if they are accepting it, for the compensation part, what it will come to, my lords, I'll request the BD LAO to calculate the amount and I'll.
ಎರಡು ಸೈಟ್ ನೀವು ಕೊಡಿ ರೆಡಿ ಇದ್ದೀರಿ.
ಎರಡು ಸೈಟ್ ಕೂಡ ಕ್ರೆಡಿಟ್
ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಆಗ್ತಾ ಇದೆ ಹೋಲ್
ಆಗ್ತದೆ ಸ್ವಾಮಿ. ನಾವು ಅಫಿಡವಿಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀವಿ ಕಮಿಷನರ್ ಸ್ವಾಮಿ.
ನಂಬರ್ 1.
ಪ್ಲೀಸ್
ಆ ಸೈಟ್ಸ್ ಅನ್ನ ಅವ್ರಿಗೆ ಕೊಡಿ.
ಪ್ಲೀಸ್
ದಿ ಡಿಫರೆನ್ಷಿಯಲ್ ಅಮೌಂಟ್ ಇದೆ ಅಲ್ಲ.
Please.
Even according to you,
ಪ್ಲೀಸ್
the value of one site is higher than that of the other site in the other layout. Obviously, it will be. So you can't say the X site and Y site should be valued in the same terms at the highest level. It cannot be.
my lord, the as-
Even the other site ಕೊಡಿ ನೀವು. Rest of the things we will address on the next date of hearing. ಎರಡು site ತೊಗೊಳ್ಳಿ ನೀವು. Are you ready?
Kempegowda layout is very less.
ಅಲ್ಲ ಯಾವ್ದು ಸೈಟ್ ಬೇಕು ನಿಮಗೆ? ಒಂದು ಸೈಟ್
BDA, the Kempegowda Vishweshwar layout, we are ready to accept.
one site.
One site.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಸೈಟ್ ನೆಕ್ಸ್ಟ್ ವಿಲ್ ಅಡ್ರೆಸ್ ದಿ ಅದರ್ ಆಸ್ಪೆಕ್ಟ್ಸ್. ಆಗ್ಲಿ.
My lord, may I request this? They have to relinquish that 15 guntas of land which we have used to us, my lord, by
They
way of
were
registered
used
deed.
ಅದಾದ್ಮೇಲೆ ಕೊಡಿ.
As with respect to the title, my lord, they have to show that they have the title over the property. Because it's been in our past experience that we have had a bitter experience where people who do not have title have relinquished the land to us.
ನೀವೆಲ್ಲ
Arunachalam-
ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಕೊಂಡು
Please,
ಕಮ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಟೈಟಲ್ ವೌಚೇಬಲ್ ಟೈಟಲ್ ಇದೆಯೇ ಇಲ್ಲ ಅದನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ.
may I request cooperation from the appellant, my lord, to let them
ನೀವು
give the
ಸ್ವಲ್ಪ
papers.
ನಿಮ್ದು ಟೈಟಲ್ ತೋರಿಸ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ. ನಾಳೆ ಯಾವುದೋ ಒಂದು ಲಿಟಿಗೆ ನಿಮ್ದು ಇಲ್ಲದ ಲ್ಯಾಂಡ್ ಕೊಟ್ಟು ಸೈಟ್ ತೊಗೊಂಡು ಕುತ್ಕೊಂಡ್ಬಿಟ್ರೆ ಬೇರೆ ಸಮಸ್ಯೆ.
That is the reason we have filed Arunachalam review petition, Arunachalam statement.
ಅಲ್ಲ ಯಾವತ್ತು ಇದನ್ನ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ
Either trial court, it was not looked into. What happened, my lord, was this. He claimed that he has got a portion of land, suit schedule B property, my lord. Suit,
ಅಲ್ಲಿ WS ಹಾಕಿದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ.
trial conduct agi.
Did you dispute title?
No.
We disputed the title as identified by them to the adjacent property. What the appellant,
ಈ ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡು
property was not in contention before your lordship. What happened, my lord? May I just say it for in a minute?
ಅಲ್ಲ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿಕ್ ನೋಡ್ತಾ ಇದ್ದೀವಿ.
Please correct, my lords.
Have you taken citizens property?
My lord, it was determined pursuant to the survey done in the regular first appeal, my lord. The reason why is this, my lord.
You are telling the process. We
Yes,
are
sir.
asking the result. have you taken citizens' property?
Yes, my lord, we have
You have
taken
taken.
it. We have taken it, my lords.
Did you follow the process prescribed by law for taking private property for public purpose?
I'm afraid, my lords, we have not done.
Nothing. Number two. If private property is taken without due process of law, that is called land robbery. At least in two judgments, Supreme Court has used it. Please, terminology. Anyway, now by mistakes these things happen, which is that my judgment affirmed by the where Kaveriyappa.
I'm sorry.
BDA.
Huh.
You are not argued.
I think probably Murgesh argued.
Not Kaveriyappa versus so and so, where acquisition, appropriation of private property without acquisition. Take out that judgment.
In this way, they have made, sorry.
Have you seen that judgment?
Judgment ಬಗ್ಗೆ ಮಾತಾಡ್ತಾ
You are arguing on that. So read that judgment and come back. Call this matter after 2 weeks. Take out that judgment that comes to you.
Date makandi.
Put it, judgment. Then went affirmed by
I'll-
Lucas
I'll
Saib
also-
and went.
I'll see it, my lords.
Ah,
I'll see it.
or a PDA judgment, where I awarded 17 lakhs by way of damages, and the appellate court made it 20.
Please, my lords, I'll see it. my lords.
Take out that. ಓದ್ಕೊಂಬರ್ಬೇಕವಲ್ಲ? Yes. On the other date, ಕೊಡಿ. After 2.
Like, are they going to accept the site or anything so that accordingly I can instruct?
Because he's interrupting, lot of interruption he's doing. Na? Let him read and come back. Yes, next.
Please, my lords.
Yes.
In serial number 15, they filed statement of objections along with the vacating stay application. We wanted to place documents on record pertaining to the roster points because it is about a physically disabled person being given an appointment. There was only one roster point according to us. It has been given to one person. So this is he's claiming, my lords, we have issued an endorsement. The tribunal, but the data was not placed before the court, my lords. Now, along with the statement of objections, they have placed some notings on record, which show, my lords, that he is a second meritorious person.
What you want? You want to argue or you want
No,
time?
we wanted some time to place on record.
Time is
One,
granted. Call this
may
matter
make
on.
one submission, my lord.
Ah.
The same submission was made about
Not
earlier.
to
my lord.
23 matter.
Because other two have got the appointment. Only I have been sought to be discriminated.
Call in
Charged.
the first week of January
Last week also same.
2025. Next. At the request of AG. Next.
That's
And for the
this is
petitioner
this is a matter, my lords, where the arbitrator was changed. That's ordinary. My lords had, with the consent of the petitioner's counsel, 2 paragraphs were dictated, my lords. Adu solpa by oversight it got missed. Page number 3 of my IA.
Yeah.
Yeah.
But it was a consensual order.
Correct. Ordinary, my lords may turn to page number 3. I don't want to read that.
But
Yeah, solpa. Page number 3 of my IA.
your application.
Yes, my lords. Because my lords had excised, use such words, I mean, in a good way. So those 2 paragraphs are missing, which my lords, it was on consent only. These two must be included.
Incorporated.
That's all. It's nothing
Berkeley.
else.
We'll incorporate that.
As my lord, please.
Learned counsel appearing for the
Respondents.
respondent submits that a part of dictation given on the other day is missing in the order, whereby the subject WP came to be disposed of. First, he has culled out what has been missing, comma, at para 5 of his application, which reads as under. First. Next paragraph. Learned counsel for the petitioner, when asked as to whether he has any objection for incorporating this missing portion in the order by which the WP was disposed of, comma, in all fairness, he says he has absolutely no objection. Full stop. In view of the above, the paragraphs put in inverted commas beneath para 5 shall be printed in a separate sheet, and that shall be appended to the order by which the writ petition was disposed.
Grateful.
Grateful.
Ordered accordingly.
I'm sorry, my lords,
Hey. Sorry.
I
I know,
just
Mr.
mentioned-
Counsel.
But in the end, my lord, post the hearing the matter, my lord said that there will be some changes. My lord clarified it to both of us.
In this textually, then what? This is what
Correct.
we have said.
Yes,
We remember.
Yes,
ಅದನ್ನ ಅದ್ರಲ್ಲಿ ಹಾಕಿ ಅಂತ ಮುಗಿದು ಹೋಗಿದೆ.
grateful, my lord. Obliged.
Yes. Ali, one second. Mr. Mahesh Chaudhary, appearing for the petitioner, in all fairness, agreed before us that they appearing for the respondent agreed before us this day also that the appointment of the new arbitrator was consensually made. Okay.
Grateful.
ಅದೊಂದು ಹಾಕ್ಬೇಕು. Yes.
I pay for the 8th respondent.
Yes.
I may permitted to file the statement of objection to the IA for stay.
For stay. When were you served with the copy?
I entered appearance 5 days back.
You may enter whenever.
Yes,
we don't know.
statement is
When
ready.
were you?
Statement
when
is
were you
ready.
served with
I
the
may
copy?
permitted to place it on record.
We are asking you.
Yes.
You don't want to answer. When were you served with the copy?
Copy has.
Because we have rules, therefore we are.
Absolutely, my lord. Absolutely.
Call this matter in the first week of January 20.
There is some urgency, my lord.
ಏನ್ urgency?
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ after Pavitra 1, my lord, seniority and promotions were affected and it was perfectly in the ratio of 15% and 3%.
ಅದಾಯ್ತು urgency ಅದಲ್ಲ
Urgency ಅಂದ್ರೆ my lord, I am one batch senior and my lord, my learned friend's client, my lord, belongs to 1998 batch. Now she had a March. And my lord, the Pavitra 2 judgment, my lord, now has been overruled.
Call in the second week of March 2020.
Pardon,
January 2020. Yes, next.
Pardon, my lord.
We have said it. January second week. Yes.
ಅಲ್ಲ ಸ್ವಲ್ಪ
ಬೇರೆ ಯಾಕಂದ್ರೆ ಪಾಠಡ್ನಾಗಿದ್ದೇವೆ ಅದರ್ವೈಸ್ ನಾವೇ ತೊಗೊಂಡ್ಬಿಡ್ತಿದ್ವಿ. ಸಣ್ಣ ಪಾಯಿಂಟ್ ಇದೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಏನ್ ದೊಡ್ಡ ಪಾಯಿಂಟ್ ಇಲ್ಲ ಇದ್ರಾಗೆಲ್ಲ. We would have taken up the matter because they cannot be made to wait endlessly. Heartburn ಆಗ್ತದೆ. But we have some difficulty because we're in the mid of the parted matter.
may I request my lord December ಮೇಲೆ.
Next. ಏನ್ ಶೆಟ್ರು ಇದೆ?
The grievance of the petitioners, my lord, only with regard to certain observation made in the impugned order, my lord.
ಏನಂತ ಮಾಡ್ಯಾರ?
In fact, my lord, we have not followed the CCS rules while conducting the ICC inquiry and all. In fact, my lord, we have placed before the secretary, who is a competent authority. He has considered it. And even in the impugned order itself, they will, they observe, my lord, it has been done. But the transfer order has been challenged before the
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್?
CAT, my lord. That is para 20, my lord.
20.
Transfer order, my lord, we have no grievance, my lord, and that has been quashed. But only observation, my lord, because
ಅಲ್ಲಿ ಅಬ್ಸರ್ವೇಷನ್ ಒಂದು ಅಟ್ ಲೀಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಇದನ್ನ ಎಕ್ಸ್ಪಂಜ್ ಮಾಡ್ರಿ ಅಂತ ಮಾಡ್ಕೋಬೇಕು. ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೈಡ್ ಆರ್ಡಿನರ್ಲಿ expunction of observation should be sought for at the hands of the body which made those observations.
ನಾವು ಅದನ್ನ
Number
ಹೇಳಿ
one.
ಅಲ್ಲೇ ಮಾಡಿಸ್ತೀನಿ ನಾನು.
ಅಲ್ಲೇ ಮಾಡ್ಕೋಬೇಕು.
ಬೆಟರ್
ಮಾಡ್ತೀರಾ?
ಪ್ಲೀಸ್.
Learned counsel for the petitioner, having argued the matter for some time, confined his contention only to the observations made by the tribunal at para 20
to 25.
to para
25.
25. Twenty-five.
Please.
Odi.
Para 25, my lord.
The record as produced. Page 37, na?
37.
Ah.
The record as produced by the respondents pursuant to our direction nowhere reveals that the inquiry report submitted by the internal
Was ever dealt with by the
was
competent
ever dealt
authority?
with by the competent authority in accordance with the provisions of CCS law.
In observation, it protects the ground for the order.
No, we have done, my lord. In fact, I have stated in my.
Now, how your grievances against these observations?
22, there are so many, 5 observation, my lord.
ಯಾವ್ದು ಯಾವ್ದು? ಇದು ಒಂದಾಯ್ತು. ಇದರಲ್ಲಿ
Please,
ಏನಿದೆ? ಇದರಲ್ಲಿ
please.
ಏನಿಲ್ಲ. ಮತ್ತೆ ಬೇರೆ ತೋರಿಸಿ.
That is 24, my lord.
24.
Please. It is beyond our, that is page 36, man. Comprehension as to the prompted, to what prompted the DS V&L to record such a note about transfer of the applicant herein, along with the respondent number 3. The note dated 17/10/2020, recorded by DS was approved by the joint secretary with the direction to the center to transfer the applicant to a division where she does not report to respondent 3. However, no decision was taken to transfer the respondent 3.
Learned senior CGC appearing for the petitioners, having argued the matter for some time, submits that since grievance is only as to certain observations in the body of the order and not against the end product, comma, he may be granted leave to approach the CAT for seeking expunction of the alleged observations. First up, such innocuous prayers cannot be denied. First up, in view of the above, writ petition is disposed of, granting liberty to the petitioner to take the matter before the Central Administrative Tribunal. First, in that connection, all contentions are kept open. First up, we make it clear again that there is no challenge, the challenge to the operative portion of the order of the tribunal.
So for quashing of the transfer order.
For quashment of the transfer order is
Of
given
respondent.
up.
Of responding.
Is given up.
Please.
Given up. Okay. Registry to send a copy of this order to the private respondents by speed post immediately. Yes.
My lord,
Yes.
I'm the 83-year-old retired senior scientist and got retired on through superannuation in 31/3/2002. My lord, my issues are that I supposed to get the 2 increment and received it, but after that it has been withheld by the department. My lord, respondent number 1, the issued a circular by which revised pay scale for scientists of ICR were notified following the revision of the pay scale under central government employees on the recommendation of 5th CPC, my lord. In the scientist will eligible for 2 advance increments and as when we acquires the PhD degree in his service career.
You wanted to recover that. You wanted to recover that.
Yes, my lord.
Notes in, first it was Millers, they would get an incentive if they complete PhD Millers. That was the incentive which was there. It was from 1985 he completed.
That's all right. When did you initiate the recovery process?
Lords, it was granted in the year 2022, my lords.
22,
Howದು?
after retirement.
Howದು? After retirement, it was done, my lords. By mistake, my lords, we had given it under the assumption that he is entitled.
But Rafiq Masaya ಆಗಲ್ಲ ನಿದು.
ಇದಾಗಲ್ಲ. ಇದು ಮೊದಲೇ ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ. Already retired. When he made a representation that he is entitled for change, my lords, we took it and gave it. Later on,
What we said, we considered Rafiq Masaya na in another judgment. Where you, who appeared? Rafiq Masaya, we have interpreted in another judgment.
5 conditions ಇರೋದು.
ಅದನ್ನ interpret ಮಾಡಿದ್ವಿ. ಅದ್ರಲ್ಲಿ first they said lower cadre officials ಅಂತ hold ಮಾಡಿದ್ರು. That was argument. ಪ್ರಸಾದ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ಯಾರ ನೋಡಿ. ಯಾವ್ದು judgment court officer? Prasad,
Maybe I
MS
will-
Prasad had argued that.
I'll
much.
just
We have
check.
interpreted it.
I'll
Just look into
because it
and
is
come
coming,
back.
it is coming for the first time, my lords.
Issue
I will also
emergent
request some
notice.
time.
My lord,
That,
I undertake to appear for all the respondents.
learned,
lord, IA
TGC appears.
My lord,
for-
they already sent the letter, several letters to recover that, the whatever the
Don't-
amount is,
don't
kindly
recover.
give the
Please.
stay for.
Don't recover. But the coercive action for recovery shall not be resorted to during the pendency of the petition. First, this relief we have accorded to the petitioner in the light of our judgment in WP number so and so disposed of on such and so, wherein we have construed the parameters prescribed by the apex court in Rafiq Masaya. 2015, Rafiq Masaya, 2015?
Yes, ma'am.
Yeah, no, citation head.
And one more request, my lords.
Ah.
They have to file the pleadings which is filed before the tribunal, my lords. OA with reply, reply annexures ಇಲ್ಲ.
ನೀವ್ ಹಾಕ್ಬಿಡಿ.
ಅಲ್ಲ, ಅವ್ರು petition ಹಾಕ್ತಾರೆ, ಅವ್ರು ಅದ್ಯಾವ್ದು produce ಮಾಡೋದಿಲ್ಲ. They are,
ಈಗ now they have produced, the rule requires that they should produce all right. Whatever you want to produce, you are the mighty central government.
not mighty, my lords. My lords, if I am the petitioner, even if a document is not legible, my lords, office will raise
That's
objection.
complaint against the office.
OA copy ಆದ್ರೂ ಹಾಕ್ಬೇಕಲ್ವಾ?
ಏನು ಹಾಕಿಲ್ವಾ ಇದರಲ್ಲಿ?
ಹಾಗೆ submitted, all
ಹಾಕಿ-
submitted,
ತೋರ್ಸಿ.
submitted.
ಎಲ್ಲಿದೆ? ಪೇಜ್ ತೋರಿಸಿ.
OA copy.
ಹಾಕಿದ. A1 35. ಒಯ್ ಹಾಕಿದಾರಲ್ಲ.
ಇಲ್ಲ.
ಹಾಕಿಲ್ವಾ ಒಯ್?
Submit ಆಗಿಲ್ಲ.
ನಮ್ಗ್ ಕಾಪಿ ಕೊಡ್ಬೇಕಾದ್ರೆ
Change ಮಾಡೋಣ.
ನಿಮ್ ಪೇಜ್
Annexure A ಅಲ್ಲಿ ಇದೆ.
ಅಲ್ಲ, ನನಗೆ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ಇಲ್ಲ, ಆಮೇಲೆ ಇನ್ಸರ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
I complained
That's
of
not the,
objection and I have submitted.
ಅವ್ರಿಗೆ ಫುಲ್ ಕೊಡಬೇಕು.
Submit ಮಾಡಿ, will service.
This interim order shall not be released till after the whole new set of writ petition along with all the documents that were part of the record before the CAT are served on the learned CGC and an acknowledgement is filed in the registry.
ಅಚ್ಚಾ.
Okay. Next. Rafiq Masaya ತಕೊಂಡು ಹೇಳ್ಬೇಕಂದ್ರೆ ಯಾವ್ದೋ ಒಂದು ಮಾಡಿದೇವಲ್ಲ. Where is our researcher? Why is he sitting in the chamber? He should be here to assist us. That is the object of appointment. ನೀನು ಡಿಕ್ಟೇಷನ್ ನೀ ತಗೊಂಡೇನ ಅದನ್ನ? ರಫೀಕ್ ಮಸಯ್ಯ ಟ್ರೀಟ್ ಮಾಡಿದ್ದು ಅದ್ ಬರ್ದಾಕ. Okay.
Appear for the petition.
ಅದು ರಂಗನಾಥ್ ಜೋಯ್ಸ್ ವರ್ಸಸ್ NS ಪ್ರಸಾದ್. Yes. Liars we had argued. Yes, brother.
my lord, in this case, I accept notice for the first respondent, my lord. For other respondents, notice has to go out.
Learned issue notice, learned DSG is requested to accept notice for
First respondent.
first respondent. Issue usual notice to the other respondents by way of emergent notice.
They are the answering respondent also.
State illano?
No,
Lords, ESIC, Advocate
Yes, I ಯಾರಿದ್ದಾರೆ?
Sridhar.
ಯಾರು?
Advocate Sridhar.
ಶ್ರೀಧರ್, ಶ್ರೀಹರಿ,
Sridhara.
ಶ್ರೀಧರ. Mr. Sridhara, Learned Panel Council is requested to accept notice for
Respond.
2 and 3 na.
ಎಲ್ಲರಿಗೂ 2 ರಿಂದ 5.
All right, for rest of the respondents. One DSG for one, Mr. Sridhara, learned panel counsel. ಅವ್ರಿಗೇನು ಇದು ಇಲ್ಲ ನೋ
Initial
ಇನಿಷಿಯಲ್
ಗೊತ್ತಿಲ್ಲ.
ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ. Petitioner to serve copy of the petition on the ನಿಮ್ ಕೊಟ್ಟಿದಾರ on the panel counsel appearing for respondents 2 to 4 and file acknowledgement in the registry within 1 week, failing which petition stands rejected. Yes.
Obliged.
Next.
Before respond number one.
Huh.
It's a fresh matter, my
Yes,
lords. Even for respond number two, I undertake to file.
You appear for two also.
Please, my lord.
See, B. Pramod, learned CGC, appears for respondents 1 and 2. Okay. Any matter,
Request for some time, my lord.
call this matter in the first week of January. Yes, next. Thank you.
My lord, even in this matter, they have not filed the entire.
Brother, you have to file the entire set, na?
There are totally four matters, my lords. Common order is passed. ಒಂದರದ್ದು ಪ್ಲೀಡಿಂಗ್ ಹಾಕಿದ್ದಾರೆ, ಇನ್ನ ಮೂರ್ದು ಹಾಕಿಲ್ಲ.
ಅವ್ರದ್ದು ಯಾರು ತೆಗೆದು ಅದನ್ನ ಹಾಕಿರ್ತಾರೆ.
ಅಲ್ಲ, 4 ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಇದರಲ್ಲ.
ಹೌದು, 4 ಮ್ಯಾಟ್ರು ಕಂಬೈನ್ಡ್ ಆಗಿ ಕಾಮನ್ ಆರ್ಡರ್ ಆಗಿದೆ. ಒಂದರದ್ದು ಪ್ಲೀಡಿಂಗ್ ಹಾಕಿದ್ದಾರೆ, ಇನ್ನ ಮೂರ್ದಿಲ್ಲ. ಲೆಟ್ ದೆಮ್ ಫೈಲ್, my lords, the entire
Our rules, under our rules,
entire
new rules of 2018, you have to produce all the, not only pleadings before the CAT, all the documents that were part of the OA.
You know, there were 3 OAs. In one common order was passed. Similarly, the respondents have filed in similar cases, 24 cases.
All, if common order is passed, all OAs to be produced. Petitioner to
I will produce.
stitch the pleadings and along with all the documents that were part of the record before the CAT to the petition. Within 2 weeks, failing which petition stands rejected on that ground per se. Yes, thank you. ಯಾಕವರು ಇದು ತೊಳಪ್ಪ ರಫೀಕ್ ಮಸೈ ಅಲ್ಲ. This is the judgment which you have said, na? ನೀನೇ ಡಿಕ್ಲೇಷನ್ ತೋಡಿದ್ದು. Yes.
appearing for petitioner's counsel. The order of the arbitrator, my lord, is called in question, my lord, in this writ petition. The main question that was required to be decided whether the goodwill, payment of goodwill, my lord, is arbitrable when there is no dissolution of the partnership firm. All other partners continued, my lord, the business. The question of sharing the goodwill, my lord, will arise only when there is a dissolution. Therefore, my lord, leading evidence, my lord, on the question of goodwill, my lord, is not arbitrable, my lord, was the question. May I request your lordship kindly see, my lord.
But at this stage, can you interview here? That will be a ground in the event it is decided.
It is not arbitrable. The dispute cannot be arbitrable because in view of section 55, my lord, it is only in the event of dissolution. Admitted position is that, my lord, the dissolution has not taken place according to the partnership firm, my lord, partnership deed, my lord. The firm will continue, my lord, even on the death of a partner. If this is the admitted position, the question of, my lord, evaluation of the goodwill, my lord, will not arise, my lord, is the specific question raised. And the learned judge says, my lord, we'll decide it later. Without deciding, my lord, whether it is arbitrable, whether this claim is arbitrable.
ಇದ್ರ ಮೇಲೆ ಏನ್ ಹೇಳಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಆನರಬಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಿಸಿಷನ್ ಇತ್ತು.
Lord, there are, Lord, they say, my lord, it goes according to the partnership deed. Your lordship will kindly see, my lord, the partnership deed also, my lord, we have produced. Before that, my lord, your lordship will kindly see, my lord, section 55 of the partnership.
Here, our preliminary question to you is,
Yes.
where an unarbitrable issue is pending for consideration before the arbitrator, can the party to the arbitration contract agreement come before the court at the intermediary stage and make it a grievance?
If a application is filed under section 16, the learned judge is required to rule on his jurisdiction under section 16 and pass an order. It is a very peculiar case where, my lord, the dispute is, my lord, arbitrable. But
Not this part.
not this part. I cannot.
What do you say?
Lord, what I had filed.
Whether was there a dissolution of the firm?
No, there was no
There was
dissolution
no
of the
dissolution. Do you agree with the legal position that unless there is dissolution of the firm, the question of seeking any remedy in respect of goodwill will not arise?
No, my lord. So far as, even though if dissolution of firm has not taken place, but for the purpose of calculation of the share of the deceased partner and for payment to the legal heirs, my lord, at the time of calculating under section 37, my lord, even that portion of the
To be
goodwill has
taken
to be
note of.
considered. And exactly, my lord,
How
what
section reads?
my lord, section
Section ನಲ್ಲಿ
40.
ಏನ್ ಗೊತ್ತಾಗಲ್ಲ ಅದು. ಅದ್ರ ಮೇಲೆ ಇರೋ ರೂಲಿಂಗ್ಸ್ ನೋಡ್ಬೇಕು. What are the rulings which you bank upon, Mr. Chandrasekhar?
Lord, when there is a dissolution, my lord, the judgments are, my lord, for valuation of the goodwill.
Suppose if the deed itself provides otherwise.
Then it is permissible.
Permissible.
But deed does not provide for it.
Deed ನಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ?
It says, my lord, it is the property of the firm. It always, my lord, will remain a property of the firm.
Means?
All assets are property of firm.
Including good assets of the firm, including the goodwill, my lord, it will be the asset of the firm. When it comes to, my lord,
Let an application is moved under 16 now.
No, my lord. I had filed an application for recall and reopen
Yeah.
for to examine the expert witness on the point of goodwill.
No,
But-
that question arises, provided it is shown to be demonstrated to be arbitrable. That is his contention. Anyway, why should not the arbitrator give a ruling on that?
But that was never, section 16 application was not at all filed.
But you said
but section application, I cannot file section 16 application.
at all.
Yes. That is the difficulty.
But you raised that issue?
Yes, my lord.
Where is that?
My lord, may I request your lordship kindly see, my lord, objection statement at annexure 62, my lord, at page, internal page 4.
62. 62 is affidavit to the IA.
74, my lord, index page 74. We have extracted the section also, 55.
In your statement of objections, you have taken up that contention?
Yes, my lord. 74, at page 74, my lord.
ಇದೊಂದು at the most ಇದೊಂದು ಪಾಯಿಂಟ್ ಅನ್ನ ಪ್ರಿಲಿಮಿನರಿ ಇಶ್ಯೂ ಆಗಿ ಟ್ರೀಟ್ ಮಾಡಿದ್ರೆ ಮುಗದೆ ಹೋಯ್ತು.
Kindly takes para number, page 90, my lord. With respect to their objection, was
90.
page 90, my lord. It is
Paragraph
reviewed
6.
order, paragraph 6 and 7. 6 is what if there is no evidence, it is the stage of evidence which we were there, my lord. If at that point of time courts come to the conclusion that tribunal comes to the conclusion that goodwill is part of the asset that has to be given to me, there will be no evidence before the tribunal.
My lord, this question of arbitrability is, my lord, is postponed by the learned judge.
No, suppose if the arbitrability is a mixed question of law and facts.
My lord,
Courts have taken the view.
it is a pure question
trial
of,
has to happen.
my lord, it is, according to me, my lord, it is a pure question of law. Section 55 itself says,
Partnership Act.
but I have extracted, my lord, the same thing. my
Not,
lord,
my lord,
in my-
simple irrella. Partnership Act is a very nebulous law. No, can't go by statute. ಅಲ್ಲಿ Gupta on Partnership Act ಅನ್ಕೊಂಡೊಂದು ತರ್ಸಿ. How courts have treated, construed this provision? There are several judgments on that. Section Gupta on
55
Partnership Act. ತರ್ಸಿ. Mulla on Partnership Act.
55, my lord.
55.
It is capable of being sold, how it has to be dealt after the partnership is dissolved.
How courts have interpreted this provision?
But
Any
this,
rulings?
this provision itself is not applicable to our facts.
Because of, no, therefore, we want to know, going by this, what you say is, unless dissolved, you cannot go further is your contention, we have understood it.
The plain reading of
How
the section,
courts-
plain reading of the section, my
Law,
lord,
Bentham, Jeremy Bentham said, the statute will show its face in musk. Therefore, we will not go by statutes. How statutes are interpreted by the various high courts in the country. That is,
the
that
one
becomes.
judgment is there, my lord, it says, my lord, it
But-
must be, if there is any contract between the parties, my lord, to deal with the goodwill also, to the contrary to the contract. My lord, it is,
If there is a
if-
contract that that will
if
be.
there
given
is an agreement contrary to 55
55.
for distribution
How
of.
55 is treated? How courts have interpreted 55? ನಾಳೆ ನಾವು ಓದ್ಕೊಂಡ್ ಬಂದ್ಬಿಡ್ತೀವಿ. ನಾಳೆ ಇಟ್ಕೊಂಬೋಣ. For this matter, tomorrow.
So far as
Not,
Other question
we'll
is-
also read, we'll also read.
covered by your lordship's judgment, my lord,
ಏನಂತ?
regarding whether writ is maintainable or not, my lord.
It's all right, but one issue he has raised. ನಾವು ಹಂಗೆ ಒಂದೇ ಸರಿಗೆ ವಾಪಸ್ ಕಳ್ಸಕ್ ಆಗಲ್ಲ. Suppose we come to the conclusion that the goodwill is not, or dispute raised to goodwill is not arbitrable in the absence of dissolution of the firm. Because it appears that way. Please, going by text of these sections. Then why a whole lot of exercise need not be undertaken on? That is the purpose of writ of prohibition. If you read law of writs by Macon in England, the very purpose of law of prohibition is to curtail unnecessary litigation at the hands of somebody. Let us see that. And wholesale ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. Tomorrow. Second ಕೆಳಗಡೆ ಇರುವಂತ small note ಮಾಡಿಕೊಡಿ. Latest first judgment, how law developed, latest judgment. The entire note you have to give to. Yes.
For the appellant, my lord.
Respondents.
I had given an offer of 50 lakhs to them.
Apology, my lord, they are not.
Consider ಮಾಡಲ್ವಾ? Not ready?
ಅಲ್ಲ ಏನಂದ್ರೆ ಅದು ಐಟಮ್ ನಂಬರ್ 1 10 ಕೋಟಿ ಮೇಲೆ ಬೆಲೆ ಬಾಳುತ್ತೆ ಸುಮ್ಮನೆ ಸಿನಿಮಾ ಥಿಯೇಟರ್ ಎಲ್ಲ ಇದೆ 50 ಲಕ್ಷ ಕೊಡ್ತೀನಿ.
ಏನಾಯ್ತು? They are not ready. Argue ಮಾಡಿ. He is not ready. How can we compel the party to
No,
agree to
No
your
question of
offer?
no question of
Offer is for treating. Therefore, in English law of contract, it is called invitation to treat. So, you have offered him to consider. He says, I am not agreeable.
No, that is all right. I thought that some dispute would come to an end.
Correct? But our ಒಪ್ಲಿರ್ ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ
Yes,
ಬರ್ತದೆ?
I know.
We can't force the parties to agree to
Yes, yes.
settlement. We can force the parties to agree with our orders,
I know.
not agreement.
In the end.
Argument. Start. 2014 matter. 2013 ಇದೇನು? 2014 matter.
Yes.
Argue ಮಾಡಿಬಿಡ್ಬೋದು. ಕೊಡಿ ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಆಗಿದೆಯಾ?
ಇದೆ paper.
All right, this matter will take some time. Your friends can go for a coffee round. Yes, sir.
But this was suit for partition.
Suit for partition. It takes time. You
Yes.
can go for a round and come back.
May I request your lordship
Ah,
to have it next week if you don't mind?
you want to do it next week?
Yes,
All right. Call this
because
matter.
this is second round of litigation in this honorable court. And there are some serious this thing
ನೋಡಿ
about the.
ಯಾವ ಡೇಟ್ ಕೊಡ್ತೀರಿ ನೋಡಿ. ನಮ್ಮ ಫ್ರೀ ಇರುವಂತದ್ದು ಕೊಟ್ಕೋಬೇಕು, ಬರೀ ಪಾರ್ಟೆಡ್ ಇರೋದು ಡೇಟ್ಸ್ನಲ್ಲಿ ಬರಬಾರ್ದು. 3rd of December?
3rd of?
December.
Yes, no problem.
Call this matter on 3rd of December at the request of counsel for the appellant. Finally. Yes. 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 Chetty. In Shakri.
Yes, this is the defendant's appeal, my lord. Suit for specific performance of the agreement dated 21/4/2010.
I think I am disabled in this matter. But it is an aim person. I'm disabled. It appears he was my client years ago. Call this matter next week before the other bench. After I get, not before me, not before me. Call this matter next week. Before the bench, wherein he is. Aditya. Yes.
Appear for the appellant.
Yes, Mr.
It seems appellant died about 4 days back. Yes, I'm filing.
Appellant is stated to have died.
Filing a memo to that effect, my lord. Got it confirmed.
A memo to that effect is filed this day. First of steps, please. Yes. Please. For the response. In Shakri.
This is with regard to fixation of pension, my lord.
Yes.
In respect of.
Give us the foundational facts.
Please. In fact, Madly, he has been reappointed. Responding. As Group A, that is a technical post scientist E, my lord. As per annexure A2, page 50.
Group
A, scientist E.
Scientist E.
Earlier, my lord, he was a wing commander and he has taken.
The defensive was.
Please, and he has been reappointed. That is not in dispute.
Not in dispute.
The only question here, my lord, for considering fixation of pension is concerned, whether.
I'm sorry, my lord, it is pay, not pension.
Pay fixation. Whether rule B1 is applied to the particularly respondent, or B2 and D2. That is the only issue.
Rules ಏನು ಏನ್ ಹೇಳ್ತದೆ?
Rule my lord, annexure A4 may kindly see. Ink page 55.
55.
Relevant page is my lord 56.
Do you have objection for your friend to sit down? No objection.
No.
We'll hear you. We'll not pass any order without hearing both us. Though not to your satisfaction, we will hear, reasonably we will hear you. 55,
56 is relevant.
56.
Page. There, my lord, the bottom, para 4D, my lord.
Cessation of pay
Please, my lord.
of personnel officers re-employed prior to 1/1/2006. He was re-employed after 2006? Before?
That's 6th July 2006.
So after?
Please.
And who were in employment as on 1/1/2006? In the case of personnel officers who were re-employed before 1/1/2006, who were working in the central government organization, then their pay will be fixed in accordance with provisions of POPT. The OM stipulates that re-employed person eligible to elect revised pay structure shall exercise option in the manner laid down in rule so and so. Pay shall be. In this context, it is clarified that in accordance with provisions of provisions, Department of Expenditure should so and so corresponding to each pre-revised pay scale. In the case of those persons who were re-employed before 1/1/2006, who were working in the civilized organization, re-employment with 1/1/2006, their pay will be fixed with reference to.
Please. Here, my lord.
No, that says actually perhaps the previous service rendered.
Please.
And the pay scales they were getting should be taken into account annuity there.
Here, only question in my lord, for group A, my lord, they were commissioned officer. Their pay will be fixed, my lord, in higher position, even initially, my lord. So far as B, below A is concerned, my lord, some portion, the pension has to be fully ignored while consider fixing the pay in the subsequent reappointment, because they have been getting a little less there. So fully earlier appointment, that pension service benefit fully has to be ignored. Now, so far as A is concerned, commissioned officer.
Now, how are you going to apply,
please,
for to a case where he was reappointed post 1/1/2006? ಅವ್ರಿಗೆ ರಿಲೀಫ್ ಕೊಡುವಾಗ CAT
ಪ್ಲೀಸ್
ಇದ್ರ ಪ್ರಕಾರ ಕೊಟ್ರ ಅಥವಾ ಇದನ್ನ ಇಗ್ನೋರ್ ಮಾಡಿದ್ರ?
ಅವರು D1 that is below.
We are asking you.
Please,
whether this provision is applicable to him or not.
Provision is applicable, only rule, which rule is applicable, that is the question, madam. Because if it is a B1, D1, I will just explain.
Why are you saying cutoff date is there? Cutoff date is 1/1/2006.
Please.
Admittedly, he was appointed in July 2006. How are you going to apply this rule to strengthen your argument? How CAT has reasoned?
That is in page 26, madam. Actually, that point even
not considered.
Not considered, but even, my lord, ultimately, my lord, the order.
OA 2015 336 of 2015 ಏನ್ ಮಾಡಿದ್ರಿ? Come to page 26.
Please.
In terms of that order, relief has been granted. Did he challenge that OA? Is it reversed?
No, this is the order we have challenged here, my lord.
No.
No, earlier one more OA was there, and annexure, that is, I will.
Which is this 1336 of 2015, dated 28/7/2016.
Ink page 112, my lord. Annexure E.
That was Solomon John.
Please.
This is Simon K.
Same
John.
part, responding.
The same,
That order we have challenged it, in writ petition, my lord, next, annexure, my lord, 115 starts.
no, whether this order was challenged.
Challenge.
What happened to that WP
This honorable court remanded the matter.
for consideration of?
Please, my lord. That is the next.
That's
week.
how the present order has
Please,
arisen.
please.
Okay.
That is 117, my lord. Para 3 and 4, my lord. Operative portion.
Where is that 4B1?
4B1, my lord, that is. Page 55, my lord. 56. 55 only there, first, second para, 4B1. That is revised, my lord, the right side.
4B1.
Actually, it applies to below group A, my lord. That is our case.
Cases where the entire pension and pensionable benefits are not ignored for pay fixation. The initial basic pay on re-employment shall be fixed at the same stage as the last basic pay drawn before retirement. However, he shall be granted the grade pay of the re-employed post. The maximum basic pay cannot exceed the grade pay of the re-employed post, plus pay in the pay band of rupees 6,000, 67,000. That is maximum of the pay band PB4. In all these cases, the non-ignorable part of the pension shall be reduced from the pay so fixed. Illustrate, Kanwal who retired with basic pay of 61,007, grade pay of 87,000, pay in the pay band of 53,000 is re-employed with the deputy secretary in organization with grade pay of 7,600. In this case, on re-employment, his basic pay will continue to be 61,700. However, his grade pay on re-employment will be rupees 7,600. And the pay in the pay band of 54,100. Thereafter, the non-ignorable part of the pension will be reduced from the pay so fixed. In the revised pay structure, basic pay is pay in the pay band plus the grade pay attached to the post. What the apex court said on this? Where is that judgment?
That is produced, my lord. In that, my lord, in fact, he is not a group A, only clerk, my lord. That we have no quarrel with that. If it is below group A, my lord, we can't have any grievance and quarrel also.
This applies only when
Yeah, my lord. Our case is, my lord, B2 and D2. Because the rule is very clear. But in fact, my lord, the order earlier, my lord, it has been quashed. As per the impugned order, my lord, they upheld the very order which was quashed by this honorable court. The last portion of the.
Remand agittu.
Quash.
After remand, their field is wide open.
In fact, they should not use that word, my lord, upheld, because so this court has already quashed it.
That's not right. But whole thing is wide open. The unruly horse can run amok in a field when it is open. They have done that. That exercise they have done. The object is those who have put in service of the motherland with the possibility of sacrificing their lives if need arises, for them this benefit is granted. It is meant for defense personnel only.
Please, my lord, but there is no, we can't have a grievance also. The only question is, my lord, even I have stated in my petition itself, why that rule is being used. That's because initial fixation itself is in a higher side. That's why, my lord, some portion of the earlier pension has to be ignored. Otherwise, there is no difference now, my lord, so far as ABC is concerned.
Why there should be?
Because they are also fully ignored.
No, why at all there should be difference?
So that
Who all went to the borders
placement.
to guard the frontier of the country? They constitute one.
No, there, my lord,
regardless of
basic pay, my lord, while fixing, we will fix less, my lord, for below A. Now, my lord, A is getting more, my lord, while even fixing basic pay also, and here, my lord, fully ignored. So in that way, my lord, there should be some purpose in.
You read 4.
Please.
56-4, page 56, 3-4. 3 plus 4.
4D may kindly similar last, but 4D.
4D.
Please. That is our stand, my lord. This will 4D 1, that is no change. 4D 2, my lord, the last portion of the
In the case of
in the case of
service
commissioned
officer
service officer,
belonging to the
the
defense
respondent is
pensioner.
commissioned officer belonging to the defense forces, civilian pensioners who held group A post at the time of retirement, the first 400 of the pension and pension equivalent to retirement benefit shall be ignored. Here we have got a problem. Because so far as below A is concerned, my lord, fully ignored. We can't deduct any pension. Even I have stated in my petition, my lord, why we para 16, my lord, in page 70. Why that difference comes like that?
No, why you read 56? Please come to page 56.
Please.
Why you read 3 Roman 4? English 3 Roman 4. That's how you began your argument, na?
Please.
Why you read this?
3, my lord.
You read cut off date. Page 56.
Please, my lord.
Small Roman 4. You drew our attention to this provision. Why?
Because here, my lord, group A.
Did you draw our attention to this one? You made us to read. You wanted to bank upon this provision, na?
Please, ma'am.
In support of your case.
4D2.
4D2.
That is bottom, my lord, right side.
In the table.
Please, right side, bottom.
This has not been considered by the CAT.
Please, ma'am. Because whether there is a difference between A and below A, my lord. That they should have been.
In case of below A, the pay is fixed at a lower level.
Please.
For
Even
these people, it is fixed at the higher level.
Please. Because there is some purpose in that, my lord. Page 16, I have mentioned, my lord, why we have been harping upon this particular.
Where is that apex court judgment which the tribunal has banked upon?
That is in page 109, 109.
109.
Not 109, 119. annexure G.
Ah.
So para 3, the last bottom, my lord, that itself, my lord, respondent was appointed as a clerk. So clerk is a, my lord, below A. That is. Annexure G, my lord.
ಆ ಪೇಜಸ್ ಇಲ್ಲೇನಾ? ಇಲ್ಲ. Mistake, my lord.
Sorry, my lord, there is.
No problem. We get it wherever it is. Purpose is served. Clerk under no fees order dated 22, his pay had been fixed. In his salary. This could not have been banked upon by the tribunal at
Please.
all because of the.
Because admittedly, my lord, the clerk, my lord.
So
for
he
which-
is not done.
Please.
What do you say?
No.
Admittedly, my lord.
Huh?
My learned friend has
Sir,
not read.
adjudgmental. Adjudgmentally clerk.
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು. The tribunal, my lord, while allowing the OA, has clearly stated, my lord. Firstly, my lord, I participated in a open recruitment on par with civilian employees who would not get the age relaxation. I competed with general, and therefore, my lord, I have appointed on the basis of open recruitment. Your lordship may kindly see annexure A2 filed by the appointment order. I am directed to convey the president. He is pleased to offer you a group A technical post in scientist E against advertisement number so and so.
How that makes a difference?
So he is a direct recruit and direct entry officer, my lord.
Correct.
If your lordship may kindly now take, my lord, the OM dated 5/4/2010, because the pages.
Just now. 119. And 115 I put on. Yes, Supreme Court.
Extremely sorry, my lord, I will. There is any.
ಇದು ಬಿಟ್ಟು. Right. Yes, brother.
My lord, now kindly take, my
Your
lord.
first contention is you are
I was
appointed
a
in the open
directed
market.
entry,
From
yes.
the open market.
Yes, my lord.
How that is relevant for
My
fixing?
lord, that relevant, my lord. Here, I come to, my lord, the 4A and 4B1, my lord.
Correct.
In support of my case, my lord. 4A says,
4A.
yes, my lord, re-employed pensioner shall be allowed
Page
to
number?
draw. Page, my lord, apparently,
54.
there is some difference in the pagination.
Inexorably.
Mine, A4 is written in the red ink in my pen, my copy.
A4 ತಾನೆ?
And
55.
5th April 2010.
5 April, yes, my lord, 5th April 2010. 4A reads, my lord. The existing provision prior to 1/1/2006 was re-employed pensioner shall be allowed to draw pay only in
ಅದು ಬಿಡಿ
the,
ಅದು ಇದು as on today.
as on today, my lord, is in the other side.
ಅದು ನೋಡಿ.
Re-employed pensioner shall be allowed to draw pay only in the prescribed pay scale, pay structure of the post in which they are re-employed.
Employed. No protection of the scales of
Yes.
their pay structure of the post held by them
Yes.
prior to retirement shall be
Yes.
given.
Therefore, my pay ought to have been fixed in the lowest of the pay scale corresponding to the earlier pay scale of 14,800, 18,300. My lord, that is what I asked for. My lord, kindly go to my lord 4B2. In all cases where the pension is fully ignored, the initial pay on re-employment shall be fixed as per entry pay in the revised pay structure of the re-employed post applicable in case of direct recruits appointed on or after 1/1/2006. I have been appointed on or after 1/1/2006. They asked me, my lord, to take retirement from the air service, Air Force.
ಸೆಂಟೆನ್ಸ್ ಆದ್ಮೇಲೆ ಪಾಸ್ ಕೊಡ್ಬೇಕು.
Yes,
ನಾವು ಅಸೆಸ್ ಮಾಡೋದು ಬೇಡವಾ?
yes, ma'am.
All cases where the pension is fully ignored, the initial pay on re-employment shall be fixed as per entry pay in the revised pay structure of the re-employed post applicable in the case of direct recruits appointed on or after 1/1/2006 as notified so and so, so and so. 4B1 you have read now,
Yes,
is it not?
I rely on this class.
All right.
And
Go
the-
to, all right, we'll have this one second. Go to rule 4D2.
Yes.
To whom 4D applies?
Well, here my contention is, as an illustration, it has been stated. It does not mean that for others 4B1 is not applicable. Otherwise, my friend has to establish how he comes to know that only less than a group A officers are eligible for initial fixation of entry pay. Initial fixation of entry pay is to everybody because the wording is used in all cases where the pension is fully.
4B1 you have read.
Yes.
All right.
I say that 4B1 is applicable to me, which has been upheld by the Honorable Tribunal.
Our tribunal has not referred to that at all.
It has, my lord.
It only went by the apex court decision,
yes.
which
No.
related to clerical cadre.
No, it says, my lord, if I may be permitted to read the order of the tribunal, my lord. Heard the matter is covered by our earlier order in OA number 1336. This OA, my lord, was initially filed when my case was pending and the Honorable Tribunal.
Anyway, that has been set
That is
aside and
over.
remanded.
That is always over. Your lordship raised a query earlier. That is why I am clarifying it. Then the matter is covered by the order of the Honorable Apex Court in Civil Appeal number so and so. That is the
wrong.
last annexure which my friend.
That
had
itself
referred.
is wrong.
Yes. Wherein the Honorable Apex Court had clearly held in para 10 of the order that whenever a person receives a military pension and on re-employment, it is not taken into account to fix the pay, then it shall be in accordance with 4B1. Now, my friend's contention is that the Honorable Supreme Court was dealing with the case of only non-commissioned officer.
Yes.
If there were to be any decision shown by my friend where a commissioned officer's case was declined, I have no case. Here, whether it is non-commissioned officer.
But how this case is not a commission?
No.
Cumbersome argument ಮಾಡ್ತೀವಿ. Now we are saying. See, 4B1 is a general law.
Yes, my lord, in all cases.
4D2
Yes.
is a special law. There can be a general law and a special law in one instrument of law. Do you agree or you don't?
Yes,
want to?
I do.
The same statute or same subordinate legislation can have both mongoose
Yes,
and
ma'am. Yes.
cobra together
Yes.
in our system. If your case falls into special provision, that overrides the general
Agreed.
provision. Agree?
Agree.
Do you agree that 4B1 is general?
It says, my lord, may I clarify? In all cases,
Okay.
in all cases where full
Therefore,
intention
it
is
is general.
ignored, there are two ways of fixing the pay of the person, my lord. One is entry pay. Nothing is taken into consideration from the earlier Purvashram service. Or I insist that
That
my
is
pay should be
clean, that's called in service to clean slate entry. If you take it as a clean slate entry, what you say is correct. That's not a case of clean slate entry. You are
a direct entry.
you were a commissioned service officer.
Yes, I
In
was.
the defense.
I was.
Therefore, the special provision applies. A special provision is made for commissioned service employees. Illide. Page 55 bani.
Ade.
There are
Supreme Court judgment also, my lord, it is referred. 4D2, my lord.
54 is general law. Correct. It is all employees. Special case is made, special rule is made for categories of his client.
In Supreme Court judgment.
Argument ಇದೆ?
My lord, yes,
Yeah, there are.
yes, my lord. I have, my lord, I have produced one appendix, my lord, which I had produced along with my representation. In my paper book, the page number is 8990. And I don't
Paper
know.
book ಇದೆಯಾ? ಕೊಡಿ. ಏನದು? Paper book ಇದೆಯಾ? ಇದ್ರಲ್ಲೇ ಇದೆ.
ಅದ್ರಲ್ಲಿ ಇದೆ.
The same.
ಇದ್ರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಏನು?
ಗೊತ್ತಿಲ್ಲ. I'll search and give it back.
ಕೊಡಿ ನಿಮ್ದು ಯಾವ್ದು ಕೊಡಿ. ಓದಿ ನೀವು ಒಂದ್ಸರಿ ಓದ್ಕೊಂಡು.
Yes, my lord. My lord, pay fixation in respect of a defense officer of colonel with last pay drawn of rupees.
ಏನದು? What is that?
ಇದರಲ್ಲಿ it says.
Credentials ಏನು? ಯಾವ್ದು? What is the order? Rule ಏನದು?
Unfortunately, the full document is not, only one extract is produced. It apparently appears to be this revised RP rules. RP rules extract. So where there, it gives an option, whichever is beneficial, I can choose.
ಡೇಟ್ ಯಾವ ಡೇಟ್ ಇದ್ದದ್ದು? ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದನ್ನ?
ಹೌದು, ನಾನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದೆ.
ನೀವೇ ಹೇಳ್ಬೇಕು.
But I have to get my this thing, because the full document is not available. The applicant had produced several documents in which the certain documents are missing. And probably that is this copy is given to me by my friend.
That's all right. It is your document.
That my file, if I get, my lord, I'll be able to produce the entire
Will not
thing.
give time.
My lord, all right, my lord. This is a RP rules, my lord, which says that wherever a person has an option, he can choose the option which is beneficial to me. So that option I have exercised.
ಬರ್ಕೊಳ್ಳಿ. ಆಯ್ತಾ? ಬೇರೆ ಏನಾರ ಇದೆಯಾ?
Yeah, then their counter argument appears to be that I have not faced any interview or any such thing according to the pleadings in the case.
That makes no difference.
Yes.
The entry, how one gains entry to the palace is not our concern. Once he enters, what should be given to him?
My case, still, my lord, I rely on, my lord, 5/4/2010 OM 4B1, read with an option, my lord, dated 5th July 2010, where a further option was permitted to be given to us to exercise an option to go to whichever scale that is beneficial to us.
Right, good. Sit down, please be seated.
And one more submission is
Yes.
that the provision which my friend is relying is applicable to a person who retires after attaining the age of superannuation, where after re-employment, there is no career progression. He will enter the service and retire. Whereas in my case, I have been inducted directly, I have been promoted, I have been confirmed. All procedures and formalities applicable to a direct entry employee is applicable to me.
ನಿಮ್ ಜೊತೆ ಅಪಾಯಿಂಟ್ ಆದಂತವ್ರಿಗೆ ಏನಿದೆ ಸ್ಯಾಲರಿ?
My lord, there was one case where they had initially granted
ಇವರಿಗೆ ಡೈರೆಕ್ಟ್ಲಿ ರಿಕ್ರೂಟ್ ಆದಂತಹ ಪರ್ಸನ್ಸ್ ಏನ್ ಸ್ಯಾಲರಿ ಕೊಡ್ತಾ ಇದಿರಲ್ಲ,
Please,
ಇವ್ರಿಗೆ ಕೊಡೋದು ಲೆಸ್ ದೆನ್ ದಟ್ ಇದೆಯಾ, ಅಷ್ಟೇ ಇದೆಯಾ?
verify, madam.
ಅಲ್ಲ, ಕ್ವಶನ್ he cannot, he has to be given at least the salary in the pay scale prescribed for direct recruits. It cannot be less than that in any event. In pay scale nimdu.
The early, the pay scale prior to the implementation of 6 APC was 14,300, 18,300.
In para 16, my lord, I have explained.
Less than ಮಾಡ್ಕೊಡ್ಬೇಕು. ಅದಕ್ಕೆ ಇದು ಮಾಡಿದ್ದಾರೆ. ಹೈಯರ್ ಲೆವೆಲ್ ಜಾಸ್ತಿ ಎಮೋಲ್ಮೆಂಟ್ಸ್ ಅಂತ.
Para 16 only,
Para 16.
In detail, I have ink page 17 of my petition.
No.
Last para.
Para 16.
Please.
He has not challenged ಅಂತ ಹೇಳಿದ್ವಿ ಅಷ್ಟೇ. ನಮ್ಮ ಪ್ರಶ್ನೆ ಅದಲ್ಲ. What was the?
ಅಲ್ಲಿ ನಾವು, how much it has been fixed, my lord?
ಅದಿದೆಯಾ? Para 15. Para 15.
16, my lord, last para. Sir, ink page 17 ಅಲ್ಲಿ. Last para.
ಓದಿ.
It is relevant to mention that for a commissioned rank group A post office, the pay scale in their reappointment which starts from 15,639,100. And since the respondent was in a E group, scientist E, his pay has been fixed from 37,000 to 67,000, pay band 4. Applying the provision para 4B2 and 4D2 of the OM dated so and so, whereas for non-gazetted officer group B or below group B employees, the initial pay will starts from 9,300 up to that is 34,800 for non-scientific group. Applying the provisions of 4D1 of the OM 54/2010, it is relevant to mention that since the non-gazetted officers group B or below group B, that is non-scientific group post, employees are getting less initial pays, their pensions are to be ignored fully. Whereas since the respondent was holding group A.
All. Understood. Good.
My lord, one last para, my lord, one submission. Honorable CAT, my lord, in para 2 of its order says, when two options are available and the government chose one option among them, that has to be followed through continuously. They cannot elect to choose one element of the option and then another element of another option. The idea is when.
Where is that?
In the impugned order.
No, that is put in challenge now.
Yes.
Where is that provided? That facility is provided.
That is what I am relying on 4B1.
4B1.
4B1 is exclusively applicable to me, and they have not distinguished, even saying that the non-commissioned officers alone are entitled for such benefit.
ಕೂತ್ಕೊಳ್ಳಿ. ಬರ್ಕೊಳ್ಳಿ. Petitioners are knocking at the doors of Court for assailing Central Administrative Tribunal's order dated 27/11/2017, whereby OA number 526 of 2014 of the respondent having been favored, relief has been accorded to him as texted below. Page 27, para 2 ಹಾಕಿದ್ರು. Learned CGC appearing for the petitioners seeks to falter tribunal's order on the following grounds. Small Roman 1. The order is structured on the basis of apex court decision in so and so, which is not applicable to the respondent in as much as the said decision related to an official of lower cadre in the defense services. Semicolon. The tribunal ignored the text of 4D, small d, Roman 2, which constitutes a special law qua para 4B1 in the OM dated 5/4/2010 and thereby an infirmity, a legal infirmity of great magnitude having financial implications on the central exchequer has crept into. First. Next paragraph. Learned counsel appearing for the respondent employee resists the petition, making submission in justification of the impugned order and the regions on which it has been constructed. First, he emphatically reads out para 4B1 of the OM dated 5/4/2010 and asserts that the case of his client would fit into the precincts of the said paragraph, and therefore we need not travel to the other paragraph banked upon by learned CGC. First, he also gives a thumbnail description as to how he gained entry to the service from the open market. First, next paragraph. Having heard learned counsel appearing for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter for the following reasons. Number 1, the submission of learned CGC that the tribunal could not have structured the impugned order in the light of apex court decision supra has force. Semicolon. Apparently, the said decision related to an official of the lower cadre in the defense department, wherein obviously the pay scales will be comparatively not that attractive qua officials in the higher cadre. First off, it was Lord Halsbury who said in Quinn versus Latham that a case is an authority for the proposition laid down in a given fact matrix and not for all that, that logically follows from what has been so laid down. First off, a little fact can make a sea change warranting a different approach, and resulting into a different finished product. First, when the decision had one of the essential facts, namely the cadre of the official involved in the litigation, comma, that factor could not have been ignored by the tribunal. First, that runs counter to law of precedent. First, next paragraph. There is a force in the submission of learned CGC that the OM dated 5/4/2010, a copy whereof avails at Annexure A4, is in the nature of a delegated legislation, since it has got normative and repetitive effect in all cases, and that para 4B1 promulgates a general law which has to yield to para 4D3, which is a special provision. Essentially, and in so many words, made applicable to the cases of commissioned service officers belonging to the defense forces. Semicolon. Learned counsel appearing for the respondent employee, in all fairness, agreed that a general law and a special law can coexist in one legal instrument, and that the latter would prevail over the former. First, paragraph 4B1 reads as under. First, its generality in application and coverage cannot be disputed. First, paragraph 4D2 has the following text. Its speciality also cannot be discounted. First, this aspect having not been adverted to by the tribunal, comma, learned CGC is right in telling us, comma, the legal infirmity has crept into. First, next paragraph. The vehement submission of learned counsel appearing for the respondent employee as to how his client gained entry to the civil service, having retired prematurely from the defense services, comma, does not have much relevance for the fixation of pay and structuring of salaries on that basis. First off. Next one. In the above circumstances, this petition succeeds. 177. Please sit down. I'll hear you after that. A writ of certiorari issues, quashing the impugned order of the tribunal. Courts made easy. Yes, sir.
Availability of option for the applicant, my lord. That has not been found in place.
Last page. The related contention that his client had exercised the option, and that would make all the difference so far as fixation of pay is concerned, again pales into insignificance, rules being what they are.
Sorry, my lord, I have.
Why?
some Page nation, my lord.
Sorry, sometimes it happens, na? You have put one extra page. That's all. Nothing has happened. Therefore, otherwise we were on same page. Both we were on the same page. No.
Petition. My lord,
Ah.
the impugned order identically placed a person by referring to the impugned order filed an OA in the Andhra Pradesh tribunal. The tribunal allowed because identically based at that of my case. Against that, Union of India preferred writ
SLP.
petition
WP.
in the High Court. And in the High Court,
ಏನ್ ಮಾಡ್ತಾರೆ?
they
Dismiss
made a
ಮಾಡ್ತಾರಾ?
no, no,
Affirm
in
ಮಾಡ್ತಾರಾ?
the High Court, what has happened is they have complied with the order.
They have complied with
They
you.
have complied. Hence, the writ petition has been disposed of on 23rd April. Identically placed. Annexure A8, page 117, Chalsani Rajashri. She was placed like at that of me. She is at serial number 7 and I am at serial number 9. At Annexure A8, page 117, my lord.
No, ಸ್ವಲ್ಪ few facts let him say. You can say that after.
Identically,
Okay.
nothing remains for this reason that Hyderabad tribunal followed this impugned order and allowed it, saying it identically placed, which is a fact. And against that, the Union of India preferred the writ petition. When the writ petition came up for hearing, my lord, they say they have complied with the order. That is, relief has been given to Chalsani Rajashri.
In the same department.
Same department, same 118, 117, Annexure A8, my lord.
Names of both the persons are in the same list, man.
They are also in the
Seven
same.
and-
Same list.
Same list, my lord.
7 and 11.
You,
11.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
Yes. Order, Hyderabad order. OA also. OA order also.
The OA order.
Lords, in the OA, my lords, OA order, the tribunal refers to the order passed in this writ petition, which is impugned. Based on that, it says it is covered by this order of the tribunal. ಇಲ್ಲಿ ಏನು ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಿ,
Correct.
ಆ ಆರ್ಡರ್ ನ ಫಾಲೋ ಮಾಡಿ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ my lords.
Passed.
ಹೌದು.
And you challenged it
That was challenged and
before the
contempt was,
Andhra Pradesh High Court.
contempt was filed. They have complied and paid the amount. And in the writ petition, it is held that because of the compliance and amount is paid, and it is closed. That's the.
Did you retain your right to see, if a money decree is passed and amount is paid in execution, that does not kill your right of appeal. We understand that.
Ali, it seems that they are not in compliance of the contempt order, they have paid.
Did you read? Then not only that,
ಅದಾದ್ಮೇಲೆ
you got the petition disposed of as a become
ಆಮೇಲೆ in the High Court, my lords, it is observed that in view of the complaints which is passed, my lords, order is passed. I can't make a submission contrary to it because I was also carrying that same thing to point out also.
I reserve this, sir. They cannot do it because same department. You can't give benefit to one and deny that to another who is similarly circumstanced.
That I don't have any arguments to make contrary to it. It is there. But only to say that e-order, when it is pending before the sound court, which has not, which refers.
No, you should have said.
I should have done,
Saying,
my lords,
No, we are making this payment subject to outcome of the petition before the High Court of Karnataka. That you did not do.
ಅಲ್ಲಿ ಪೆನ್ಷನರಿ ಬೆನಿಫಿಟ್ಸ್ ಮಾತ್ರ ಕೊಟ್ಟಿರೋದು ಕಂಪ್ಲೈನ್ಸ್ ಇದೆ. ಇಲ್ಲಿ ನಾವು ಪೆನ್ಷನರಿ ಬೆನಿಫಿಟ್ಸ್ ನಾವೇನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಅಂದ್ರೆ ಟು ಪಾಯಿಂಟ್ ಔಟ್, ಇಫ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಇಸ್ ಹೈ ಕೋರ್ಟ್ಸ್ ಆರ್ಡರ್ ಪ್ಯಾರಾ 2, when the matter is taken up for hearing, learned counsel for the respondent has informed this court that the order dated so and so
passed by the tribunal in OA number 917 of 2016 has been complied with, and all pensionary benefits were paid to the respondent. Illino, whatever pensionary benefit it was there, it has been paid, my lords, to the respondent herein also. Yeah. Issue is not about pensionary benefit.
Identical prayer in the OA.
Complied. Otherly, what was done in that one, my lords? If my lords sees page number 6, my lords, I'm just trying to. What was the grievance of the petitioner before the tribunal? Lord's grievance of the petitioner is that, my lords, he is entitled for financial upgradation, which is known as ACP, my lords, under the ACP scheme. Yes. That was his grievance. The basic facts, few facts I'll just point out. Lords, the applicant respondent entered into the service on 1/10/1977, my lords. Entry is on 1st October 1977. Military engineering service. Yes. As superintendent grade 2, my lords. His education qualification is diploma holder, my lords. He is a diploma holder, my lords. My lords, in the year 97, that is with effect from 9/7/1997, 2 grades, my lords. He joined as grade 2. Grade 1 and grade 2 were redesignated as JE Civil, my lords. It got redesignated, grade 1 and 2. Merged into and redesignated. Redesignated as JE Civil, my lords, with effect from 9/7/1997, due to which there of 2 grades. How? Grade 1 and 2, which is redesignated as JE Civil. Grade 1 and grade 2. How? As redesignated as JE Civil. ಅಲ್ಲಿ ಡಿಪ್ಲೊಮಾಸ್ ಅಂಡ್ ಗ್ರಾಜುಯೇಟ್ಸ್ ಇಬ್ರು ಇದ್ರಾ? ಇಬ್ರು ಗ್ರಾಜುಯೇಟ್ಸ್ ಇಲ್ಲ ಡಿಪ್ಲೊಮಾನವರೇ ಇದ್ದಿದ್ದು. ನೆಕ್ಸ್ಟ್ ಅದಕ್ಕೆ ಮಾತ್ರ ಇಂಜಿನಿಯರಿಂಗ್ ಬೇಕಾಗುತ್ತೆ, ನೆಕ್ಸ್ಟ್ ಪ್ರಮೋಷನ್ ಇದಕ್ಕೆ ಇದ್ದಿದ್ದೆ ಅವರು. ಇದಕ್ಕೆ ಏನಂತ ಕರೆದ್ರಿ ನೀವು ಹೊಸ ಹೆಸರು? JE Civil ಅಂತ. JE Civil. ಹೌದು. This is with effect from 9/7/1997. Illi in between, my lords, one point I want to make it out, that we did not have any kind of financial upgradation as such, but there were time scales were given, my lords, after a certain period, 5 years, 10 years, 15 years, ಆ ತರ ಕೊಡ್ತಾ ಇದ್ರಿ. Here, my lords, the applicant passed one examination known as, my lords, Military Engineering Service on 30th of June 2003, my lords. This is a crucial date, my lords. 30th of June 2003, my lords. He passed one examination which is known as Military Engineering Service, my lords. My lords, this is the crucial date, my lords, wherein it depends when he has passed that examination to get a particular financial upgradation. This is the crucial date. 30 June 2003. How? My lords, by mistake, my lords, when the ACP scheme came into effect from 1999, we had given him benefit of the next in line. ಒಂದ್ ಇಬ್ಬರು 3 ಜನ ಇರಿ, ಉಳಿದವ್ರು ಏನ್ ವೇಟ್ ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ, ಇದೆಲ್ಲ ಮುಗಿಸಕ್ಕಾಗುತ್ತದೆ. ಹಂಗಾಗಿ ತಮ್ಮದ್ರಲ್ಲಿ ಡೋಂಟ್ ಮೆನ್ಷನ್ ಎನಿಥಿಂಗ್, ಡೋಂಟ್ ಡಿಸ್ಟರ್ಬ್ ಅಸ್. Yes, you need not wait, you can come afternoon. Yes, please move. 30 June 2003, he passed one examination, my lords, which is known MES examination. MES examination anta he has passed. Lords, in between this, my lords, ACP scheme was introduced in the year 1999, saying that certain financial upgradation they are entitled at the period of 12 years and 24 years anta ittu, regardless of examination. Allala, adu examination also linked. Adu ide. Adರಲ್ಲಿ ಒಂದು condition number 6, which I will just point out, my lords, said that may just request my lords to kindly take up page 59 for a moment. This is the scheme, one of the condition number 6. Page number 59, please. 15. Yeah, scheme starts with page 55. Relevant page is 59. This will be the relevant clause, my lords. Third. Conditions for grant. ಹೌದು, ಕಂಡೀಷನ್ಸ್ ನಲ್ಲಿ ಬರುತ್ತೆ. ಆ ಕಂಡೀಷನ್ಸ್ ನಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಲ್ಲಿ 6ನೇದು, ಅದು ನಂಬರ್ ಮಾತ್ರ 6 ಇದಾಗಿದೆ, ಕಾಪಿ. ಫುಲ್ಫಿಲ್ಮೆಂಟ್ ಆಫ್ ನಾರ್ಮಲ್ ಪ್ರಮೋಷನಲ್ ನಾರ್ಮ್ಸ್, ಬೆಂಚ್ ಮಾರ್ಕ್ departmental examinations,
Seniority.
seniority cum
Yes.
fitness in case of Group D employees, etc. Well, here there are certain fulfillment has to be done for promotional norms. First one is benchmark, my lords, that is ACR adela barutte. Second one is departmental examinations. That is applicable to these persons. Next to the Yurik Barala, it is for Group D employees. He is not a Group D. Next to the seniority cum fitness in case of
One
Group
second.
D.
A fulfillment of norms, normal promotion ಇದೆಯಲ್ಲ
ಹೌದು
ಅದೇನು 5.3 ನಾ
ಅಲ್ಲಲ್ಲ ಅದು
6 ಅದು
6 ಸಾರಿ ಅದು ಸ್ವಲ್ಪ ಇದಾಗುತ್ತೆ 6 ಅದು
all.
For the financial accreditation, this is there. Departmental examination is one of the requirement. Departmental.
Let us read this. One second. Let us face this.
Fulfillment of normal promotion,
Grant of financial
norms,
performance,
benchmarks, departmental examination, seniority cum fitness in case of Group D employees, etc. For grant of financial accreditations, performance of such duties as are entrusted to the employees together with retention of old designation. Financial accreditation is personal to the incumbent for the stated purpose and restriction of ACP scheme for the financial and certain other benefits, house building advance, allotment of government accommodation, advance, etc. Only without conferring any privilege related to higher status. That is, example, invitation to ceremonial functions, deputation to higher post, etc. shall be ensured for grant of benefit under ACP. Here, my lords, the contention of the department is, one the departmental examination is, it is MES examination, which is crucial. Adunu pass agbeku if the benefit is to be
And
there.
he passed on 36/2003.
ಹೌದು. Now ಏನ್ ಮಾಡಿದ್ರಿ, by mistake, my lords, to not only this, all ಒಂದು 13 ಜನಕ್ಕೆ by mistake we had given it on 2 different dates that was recalled, and again we said they are entitled for 2001 ನಲ್ಲಿ ಒಂದ್ಸರಿ ಕೊಟ್ರಿ, ಆಮೇಲೆ 4 ನಲ್ಲಿ ಒಂದ್ಸರಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಆಮೇಲೆ after some confusion they have said when they have passed from that date ಅಂತ ಹೇಳಿ ಅವಾಗ ಕೊಟ್ರಿ. ಇವ್ರಿಗೂ he has passed on a particular period, is that period ಇಂದ ಅವಾಗ ಕೊಟ್ರಿ. Here, my lords, even clarification is there by the DOPT, which is available at page 64. There are 2 clarifications, my lords.
ಅಲ್ಲ, ನೀವು 6 para 6 you read that.
ಹೌದು.
Which other paragraph is relevant here?
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಅದೊಂದೇ
ಅಷ್ಟೇ.
ಅದೊಂದೇ.
In very general terms ನಲ್ಲಿ ಇದೆ ಅದು.
ಹೌದು. ಅದಕ್ಕೆ ಇದು
examination ಬಗ್ಗೆ ಎಲ್ಲಿದೆ?
Doubt, my lords, whether it will apply that they have to write this examination even in spite of financial accreditation scheme. ಅವಾಗ್ಲೂ ಬೇಕಂತ, that was the doubt. That was clarified. 2 clarifications are there. One is available page 64, condition number 16.
Document beautifully argues. ಯಾವುದು paragraph 16 16
ಹೌದು 16 page
64.
ಹೌದು, ಲೆಫ್ಟ್ ಸೈಡ್ ನಲ್ಲಿ ಕ್ವೆರಿ ಇದೆ.
You are right.
The relevant recruitment slash
rules
service
prescribe
rules
departmental
prescribe
departmental
departmental
skill test for
skill test for
vacancy.
vacancy based promotion.
Vacancy
However, this need
based
not be insisted for accreditation under ACP. This was the query. Right column.
What was that?
The relevant recruitment slash service rules prescribe departmental examination, skill test for vacancy based promotion. However, this need not be insisted for accreditation under ACP.
Yes.
ಅಂದ್ರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಲ್ಲ ಸ್ಕಿಲ್ ಟೆಸ್ಟ್ ಏನಾದ್ರು ಇದ್ರೆ
ಬೇಕಿಲ್ಲ.
ACP ನಲ್ಲಿ ಇನ್ಸಿಸ್ಟ್ ಮಾಡಬೇಕು ಮಾಡಬಾರ್ದಾ ಅಂತ ಕ್ವಶನ್.
ACP ಅಂದ್ರೆ ಅಡ್ವಾನ್ಸ್ career
assured career progression.
advance
Same thing, the scheme which I read, my lords.
Okay. As per the scheme condition number 6.
ಅದರಲ್ಲಿ so and so all promotion norms have to be fulfilled for accreditation under the scheme. As such, no accreditation shall be allowed if any employee fails to qualify departmental skill test prescribed for the purpose of regular promotion.
Any employee fails to qualify departmental skill test prescribed for the purpose of regular promotion. Regular promotion ಏನಿತ್ತು examination?
ಅದು ಇದು ಪಾಸ್ ಆಗ್ಬೇಕು ಅಂತ, ಅದು ತಮಗೆ ಪೇಜ್ 41 ಅಲ್ಲಿ ಸಿಗುತ್ತೆ.
Page 41.
ಹೌದು, 41 ಸಿಗುತ್ತೆ.
To say that you clarified that this MES has to be passed for the application of the AP.
ಹೌದು.
Yes.
ಹೌದು ಬೇಕು ಅದು ದಟ್ಸ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ ರಿಕ್ವೈರ್ಡ್ ಅಂತ ಕ್ವಶನ್ ವಾಸ್ ವೆದರ್ ಇಟ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್ ಇನ್ ದಿಸ್.
ಸೊ ಇಟ್ಸ್ ರಿಕ್ವೈರ್ಡ್ ಅಂತ ಹೇಳಿದ್ರಿ.
ಹೌದು ಅದು ಇನ್ನೊಂದು
41 ಏನು
41 ಅಲ್ಲಿ ಏನಂತಂದ್ರೆ ದಿಸ್ ಇಸ್ ದಿ ರೆಕ್ರೂಟ್ಮೆಂಟ್ ರೂಲ್ಸ್ ಮೈ ಲಾರ್ಡ್ಸ್ ವಿಚ್ ಇಸ್ ಅಪ್ಲಿಕಬಲ್. ಮೈ ಲಾರ್ಡ್ಸ್ ವಿಲ್ ಗೆಟ್ ಫಸ್ಟ್ ಸೀರಿಯಲ್ ಇಸ್ ನೇಮ್ ಆಫ್ ದ ಪೋಸ್ಟ್. ದಿಸ್ ಇಸ್ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಇಂಜಿನಿಯರ್ ಪೋಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ಬಟ್ ಇದು ಜೂನಿಯರ್ ಇಂಜಿನಿಯರ್ ಅಲ್ವಾ?
ಅಲ್ಲಲ್ಲ ಅದು
ಪ್ರಮೋಷನ್ ಟು ಅಸಿಸ್ಟೆಂಟ್
ನೆಕ್ಸ್ಟ್
ಫ್ರಮ್ JE to AE.
ನೆಕ್ಸ್ಟ್ ಬಿಲ್ಡಿಂಗ್ ಮತ್ತೆ ರೋಡ್ ಅದರಲ್ಲಿ
ರಿಕ್ವೈರ್ಮೆಂಟ್ ಏನೇನಿದೆ
ಅದರಲ್ಲಿ ಕೆಳಗಡೆ 11 ತಾವು ನೋಡಿದ್ರೆ
ಪ್ರಮೋಷನ್.
ಹೌದು. ಇನ್ ಕೇಸ್ ಆಫ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಬೈ ಪ್ರಮೋಷನ್ ಡೆಪ್ಯುಟೇಷನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಗ್ರೇಡ್ಸ್ ಫ್ರಮ್ ವಿಚ್ ಪ್ರಮೋಷನ್ ಡೆಪ್ಯುಟೇಷನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಟು ಬಿ ಮೇಡ್. ರೈಟ್ ಸೈಡ್ ಪ್ರಮೋಷನ್ ಸೂಪರ್ಡೆಂಟ್ BR grade 1 ಇದು ಮರ್ಜ್ ಆಗೋಯ್ತು.
ಎಕ್ಸಾಮಿನೇಷನ್ ಇಸ್ ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್.
ಹೌದು ಲಾಸ್ಟ್ ಇದೆ ಅಂಡ್ ಹ್ಯಾವಿಂಗ್ ಪಾಸ್ ದಿ
MES ಎಕ್ಸಾಮ್.
ಹೌದು. ಇನ್ ಕೇಸ್ ಆಫ್ ಡಿಪ್ಲೊಮಾ ಹೋಲ್ಡರ್ಸ್ ದೇ ಹ್ಯಾವ್ ಟು ಪಾಸ್ ದಿಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅನ್ನೋದು ಇಟ್ಸ್ ಎ ರಿಕ್ವೈರ್ಮೆಂಟ್.
You are right.
Let's even there was one more clarification issue which is available at page 73 minutes.
Page 73
son. 73. 53 clarification number 53.
Page 53.
How? Queries on the left-hand segments at the bottom. If for promotion on regular basis, employee has to possess a higher additional qualification, will it be necessary to insist on possession of these qualifications even while considering grant of financial accreditation under the ACP? Answer is at the right side. In terms of condition.
What it says?
Even in case of regular basis, if an employee has to be promoted, whether he should possess higher educational, higher additional qualification ಏನಾದರೂ ಬೇಕಾಗತ್ತಾ ಹೇಗೆ ಅಂತೇಳಿ ಅದಕ್ಕೆ ಆನ್ಸರ್ ರೈಟ್ ಸೈಡ್. ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ಕಂಡೀಷನ್ 6 of Annexure 1 to DOPTOM dated so on. So only those employees who fulfill all promotion norms are eligible to be considered for benefit under ACPs. Therefore, various stipulations and conditions specified in recruitment rules for promotion to the next higher grade, including higher/additional educational qualification, if prescribed, would need to be met even for consideration under ACP. Idರಲ್ಲಿ what I want to stress is, my lords, after 4 lines, therefore various stipulation and conditions specified in the recruitment rules for promotion to the next higher grade. So ಇಲ್ಲಿ recruitment ಗೆ special condition is MES examination pass ಆಗ್ಬೇಕು ಅಂತೇಳಿ. So ಇವರು ಯಾವಾಗ MES examination pass ಆಗ್ತಾರೋ contention of the department is when he passes this MES examination as per the ACP, he is entitled by erroneously we had given an
earlier date pre-passing period.
ಮತ್ತೆ ಆಮೇಲೆ ಮತ್ತೆ postpone ಮಾಡಿದ್ರಿ. There was a lot of confusion. We have done it for all the we said when he has passed this, he is entitled from that period ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ರಿ. That was challenge. And the other contention is, if he gets on 2003, from there 10 years, he will get MACP, one more financial accreditation. Unless this first date is clear, my lords. Second one follows the first one. If it is 2001, then 2011, it is 2003, 2013, whatever date, my lords. Main contention was this. My lords, the tribunal, my lords, the main issue which fell for consideration of the tribunal was whether passing of this particular examination is a requirement or because of some communication or letter which is there, whether that has been relaxed.
Relaxed ಅಂತ ತಗೊಂಡ್ರ?
Relaxed ಅಂತ ತಗೊಂಡ್ರ.
ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ?
ಒಂದು communication refer ಮಾಡ್ತಾರೆ. I'll point out that also. ಆ communication refer ಮಾಡಿ it has been done, my lords. Here, my lords, not only in respect of this person, even other 12 employees, totally 13 employees were there, my lords. Sir, ಅವರು ಹೇಳಿದ್ದು one of the person was there, my lords. Even in that list, which I can't dispute. ಯಾರೆಲ್ಲರಿಗೂ ಮಾಡಿದ್ರಿ ಒಂದು 13 ಜನಕ್ಕೆ ಮಾಡಿದ್ರಿ. ಅದರಲ್ಲಿ ಒಬ್ರು the person which sir has referred, even they are there, my lords. To that, my lords, my only contention is there nothing was decided. This tribunal's order was referred and said that this order is passed by this Bangalore bench in such a case. we are following it, the entitled for that relief, what is granted ಅಂತ ಹೇಳಿ ಆಯ್ತು. ಅಲ್ಲಿ ಏನಂತಂದ್ರೆ whatever the pensionary benefits which was there to that person to be paid was paid, noting that it matter is closed. ಇಲ್ಲೂ pensionary benefit ನಾವೇನು ಇಟ್ಕೊಂಡಿಲ್ಲ, ಕೊಟ್ಟಿದ್ದೀರಿ. ಅದರಲ್ಲಿ my lords, I am told that out of the whatever the amounts, even pension is paid, it has been issued, my lords, in the year 2016 itself. But my lords, as per the rules, my lords, they have retained 10%, that is 1,05,000, itkondiddare 1,50,000, 350, which is required when they are settling, my lords, they have withheld. But whatever pensionary benefits, whatever other things has been paid,
That has been released already.
ಎಲ್ಲ release ಮಾಡಿದೆ, he is getting pension also. My lords, now what happens is, if it is-
Essentially, the case relates to recovery.
ಯಾವುದು ಅಲ್ಲಲ್ಲ, ಅದು recovery is second, my lords.
It is
Whether it is,
secondary.
it will be secondary, my lords. Whether we are entitled for recovery or he is at fault or it's our mistake, that's a secondary aspect, my lords. ಮಾಡ್ಬೋದು, ಇಲ್ಲ, that my lords may kindly. But what happens, what should be the date? ನಮ್ಗೆ ಯಾವ ಡೇಟ್ ಇಂದ
ಎಂಟೈಟಲ್ಮೆಂಟ್ ಗೆ ಯಾವ್ದು ಡೇಟ್ ಅಂತ?
ಹೌದು,
ನೀವು ಅನ್ನೋದು 36/2003 ಅಂತ ನೀವು ತಗೊಳ್ತಾ
ನಮ್
ಇದ್ದೀರಿ.
ಪ್ರಕಾರ ದಟ್ಸ್ ದಿ ಡೇಟ್.
ಅದಕ್ಕೆ ಕೇಳಿದೆ, ರಿಲ್ಯಾಕ್ಸ್ ಆಗಿದ್ದ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್?
Page 32, my lords, may be seen for a moment. I'll point
32.
out.
32.
ಹೌದು, 32 ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್. Para 13, my lords.
No, not tribunal, sir. Tribunal has been, you have put it into challenge now.
ಅಲ್ಲಲ್ಲ,
On
ಅದು
what basis tribunal comes to the conclusion?
ಅದೇ ಅದನ್ನು ಪಾಯಿಂಟ್
The
ಔಟ್
relaxation.
ಅದು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿ ತಮ್ಗೆ ಯಾವ್ದು ಅಲ್ಲಿ ಕಮ್ಯುನಿಕೇಶನ್ ಇದೆ ಅದು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ತೀರಿ, ಸೊ ದಟ್ ಇಟ್ ವಿಲ್ ಬಿ ಕ್ಲಿಯರ್. Para 13, my lords, after 5 lines, the only issue, my lords, got
1-3 ನಾ?
ಹೌದು, ಅಲ್ಲ 32,
32.
ಪೇಜ್ 32, ಪ್ಯಾರಾ 13.
We are swayed away by the beauty of your presentation and accuracy of the statement of facts.
Efforts will be made, my lords. Ultimately, it's a senior, what he is pointing out may prevail, but I have to point out, my lords. 32, para 13, son.
32.
ಹೌದು, page 32, para 13.
32.
ಟ್ರಿಬ್ಯುನಲ್ದು ಇಂಟರ್ನಲ್ page 7.
You are right.
ಸೊ ಅದರಲ್ಲಿ ಒಂದು 4 ಲೈನ್ ಆದ್ಮೇಲೆ ದಿ ಓನ್ಲಿ ಇಶ್ಯೂ, my lords, got the only issue that has to be considered in the present OA is whether the passing of MES procedure exam is an essential ingredient for getting financial accreditation under ACP, so and so, especially
in the context of OM dated 14/3/2007.
ಇದು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ತೀನಿ. ಸೊ ಇಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ ಐ ವಿಲ್ ಜಸ್ಟ್ ಸ್ಕಿಪ್, my lords, because it whatever the RR it is there which is there, my lords. ಇಲ್ಲ ಅಂತಂದ್ರೆ ಇಂಜಿನಿಯರಿಂಗ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇರಬೇಕು. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ ತಾವು ನೋಡಿದ್ರೆ ಪ್ಯಾರಾ 15, the ACP scheme has been introduced by the Government of India following the 5th Pay Commission recommendation, which was adopted by the respondent department in respect of so and so. So, by the order dated so, in place of existing time-bound pay scheme, the condition of grant of benefit under, let's here only one thing I want to stress out, they have replaced the earlier time-bound promotion scheme. After that, the condition of grant of benefit under ACP scheme specified that financial accreditation shall be granted subject to fulfillment of prescribed condition. This, according to the respondent, stipulates passing of departmental examination and meeting the prescribed benchmark. The memo dated so and so. This, they refer to this memo. This memo is available at page 109. This was the memo on based on which tribunal comes to a conclusion that there is some relaxation. That one and the other communication.
Let's read para 2.
Please. The case for grant of second ACP to diploma holders, junior engineer in MEC who have completed 24 years of service between 9th August 1999 to 10th July 2004 was under consideration of the so-and-so, has cleared the case keeping in view of specific anomalous situation. Education qualification in RRs have been relaxed by them only for ACP purpose. No relaxation in educational qualification in any
ACP relax ಮಾಡಿದ್ರು.
ಹೌದು, ACP ಮಾತ್ರ ಮಾಡಿ.
Not for promotion.
ಹೌದು, for actual promotion. Not considered for actual promotion.
Promotion, it will remain intact.
How?
For grant of benefit under the scheme, it is relaxed.
Relax,
Operation
one
for-
relaxation.
Well, do you
Andre,
dispute
idರಲ್ಲಿ
this?
What happens is, what is relaxed is educational qualification. If it was engineering, that is relaxed. Diploma holder can come. Andre education matra, not the passing of departmental examination, which I want to stress. What relaxation is made?
Not
as-
departmental, educational qualification is not departmental qualification. It is only that arises after gaining entry to the service. Therefore, it is not, the educational qualification ಏನು ಅಂತ ಎಲ್ಲರ ಹೇಳಿದಾರ?
ಅದು ಇದೆ.
It cannot be. Brother.
ಅಲ್ಲಲ್ಲ ಇದರಲ್ಲಿ
It cannot be because without that qualification, he would not gain entry to the department itself.
ಮೊದಲು ಡಿಪ್ಲೊಮಾ
No, it
ಹೋಲ್ಡರ್
must be this MES exam ಏನ ಹೇಳಿದ್ರಲ್ಲ, ಅದೇ ಅದು. Otherwise, the question of relaxation of entry level qualification will not arise at all. It will not be. He cannot gain entry at all. Therefore, the text of this OM, we cannot interpret it as the statute of Westminster Abbey in England. It is only some level officer has issued this.
things which is issued.
Obviously, it refers to that the JE civil examination. It cannot
MES
be anything
examination
else.
ಬೇಕು ಅಂತ ಹೇಳಿ.
ಹೌದು.
ನಾವು ಹೇಳ್ತದ.
Because assume for a moment, if your contention is accepted, then we are entering the dreaded field of recruitment process itself. You will be relaxing the qualification prescribed by the employer for gaining entry to the fray of recruitment.
Graduates had entered and by some means, some diploma holder had entered, then this would have opened the gate for them.
Correct.
ಅಲ್ಲಿ ಆ
ಅಷ್ಟೇ case.
ಅಲ್ಲಲ್ಲ ಆ ಪ್ರಮೋಷನ್ ಏನ್ ಕ್ರೈಟೀರಿಯಾ ಕೊಟ್ಟಿದ್ರು ಅಂದ್ರೆ ಸೂಪರ್ಡೆಂಟ್ ಗ್ರೇಡ್ 1 with 3 years of regular service in the grade in case of degree holders in civil engineering and 7 years in regular service diploma holders ಮಾತ್ರ MES ಪಾಸ್ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅದು ಅವಶ್ಯಕತೆ
Promotion
ಇಲ್ಲ
not-
ಅಂತ ಹೇಳಿ.
ಇದ್ರಲ್ಲಿ ಅವಶ್ಯಕತೆ ಅಂದ್ರೆ ಟ್ರಿಬ್ಯುನಲ್
ಇದನ್ನ ಯಾರು ಇಶ್ಯೂ ಮಾಡಿದ್ರು?
ಇದು ಇಟ್ ಇಸ್ issued by the department.
Department itself.
ಹೌದು 109.
So you don't disown that.
ಇಲ್ಲ sir, I can't.
This is intended to benefit a class of employees. Then
It is
where is the
issued.
case for you?
Our contention is, my lords, it includes even departmental examination. It couldn't have been the thing because engineers, persons who were holding degree qualification, my lords, it was applicable to them. Not this department examination was relaxed, was the contention, my lords.
But even English is very plain. It only reminds me of Wren and Martin's grammar book. It is very plain. Where is the scope for interpretation?
ಇರೋದು ಅದೊಂದೇ. That's the only contention because tribunal, after referring to this at para 17, if my lord says,
ಏನಿಲ್ಲ.
it comes to a conclusion.
But we appreciate the way with the hearing, your argument was more like walking on the bank of Nile River, very slowly. It was,
I had to make an
there
attempt,
was
my lords.
no, ಶಾಂತವಾಗಿ ಹರಿತಾ ಇತ್ತು ನಿಮ್ಮ ವಾದದ ವಾಗ್ಝರಿ.
Let's make, now may I request my lords to see the papers which senior has.
Yes, rest of the
ಅಲ್ಲ
things
ಅಷ್ಟೇ
will
ಇರೋದು.
vary
ಅಲ್ಲ
between
ನಾನು ಏನಂತಂದ್ರೆ ಮೇ ಬಿ this will be decided or this the order which is against us, my lords, has to be
That's right.
followed.
We appreciate you.
Only to point out that this matter, when it is pending, my lords, it has not reached finality. It was referred and said that it's covered and ಹೇಳಿ ಆಮೇಲೆ next because pensionary benefits are paid, for that reason it is closed. But this issue,
But it matter. ಇಲ್ಲ, now we will decide it. That will be feeding the grant by estoppel in transfer of property at time. And that becomes valid by virtue of our reasoning now.
now my lords gives the reason, there it ends, my lords. And the other thing is, my lords may hold that whatever date he is entitled for this particular ACP, from there 10 years he is entitled for whatever next financial upgradation.
Ultimately, the pith and substance of the case is the interpretation of this memo. If this memo has relaxed the requirement, then you cannot classify them on the basis of when they passed the examination.
The other thing
that will go.
Other thing would be, my lords, just
Lots by a communication or the letter, my lords, could they have relaxed whatever was available in the scheme, which clearly stipulated, and even DOPT clarifications were issued that it is a requirement.
Who is the author of this scheme?
Scheme is the DOPT.
Who is the author of this letter?
Letter is department, my lords. It's a
That's the-
department.
That answers 56 Supreme Court. That will be the answer.
I'll leave to my lords.
Perfect. Petition is dismissed. Agreeing with the reasoning of the CAT at internal page 8, running page 33, which quotes the memo dated 14/3/2007, wherein para 2 provides for relaxation of passing of the examination, departmental examination, MES examination.
MES.
Examination. First, the vehement submission of learned counsel, learned CGC appearing for the petitioners, that the term inverts null, educational qualification inverts complete, employed in para 2 of the memo means the qualifying examination for the appointment of the posts in question,
Promotion.
by way of promotion, is bit difficult to countenance. In as much as the last 2 lines in the very paragraph would exclude that interpretation. First, for the purpose of promotion, the prescribed requirement would obtain as it is, wide page, running page 41, correct?
Serial 11.
Item 11. However, for the purpose of availing of benefit under the scheme, this relaxation has been consciously granted. First, all the above being said, we shall be failing in our duty if we do not place on record our profuse appreciation for the learned CGC's beautiful and articulate submission of the case. Yes. First, dismissed.
Much.
Ready. The registry shall share a copy of this judgment free of cost with the learned CGC.
Much.
Need not wait.
ಮಧ್ಯಾಹ್ನ ಇದೆಯಲ್ವಾ ಸರ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಲ್ಲ
2:30 ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ವೆಯ್ಟ್ ಮಾಡ್ತೇವೆ, ವೆಯ್ಟ್ ಮಾಡೋಣ. ಬಿ ಗ್ರೂಪ್ ವೆಯ್ಟ್ ಮಾಡ್ತೀವಲ್ಲ, ವೆಯ್ಟ್ ಮಾಡ್ಬೋದಲ್ಲ?
ಮಧ್ಯಾಹ್ನ ಇದೆಯಲ್ಲ, ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ.
ಸರ್ ಪಾಸ್ವರ್ಡ್ ಒಂದೇ ಒಂದು ಪಾಸ್ವರ್ಡ್. ಬಿ ಗ್ರೂಪ್ ವೆಯ್ಟ್ ಮಾಡ್ಬೋದಲ್ಲ, ವೆಯ್ಟ್ ಮಾಡ್ಬೋದಲ್ಲ? ಅಲ್ಲ ಇಲ್ಲಿ ಇಲ್ಲಾಂದ್ರೆ ಡೇಟ್ ಕೊಡ್ತೀರಲ್ಲ? ಅಲ್ಲ ಕವರ್ಡ್ ಬೈ ಡಿಸಿಷನ್ ಅಂತ ಕೇಳ್ತೀವಿ. ಸರಿ ಸರ್. ಸರ್ ಆಮೇಲೆ ಗೊತ್ತಾಯ್ತು.
Court officer. Court officer. Court officer. Court officer. B group. Hello. Court officer. Court officer. Court officer. B group ತಗೊಳ್ತಾರಲ್ಲ?
ತಗೊಂತಾರೆ ಮೇಡಮ್, 230 ಮ್ಯಾಟರ್ ಅರ್ಜೆಂಟ್ ಅದೇ ತಗೊಂತಾರೆ.
ಸರಿ, ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
ಹೇಳ್ತಾ ಇದ್ದೀನಿ, 230 ಮ್ಯಾಟರ್ ಅರ್ಜೆಂಟ್ ಅದೇ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಹಾಗೆ.
ಅಲ್ಲಲ್ಲ ಅಲ್ಲ ಪಾರ್ಟೆಡ್ ಅಡ್ಜಸ್ಟ್ ಆಗೋ ಚಾನ್ಸಸ್ ಇದೆಯಾ? ಇಲ್ಲ ಬರ್ಲಿಲ್ಲ.
Wow. ಇಡ್ಲಿ ಅಂತ ಬರೋಣ ಹ್ಮ್ Thank you. Tomato.
Here.
ಇಲ್ಲಿ ಬೇಲಿಲ್ಲಲ್ಲ ಎಲ್ಲಿ ಬೇಲಿಲ್ಲ ಇಲ್ಲಿ ಇಲ್ಲಿ ಬೇಗ ಎಲ್ಲ ಸಿಟಿ ಬ್ಯಾಂಗ್ಳೂರ್ ಸಿಟಿ ಬ್ಯಾಂಗ್ಳೂರ್ ಸಿಟಿ ಇದು ಮನೆ ಫುಲ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಸಿಟಿ ಓಲ್ಡ್ ನೀಡ ಮನೆ ಬ್ಯಾಂಗ್ಳೂರ್ ಸಿಟಿ ಓಲ್ಡ್ where you forgot everything in between, so this confusion. In 1954 ಮನೆ ಕಳದಾಡ ಮನೆ ಬಿಟ್ಕೊಂಡಿ ಮಂಗಲಾಯ್ತು ಬ್ಯಾಂಗ್ಳೂರ್ ಬನ್ನಿ ಬ್ಯಾಂಗ್ಳೂರ 1954 January. Mangalacha? Mangalacha, no? Okay. Yep. Okay. ಮನೆಯಲ್ಲಿ ಹೋಗ್ಬೋಯ್ತು ಜ್ಯೂಸಿ ಮನೆ ಉಂಟು ಹೋಟೆಲ್ ಉಂಟು ಮಾರಿ ಹೋಗಿ ಹೋಟೆಲ್ ಉಂಟು Done. Okay, మీరు tenure నాలుగు ఇస్తుంది. പുതിയ നമ്പർ എന്താ ബാക്ക് പേജ് sweet potato sweet potato tomato അവിടെ മഞ്ഞയില്ല വാക്കിംഗ് സ്റ്റിക്സ് కూర్చోండి మీకు వాకర్ అర్థంగా చర్చ్కి వెళ్ళిపోతాం చర్చ్ పోతాం చర్చ్ వాకింగ్ వాకర్ ಅವನಲ್ಲಿ ಒಳ್ಳೆ ಮನೇಲಿ sweet potato Court entala. Court. Court judge in term. ಈ ಒಳ್ಳೇದು ನೀನು ಒಂದು ನೋಟನ ಫೋನ್ ಹಿಡ್ದತಿ ಅನ್ನೋದು ಫೋನ್ ಹಿಡ್ಕೊಂಡವ್ರು ಕೋಟ್ರ ಒಳ್ಳೆ ಫೋನ್ ಹಿಡ್ಕೊಂಡಿಲ್ಲ. ಇಲ್ಲ
ಆಡಿಯೋ ಅದು ಕಂಪ್ಯೂಟರ್ ಮೇನ್ ಸೆಂಟರ್ ಕೇಳ್ಬೇಕು ಸರ್. ನಾವಿಲ್ಲಿ ಯಾವಾಗ ಯೂಟ್ಯೂಬ್ ಆನ್ ಆಗಿರುತ್ತೆ ಟೆಕ್ನಿಕಲ್ ಇದಾಯ್ತು ಅಂತ ಅಲ್ಲಿ ಬರುತ್ತೆ. ನಾವು ಇದ್ರಲ್ಲಿ ಕೊಟ್ರೆ ಬರ್ತದೆ. ನಾವು ಕನೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರೆ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಕೊಟ್ಟಿದ್ರೆ ಬರುತ್ತೆ. ಇಲ್ಲ ಮಾಡಿಲ್ಲ. ಆ ಫೋಟೋಸ್ ಬಿಟ್ಟಿದ್ದು ಅಷ್ಟೇ. ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನಲ್ಲಿ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಅದು ಅರ್ಜೆಂಟ್ ಆದ್ರೆ IA1 IA2 ಫಾರ್ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ. ಮಾಮೂಲಿ ಸೂತಟ್ಟಿ ಮೇಲೆ ಕೀಬೋರ್ಡ್
ಹೌದು 6 ಅಲ್ಲಿ ಇದೆ.
ಏನಿಲ್ಲ R6 ಟೆನೆಂಟ್ ಸೊ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳ್ಬೋದು ನೋಟಿಸ್ ಮೆಮೊ ಇಲ್ಲ. ಈ ಕಾಲ್ ಬಂತು, ನಾನು ಫೈಲ್ ಮಾಡಿ ನಾನು ತಂದ್ಕೊಡ್ತೀನಿ. ನಂಗೂ ಹೇಳಿದ್ರ ಸಾಹೇಬ್.
ಇಟ್ಟಿರಿ ಟೇಬಲ್ ಮೇಲೆ. ಕಳಿಸಿ ಯಾವತ್ತು ಓಕೆ ಟೇಬಲ್ ಮೇಲೆ ಇಡಿ.
ಸತೀಶ್ ಗೊತ್ತಾಗ್ತದೆ. ಸತೀಶ್ ಅಡ್ವೊಕೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಈ ಸತೀಶ್ ಬರ್ತಾರಲ್ಲ ಅವನೇ
ಸರ್ ನೆಕ್ಸ್ಟ್ ನಂಬರ್ ನಂದಿದೆ 29 ಕರೀತಾರ ಅದು ಕರೀಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಡೇಟ್ ಅನ್ನು ಕೊಟ್ಬಿಟ್ರೆ ಹೋಗ್ಬಿಡ್ತೀವಿ.
ನಾನು CRT ತಲೆನೇ ಕಸ್ಕೊಂಡಿದ್ದೆ, ನನಗೆ ಪ್ರಮೋಷನ್ ಬೇಡ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ಬರ್ಕೊಡ್ತೀನಿ, ಅದು ಬಂದಾಗ ಬರ್ಕೊಡ್ತೀನಿ. ಬರ್ಲಿ ಬಿಡಿ, ಅದು ಬಂದಾಗ ಬರ್ಕೊಡ್ತೀನಿ. ಕೇಳಿ ಅವತ್ತೇ ಅಲ್ಲಿ ಹೋಗಿ ಧಾರವಾಡಕ್ಕೆ ಹೋಗೋದು, ಕಲ್ಬುರ್ಗಿ ಕಳಿಸ್ತಾರೆ, ಆಮೇಲೆ ಒಂದು 5 ಬ್ರಾಂಚ್ ಕೊಡ್ತಾರೆ. ಇಲ್ಲಾಂದ್ರೆ ಹೆಚ್ಚು ಕಡಿಮೆ ಆದ್ರೆ ಯಾರು ಕರೀರಿ ಅಂತ ನಾವು ಉಳಿಸ್ಕೊಬೇಕು. ನಾನದೆಲ್ಲ ಒಳ್ಳೇದಕ್ಕೆ ಅಂತಾರಲ್ಲ, ನಂಗೆ ಇಷ್ಟ ಇರಲಿಲ್ಲ. ವಿಜಿಲೆನ್ಸ್ ಬ್ರಾಂಚ್ ಹೋಗ್ಬೇಕಾದ್ರೆ ಬೇಡ ಯಾರು ಒಬ್ಬ ನಮ್ಮ ಬುದ್ಧಿ ತಗೊಂಡ್ ಬಂದಿದ್ದೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಒಂದು ಕ್ಲೀನ್ ಶೀಟ್ ಕೊಡಿ ಮೆಮೊ ಬರೀ.
ಒಂದು ಗ್ರೀನ್ ಶೀಟ್ ಕೊಡಿ. ಒಮ್ಮೆಲೆ ಗೊತ್ತಾಗಲ್ಲ. ಇಲ್ವಲ್ಲ
ಇನ್ಸ್ಪೆಕ್ಷನ್ಸ್ ಆಗತ್ತಲ್ಲ.
ನಾನು ಹೇಳಿಲ್ವ ಸರ್, ಭಾಗ್ಯಲಕ್ಷ್ಮಿ ಕೂಡ
Three years cadre, they have not served in the feeder cadre.
ಅದ್ರ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀವಿ. ನಾವು
ಬೇರೆಯವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಏನೋ ಹಾಕಿದ್ದೀರಾ, but I have to take instructions from them.
ಬಂದ್ರ
With your lordship kind permission, sorry, senior was waiting. He left for Gulbarga. 39 may kindly be had on Friday, my lord, 15th. Or Monday, my lord.
ಫಿಕ್ಸ್ ಆಗಿರ್ತಾವಲ್ಲ, ನೋಡ್ಕೊಂಡು ಯಾವ್ದು ಒಂದು ಡೇಟ್ ಕೊಡಿ. 2 weeks. 2 weeks ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ, ಸೊ ದಟ್ ಸೀನಿಯರ್ ಕ್ಯಾನ್ ಕಮ್ ಅಂಡ್
Date may be.
ಆಯ್ತು.
No, my lord, not 28. Let it be before 17th. He is leaving for Australia.
ನೆಕ್ಸ್ಟ್ ನೆಕ್ಸ್ಟ್
Then let it be there, my lord.
ಡೋಂಟ್ ವೇಸ್ಟ್ ಅವರ್ ಥಿಂಕ್ ಮಾಡಿ ಹೇಳಿರ್ತೀವಿ, ಬಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಬಾರ್ದು. ಎಸ್, ನೆಕ್ಸ್ಟ್
Outdoor matter, number 3.
And for the appellant's counsel, my lords.
For the respondent.
My lords, respondent number 6 was indeed a tenant, my lords.
Tenant.
Yes.
Then why it's not a necessary party
Not
for
a
partition at all?
Please, my lords, this notice to respondent number 6 may kindly be dispensed with, my lords.
Notice to respond number 6 is dispensed with. And further, the appellant is directed to delete the respondent number 6 from the array of parties, comma, he admittedly being only a tenant of the premises in question. Okay.
Lord, we have
But
filed,
date, my,
If your lords permit.
Lord, we have filed earlier in application, my lord.
ಯಾವಾಗ ಬೇಕು? 2015 matter.
matter.
We'll have it in last week of January. 13 ನಡೆದಿದೆ ಈಗ. Senior advocate, Mr. Shankar is sitting behind you, na?
Last week of January.
Last week of January. I disposed of.
Lords permit, I'll do the corrections now.
Yes, my,
Please, thank you.
but ಮೂರು ಗಂಟೆ ತನಕ ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ, 3 ಗಂಟೆಗೆ ಸ್ಟಾರ್ಟ್ ಮಾಡೋಣ. ಸರ್ 3 ಗಂಟೆಗೆ ಬನ್ನಿ. ಮಹಾಲಯ ಅಂಡ್ ಶಂಕರ್ ಸರ್. Yes.
For 28, Shanti Bhushan, M. Babu Rao.
For the petition, kindly pass over the matters, my lord. Seal number 28.
Serial number
28.
8. 2018 matter. They are doing submittal on time.
Date may be
And date what?
27th.
27.
Interim order, maybe.
Huh?
Interim order.
Entry order idea? Entry order to continue till then. Entry order, if any, will continue till then. Yes.
29, D. Baswaraja.
Present, my lord.
Yes, Mr. Basuraja.
My lordship, this is a prayer for the.
ಯಾರು ನಿಮ್ friend?
Respondent, sir.
My lordship, 2 times notice served, but he is not appearing. He is not interested in the case.
Not interested in the case. End point.
MACP, my lordship, about MACP, grant of MACP. Already we have given a 3 MACPs, passing the limited competent examination as a promotion as per the recruitment rules. But he is claiming that passing the examination, department examination is a initial entry, he should be granted with 1 more promotion. That is not permissible, madam. As per the rules, every central government employee has to get the 3 promotions or 3 upgradations. We have already given. My lordship, on 11083, he has initially appointed as a group D in the post, in the Department of Post. After that, he passed the examination, postman, he has promoted as a postman. That is one of the upgradation or MACP. Secondly, he is also promoted the limited.
See that order of Dinesh Sharma, learned member of, administrative member of the tribunal.
Yes, my lordship.
At Bangalore, he refers to Jodhpur bench judgment and Madras bench judgment.
Yes, my lordship. My lordship, after that, there is some developments are there. Kindly see the judgments of this coordinated bench at appendix at annexure D and E.
ನೋಡೋಣ ಸ್ವಲ್ಪ ಓದ್ಕೊಂಡ್ ಬರ್ತೇವೆ ನಾವು ಇದು ಗೊತ್ತು ನಮಗೆ ಸಿಗಲಿಲ್ಲ ಇದು.
D and E, annexure D and E, my lord.
ನೋಡೋಣ ಸ್ವಲ್ಪ we'll read it and come back on 27th.
Thereafter, my lordship.
As affirmed in matter went in SLP is also dismissed. MACP, this floodgates of litigation. Where is that judgment in SLP 4848 of 2016?
It is not here.
Nodi, already there is a order by the coordinate bench.
My lordship, I will tell you, my lordship, there are some developments after that. Actually, before the Supreme Court and also before the Jodhpur bench, They have not produced this one, recruitment rules.
All right, you give that judgment of the apex court. Copy kodi, SLP 4848 of 2016. Call this matter on 27th. You have to comply, madam. Idea?
Illa, my lordship.
Counsel for the petitioners to furnish a set of 2 copies of the apex court judgment in SLP 4848 of 2016, decided on 16/8/2016. Unproduced, my.
Agree, my lordship. Date, my lordship.
27th?
Oblige, my lordship.
Yes.
The group matters, number 30, Sarojini Muthanna. Madam Sarojini Muthanna.
Yeah, your lordships,
Yes.
in this case, I have suffered a order from CAT.
Cat and dogs.
Your lordships, they have sought for a basic pay of 7,440 on par with the second respondent on the basis of equal pay for equal.
Venkatesh Kumar for respondent number 1.
Madam, your friend is not present. We will post it on 27th.
Right, Your Lord.
Call on 27th for respondents counsel to come and argue.
27th of this month, your lordships.
Whichever date you want. Even
Yes,
December is
Yeah.
all right for us.
Lordships, this is fine.
Yes, fine, okay.
Yes.
Number 31, Raghupati.
For petitioner in this case. But the petitioner is denied his promotion as per the petitioner is initially is appointed as a FDA. His promotion for superintendent has kept under seat cover because of some disciplinary inquiry. The disciplinary inquiry ended with censure. Though it is a censure, his promotion as seat cover has not kept it open. Approach the tribunal has directed the authority by set aside the censure order, give promotion from the date of his junior or promoted. His promotion is given with retrospective effect. But at the time of promotion to the next cadre, the respondent has denied that you are not worked in the 3 years of in the cadre of superintendent, so thereby you are not eligible.
What is the requirement of rule?
The requirement of rules for a period of 1 month, 3 years. If not available, 1 year is sufficient.
If candidate is not available.
If not, but if he is eligible, my lord. Moreover, is that, my lord, the tribunal has set aside my penalty order and directed to consider my promotion with from the date of my junior. So promotion is given with retrospective from the date of my junior. Then I am entitled for all consequential benefit. That is the legal proposition of this proposition. Moreover, my lord, the other person, the respondent authority is given a promotion. So within the same period, my lord, I produced the document, my lord. 2 documents, my lord.
When you come to page 28, para 8.
Tribunal order, my lord.
Yes.
Even if you consider the case of the applicant for including the select list 2/12/2020 on merit, the unmissable fact would be that the applicant had not completed 3 years of service as on the date of DPC on 2/12/2020. That would not eligible to him to promotion to the assistant secretary grade. Thereby, in any case, the promotion order based on the selection list 2/12/2020 has not at all been challenged at all the this application, apart from the fact that the applicant is stopped from the agitating this plea in this application, the prayer of the inclusion is the select list. 2/12/2020 would therefore be untenable to the material.
Tribunal says 3 years. Where is the 1 year you said now?
That for the CN rules page number A21, relevant is my lord 135, my lord.
135.
Please, my lord. Seal number 12, my lord. Assistant Secretary or Headquarters Secretary, my lord.
Assistant
Secretary.
Secretary, Headquarters Assistant to Regional Transport Officer, so and so, so and so. By promotion in the cadre of superintendent, must have put in service of not less than 3 years in the cadre of
Superintendent.
superintendent. If an officer with 3 years of service is not available, an officer who has put in a service of not less than
3
1 year in the cadre of superintendent may be considered for
promotion.
promotion.
But in other aspect, my lord, I produced that list of production of document. In this case, my lord, one person is a senior motor vehicle inspector is facing some departmental inquiry. Based that his promotion is kept under sealed cover for assistant regional transport officer. So his promotion is given on 17/6/2023 to for regional transport officer. Thereafter, madam, within 1 year on 1/20/2022 has given promotion to the RTO officer. My lord, my production of document is that, my lord. That annexure E.
Annexure E.
Please, my lord. That is 17/6/2023. It is promotion from the cadre of the senior motor inspector to the assistant regional transport officer, my lord. The page number 5 is third para is stated is clearly, my lord. Page number 5 ನಲ್ಲಿ third para. ಆದ್ದರಿಂದ ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹಾಗೂ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಅಂತಿಮ ತೀರ್ಪುಗಳಂತೆ ಶ್ರೀನಿವಾಸಪ್ಪ ಹಿರಿಯ ಮೋಟಾರ್ ವಾಹನ ನಿರೀಕ್ಷಕರು ಪ್ರಾದೇಶಿಕ ಸಾರಿಗೆ ಅಧಿಕಾರಿಗಳ ಕಚೇರಿ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ಸೋನ್ಸೋರ್ ಇವರ ಮುಂಬಡ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ
Lord,
Where the
3 years.
tribunal has considered the other provision?
Lord, in so far as this 17/6/23 order is concerned, my lord, what they have placed. Subsequent to this, they have again given representation, my lord.
What will happen? You will quote this order and send him home. Why you did not tell to the tribunal saying there is a provision which provides for consideration of a candidate who has put in less than 3 year service provided he has completed 1 year service. ಈ ಎಲ್ಲ ಕೇಸ್ ಜಾಸ್ತಿ ಆಗೋದೆಲ್ಲ substandard advocacy ಇಂದ. Most of these cases arise because of substandard advocacy. Why you did not tell the tribunal? When tribunal said 3 years, you should have said, sir, it is not like that. Even 1 year candidate also can be considered under the rule. Therefore, and you may say reason why he will not fit into 1 year also. That's another thing.
Yes.
You have misled the tribunal. When tribunal was giving, whether dictation was given in the open court or in the chamber.
Reserved
judgment. Then we cannot find a fault with that. Very safe for us judges to reserve judgment and pass orders.
Moreover, my lord.
What do you say? You have granted 1 year promotion to other person. You have given that one?
I given that copy, my
Lord, they have not given complete.
Complete. Iಷ್ಟೇ order.
ಎರಡು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇಷ್ಟೇ ನಿಮ್ಗೊಂದು ಕಾಪಿ ಕೊಟ್ಟ
annexure E and E ಬಂದಿದೆ. Subsequently within
1 year ಅಂತ ಆಗಿದೆ. ಬೇರೆ ನೀವು ಕೊಟ್ಟಿದ್ದೀರಿ.
I
Number 1.
understand.
Whether censure is a penalty?
Penalty ಆಗಲ್ಲ because the during
there are the rules. ಏನಾರ ಒಂದು ಉತ್ತರ ಕೊಡಬಾರ್ದು. Censure is held to be penalty by division bench. Warning is not.
Censure
is a penalty.
Under rule 8(1), my lord. Censure is penalty.
Is a penalty.
Will come into your an end the day it is administered.
That's all. So it leaves only for 1 day.
Censure if order is passed today.
It comes in the evening, it comes to an end. So that also is over now. That cannot be a hurdle for promotion at all. A civil servant disappointed by the state administrative tribunal's order dated is invoking the writ jurisdiction of this court against denial of relief to him, relief of promotion to him. First, learned counsel for the petitioner drawing attention of paragraph, order the paragraph 8 of the tribunal's order argues that there is a legal infirmity in the order, of great magnitude, in as much as the extent 2013 rules specifically provide for consideration of a candidate for promotion to higher cadre, next higher cadre, if he has put in not less than 1 year service in the feeder cadre, provided candidates who have put in 3 years of service do not avail. First off. So contending, so arguing, he seeks allowing of the petition. He has also produced, along with a memo with leave of the court, the OM dated 17/6/2023 relating to one Mr. Srinivasappa B, who has been directed to be considered for promotion to the post of
Assistant Transporter.
ARTO, though he has put in only 1 year service. He has put in less than 3 year service in the feeder cadre.
You corrected it, my lord. On 17/6/2023, promotion to the ARTO because of his promotion is kept under the departmental inquiry is pending. Thereafter, my lord, the ARTO. Subsequently, my lord, on 2022.
First off, he points out to order dated 6/4/24, dated by which he has been promoted.
Promotion
First
is
one
given on-
17/6/2023, my lord.
17. Correct.
Next, annexure, please, my lord.
They may not be. ಅಲ್ಲಿಂದ ಮುಂದೆ ಹೋಗ್ಬಿಟ್ಟು. First, next paragraph. Learned AGA appearing for the respondent opposes the petition, making submission in justification of the reasoning of the impugned order made by the tribunal. First, she also points out that the petitioner's case was put into sealed cover since he was facing a disciplinary inquiry, which eventually resulted into the penalty of censure. First, so contending, she seeks dismissal of the petition. Next, having heard the learned counsel for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter, in as much as the extant rule is as clear as Gangetic waters. First, it provides for a candidate who has put in less than 3 years of service, but not less than 1 year of service in the feeder cadre for consideration of his case for promotion to next higher cadre, namely ARTO. First, this aspect of the matter has been lost sight of by the tribunal. First off, when we asked learned AGA as to why that was not informed to the petition, the tribunal, she submits that the impugned order was was reserved in the case before the tribunal, it was reserved for orders after hearing, and the orders were pronounced later. First, be that as it may. Next paragraph. In sentence. True it is that the right to promotion as such is not recognized in the service jurisprudence, but right to have the candidature considered for promotion is recognized. Says Justice Rama Joyce in his Services under the State. Page ಎಲ್ಲ ಹಾಕೊಳ್ಬೇಕು. The consideration ought to have taken place keeping in view the requirement of 1 year minimum service in the feeder cadre, as rightly argued by counsel for the petitioner. That having not happened, he is more than justified in complaining before the writ court against the order of the tribunal. Next point. Counsel for the petitioner is justified in placing reliance on the government order dated 17/6/2023, whereby benefit has been accorded to one Mr. Srinivasappa, who was similarly circumstanced. And he has been given promotion as well, though he had not put in 3 years of service. First, we are told that by another order dated 6/4/24, which is that order by which further promotion is accorded to him?
20/2/2024, my lord.
We are told that by another order dated 20 February
In the respect of
2024,
discipline.
by notification dated, order with notification dated so and so, he has been accorded further promotion as well. First off, we are at loss to know why the petitioner has been meted with stepmotherly treatment. First off, state being constitutionally expected to be a model employer, wide Mudaliar versus so and so, cannot practice discrimination of the kind. Next paragraph. The submission of learned counsel for the learned AGA that the petitioner in the subject disciplinary proceeding has suffered a penalty order of censure, and maybe because of that, he was not considered for promotion, is a bit difficult to agree with. First off, ordinarily, censure, though is a recognized penalty under rule
8 subclass.
881,
8 subclass 1.
8 Satish Yadav. 8(1) of CCA rules, CCA rules 1957, would expire on the day it is administered. First off, no contra rule or ruling is brought to our notice to hold otherwise. First off, in the above circumstances, this petition succeeds. Second, the writ of certiorari issues quashing the impugned order of the tribunal. Second, petitioner's application number so and so having been favored, a writ of mandamus issues to yarge,
The second respondent.
first and second respondents to consider or cause to be considered petitioner's candidature for promotion to the post of ARTO. Post of
Assistant Secretary.
Assistant Secretary. Assistant Secretary. Within a period of Assistant Secretary and grant all consequential benefits within a period of
3 months.
3 months.
Please.
Why 3 months? He has already spent so many years there. 8 weeks.
As per the DPC dated 2/12/2020.
In terms of
DPC
DPC dated
2/12/2020.
2/12/2020
Annexure 8/12.
at annexure 812 to the petition. Within 3 months, 8 weeks ಅಂತ ಹಾಕಿ. Delay in non-compliance, if brooked, would be viewed very seriously. Okay. No, courts reluctantly made easy. Next. Let's see.
See number 48
Yes.
for further hearing, 230 matter.
39. ಏನದು 2024 ಮ್ಯಾಟರ್ ಸ್ಟೇ ಏನದು ವಿಶೇಷ ಹೇಳಿ 2 ನಿಮಿಷ ಸರ್ ಒಂದೆರಡು ನಿಮಿಷ ಏನೋ ಒಂದು ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ವಿ ಗಾಟ್ ಇಟ್ ಪೋಸ್ಟೆಡ್ ನಾ ಏನದು ಶ್ರೀಧರ್
In this case,
yes
the petitioner who is an employee of the
Before
health.
that, may I make a submission, my lords? I appear for respondent, my lords. They have challenged the interim audio, my lords. Tomorrow, the matter is listed before KAT, my lords, for final arguments, my lords. So,
tomorrow
my lords,
order will be issued.
my lords, it is listed for arguments, my lords.
See,
Please,
suppose if there is fault at the
Please.
hands of the tribunal in refusing interim relief,
please, my lords.
citizen is entitled to invoke jurisdiction.
My lord,
Yes.
I'm working as a professor and head of the department in nursing college. That post are meant to the health and family welfare department.
Huh?
Health and family welfare department.
Sentence full ಹೇಳಿ.
My lord, these posts are filled up by the health and family welfare department. Though they are coming under the medical education department. What happened, my lord, in the impugned order? Kindly see the annexure A10 at page number A9 may kindly be seen, my lord. What happened, my lord?
Page number ಹೇಳಿ.
ನನ್ನ ವರ್ಡ್ನಲ್ಲಿ ಹೇಳ್ತೇನೆ. The principal of
ಅಲ್ಲ A9 ಪೇಜ್ ಹೇಳಿ ಓದಿ ಬಿಡ್ತೇವೆ.
ಹೇಳ್ತೇನೆ ವಿಷಯ ಹೇಳ್ಬಿಟ್ಟು ತಮ್ಗೆ ಹೇಳ್ತೇನೆ.
ಹಾ.
Principal of the college, of this nursing college, was evaluating the answer paper of another university students through his PG students, my lord. This was complained by us, saying that you can't do it. Therefore, annexure A9 is the order passed directing A9, my lord, page number 45, typed copy.
ಆಯ್ತು ಅದು ಮತ್ತೆ ಹಿಂಗ್ ಮುಂದೆ ಇನ್ನೊಂದ್ಸರಿ ಹಿಂಗ್ ಆಗ್ದಂಗೆ ನೋಡ್ಕೋಬೇಕು ಧಕ್ಕೆ ಆಗ್ದಂಗೆ
ಅಲ್ಲ
ಮಾಡ್ಕೋಬೇಕು.
ರಿಪೋರ್ಟ್ ಬಂದಿದೆ,
ಹಾ.
ನೀವು ಅದನ್ನ ಇನ್ನೊಂದ್ಸರಿ ಹೀಗಾಗ್ದಂಗೆ ನಾವು ವಾರ್ನಿಂಗ್ ಕೊಟ್ರೆ ಸಾಕು ಅಂತ ಹೇಳಿದ್ರು
ಹೇಳಿ.
ಯಾರೋ ಡೈರೆಕ್ಟರ್.
ಹಾ.
Then annexure A10 is the impugned order. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧ ಉಲ್ಲೇಖಿತ ಏಕರ್ತದೆ ಡಾಕ್ಟರ್ ಜಯಲಕ್ಷ್ಮಿ ಪ್ರಾಂಶುಪಾಲರು ಸರ್ಕಾರಿ ಶಿಶು ಮಹಾವಿದ್ಯಾಲಯ ಇವರು ತಮ್ಮ ಅಧಿಕಾರವನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಳ್ಳುತ್ತಿರುವ ಹಾಗೂ ದೂರಾಚಾರ ಸ್ವೀಕೃತವಾದ ದೂರುಗಳ ಬಗ್ಗೆ ವಿಚಾರಣೆ ನಡೆಸಲು ವಿಚಾರಣಾ ಸಮಿತಿಯನ್ನು ರಚಿಸಿ ಸದರಿ ಸಮಿತಿ ನೀಡಿರುವ ವಿಚಾರಣಾ ವರದಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಕೆಳಕಂಡ ಮಾಹಿತಿ ಮತ್ತು ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. ಪ್ರಾಂಶುಪಾಲರು ನೀಡಿದ್ದ ಉತ್ತರ ಪತ್ರಗಳನ್ನು ವಿದ್ಯಾರ್ಥಿಗಳು ಮೌಲ್ಯಮಾಪನ ಮಾಡುತ್ತವರು ಸದರಿ ಉತ್ತರ ಪತ್ರಗಳನ್ನು ಪ್ರೊಫೆಸರ್ ಮಮತಾ ಜಿ.ಸಿ. ನಾನು ಡಾಕ್ಟರ್ ಸರಸ್ವತಿ ವಿ. ನಾಗರತ್ನಮ್ಮ, ಪ್ರೊಫೆಸರ್ ರೆಡ್ಡಮ್ಮ, ಡಾಕ್ಟರ್ ಜ್ಯೋತಿ ಇವರು ಉತ್ತರ ಪತ್ರಿಕೆಗಳನ್ನು ಉಪನ್ಯಾಸದಿಂದ ಕಸಿದುಕೊಂಡಿದ್ದು. ದಿಸ್ ವರ್ಡ್ ಈಸ್ ರಾಂಗ್, ಮೈ ಲಾರ್ಡ್. ಇಟ್ ಈಸ್ ಫ್ರಮ್ ದಿ ಸ್ಟೂಡೆಂಟ್ಸ್. PG ಸ್ಟೂಡೆಂಟಿಂದ ಪ್ರಿನ್ಸಿಪಾಲ್ ಮಾಡಿಸ್ತಾ ಇದ್ರು ಒಂದು ರೂಮ್ನಲ್ಲಿ ಕೂಡಿಸ್ಬಿಟ್ಟು. ದಟ್ ಈಸ್ ರಾಂಗ್. ಓನ್ಲಿ ಟೀಚಿಂಗ್ ಸ್ಟಾಫ್ ಶುಡ್ ಬಿ ಡನ್. ಅದನ್ನೇ ನಾನು ಕೂಡಲೇ ಮೇಲಾಧಿಕಾರಿ ಗಮನದ ಒಂದಿನ ನಂತರ ನಿರ್ದೇಶಕ ಹೇಳಿದ ನಂತರ ನೀಡುತ್ತದೆ. ಆ ದಿನ ನಾವು ಓರಲ್ಲೇ ಹೇಳಿದ್ವಿ. ದೆನ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ವಿ. ಡಾಕ್ಟರ್ ಜಯಲಕ್ಷ್ಮಿಯವರು MSc ವಿದ್ಯಾರ್ಥಿಗಳಾದ ಮಂಜುಳಾ ಮತ್ತು ಹಾಗೂ ರಮ್ಯಾ ಇವರುಗಳಿಂದ ಜಮ್ಮು ಅಂಡ್ ಕಾಶ್ಮೀರ ರಾಜ್ಯದ ಉತ್ತರ ಪತ್ರಿಕೆಗಳನ್ನು ಮೌಲ್ಯಮಾಪನ ಮಾಡಿಸಿರುವ ತಪ್ಪಾಗಿರುತ್ತದೆ. ಪ್ರೊಫೆಸರ್ ಮಮತಾ ಜಿ.ಸಿ. ಸರಸ್ವತಿ ನಾಗರತ್ನಮ್ಮ
ಇದು ಮ್ಯಾಟ್ರ್ ಮೇನ್ ಆಗ್ಬೇಕಾಗ್ತದೆ.
ಅಲ್ಲ, ಆಮೇಲೆ ಏನಾಯ್ತು ಅಂದ್ರೆ ಜಯಲಕ್ಷ್ಮಿ ವಿರುದ್ಧ ಆಕ್ಷನ್ ತಗೊಳ್ಬೋದಾಗಿತ್ತು. ಏನಾದರೂ ತಗೊಳ್ಳಿ, ರೆಕಮೆಂಡೇಶನ್ ಏನೋ ವಾರ್ನಿಂಗ್ ಕೊಟ್ಟು ಬಿಟ್ಬಿಡಿ ಅಂತೇಳಿ. ಈಗ ನಮ್ಮನ್ನ ವಾಪಸ್ ಹೋಗಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ದೇರ್ ವಾಸ್ ನೋ ರೀಸನ್ ಫಾರ್ ಪಾಸಿಂಗ್ ದಿಸ್ ಆರ್ಡರ್.
ವಾಪಸ್ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು?
ನಾನು ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಗೆ ಹೋಗಿ.
ಪೇರೆಂಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
ಹಾ.
What's your right to remain here?
No, my lord, this post meant the health department, and on this ground it cannot be sent, my lord. If there is any other reason ಅಂದ್ರೆ ಜಯಲಕ್ಷ್ಮಿ ತಪ್ಪು ಮಾಡಿದಾಳೆ, ನೀವು ಹೊರಟೋಗಿ ಅಂತೇಳಿ. ಅಲ್ಲಿ ಇರೋದು 21 ಪೋಸ್ಟ್ ಸ್ಯಾಂಕ್ಷನ್ ಇರೋದ ಇವ್ರ 6 ಜನ.
You are on deputation.
ಹಾ,
Deputation to
deputation to this institution, it is a post meant for health and family welfare department.
Right. Deputation
Huh.
for what period?
ನಾನು ಒಂದು 10 ವರ್ಷದಿಂದ ಅಲ್ಲೇ ಇದ್ದೀನಿ.
You cannot remain there.
ಆಮೇಲೆ ಇಲ್ಲಿ ಈ ರೀಸನ್ಗೆ ನಾವು ಇದು ಮಾಡಬಾರ್ದು ಅಂತೇಳಿ ನಮ್ ರೀಸನ್.
Yeah, we have held.
May I make a submission?
Contrary to your contention, we have held that way and apex court has.
ಒಂದೇ ಸಬ್ಮಿಷನ್ ನಂದೇನಂದ್ರೆ ದಿಸ್ post.
If we say something,
Huh.
your main case tomorrow which you have to argue should not be affected ಅನ್ನೋದು
ಅಲ್ಲ,
ಒಂದು
ಇದರಲ್ಲಿ
anxiety.
ಇದರಲ್ಲಿ
2 weeks ಬಿಟ್ಕೊಂಡು ಹಾಕೋಣ ಅಲ್ಲಿ ಬಿಡ್ಸಂಬರಿ. ನಾವು ನಿಮ್ಮ against hold ಮಾಡೇವೆ ಅದಕ್ಕೆ. In BL Sanjeev's matter.
ಈಗ ಅಲ್ಲಾದ್ರೂ ಸಹಿತ ನಾ ಇನ್ನೊಂದು ರಿಟ್ ತರ್ಬೇಕು ಅಷ್ಟೇ.
ಅಷ್ಟೇ ನೋಡೋಣ. All we are told that the main matter is posted before the tribunal for hearing tomorrow. First up. We request the tribunal to hear and dispose of the matter
ಅಲ್ಲಿ
little expeditious. Okay.
Great.
All these matters.
After 2 weeks.
After 2 weeks. Okay.
Two 30 matter? Okay.
Yes. Others perhaps may not wait. ಒಂದು ಇಬ್ರು ಯಾರಾದ್ರು ನೆಕ್ಸ್ಟ್ ಇನ್ ಲೈನ್ ಇಬ್ರು ಯಾರ್ರಿ, ಯಾಕಂದ್ರೆ ಇದೇನಾದ್ರೂ ಕಾರಣಕ್ಕೆ ಬ್ರೇಕ್ ಆಯ್ತು ಅಂದ್ರೆ we should not be without work. Yes, sir.
I was reading to my lord the examination chief of PW1 and I stopped at page 75. I requested my lord kind attention to para 4 of the deposition and last three lines. I am not seeking partition in respect of the aforesaid 24 items of properties.
Yes. You have read this. We have made our notes also on that.
Please.
Yes.
Then my lord kindly come to page 76. This also is read to your lordship that 7127 of 1990 was dismissed for default and
Restoration application was filed and their restoration application was dismissed and then one more application was filed. Then they said another suit is filed and therefore it may be disposed of accordingly.
Yes. My lord, at this moment, I must read to your lordship that withdrawal is different from abandonment. Have I abandoned? Is the question I am posing myself. No, I have, with the leave of the court, withdrawn. Whether liberty is required or not is not the issue here because liberty is not sought, liberty is not granted.
So what is that you have withdrawn? You have withdrawn your application for restoring the dismissed application, which was filed for restoring the dismissal suit.
No, we have.
That withdrawal will not fit into Order 23 Rule 1 at all. There are judgments.
No, I was laboring under the impression that 23(1)
Will not be applicable. Allahabad High Court said 23(1) is applicable only where suit is withdrawn, not any other
Then,
petitions.
my lord, Justice,
But
I am
you
requesting.
have not
my-
even withdrawn the application. You have withdrawn the application
Page
seeking
410.
restoration of dismissed application in which you had sought for restoration of the
yes,
suit
yes.
dismissed for non-prosecution.
My lord, the
31 is not, 23(1) is not.
the present suit is a classic example of what it should not be. And having regard to the. No, justice. Justice. A division bench of this honorable court had occasion to consider the effect of dismissal and withdrawal.
That was a dismissal of a main proceeding.
Yes.
Withdrawal of the main proceeding.
Yes.
I have seen that.
I
There
think,
is about
since
half a dozen
since my
judges.
lord expressed the view that this is not a case where the suit is withdrawn, I
Correct.
should labor and weary your lordship.
So we can go.
But I think, yes, we can proceed further. But the submission I make to the honorable court is dismissal of the earlier suit, which addressed itself to 24 items of properties, is totally different from the present suit for 4 scheduled properties A, B, C, 5 scheduled properties A, B, C, D, E, and hence neither res judicata nor order to rule 2 will apply.
Learned senior document S.P. Shankar submits the subject matter of the earlier suit and the subsequent suit are different from each other, and therefore there is no scope for invoking either res judicata or doctrine of abandonment. Abandonment order to rule 2 agattana?
Yes, next.
Enacted in order to
Abandonment is the appropriate word. My lord has used that, pardon me, suffering there. But in addition to it, nor order to rule 2.
nor order to rule 2. Okay.
Now, the present attack is, in the present appeal, the attack is confined only to the Schedule A properties. It's made clear more than once by my lord has also noticed it.
This submission he makes in the light of withdrawal of his application wherein restoration of dismissed application wherein restoration of suit was sought for.
ಎಷ್ಟು involved ಆಗಿದೆ.
ಇಲ್ಲ, thank you very
That's good. Then my lord is now clear that we are addressing 2 different issues in 2 different suits.
Correct.
Now, the present attack in the appeal is that from the plaintiff's father, X had purchased the property, X has sold it in favor of the vendors under D7 and D28, D27 and D28. From them I have purchased. If I show to your lordship that there is absolutely no truth in this, neither in the trial court nor in the evidence, this has come by way of material for appreciation of the submissions to be made at the appellate stage. Well, in other words, D27 and D28 serve as fulcrum for them to claim title from us. The word used by the learned advocate is we have repurchased the property.
Not you have purchased the property.
You use that word, I thought I should use it. But if you are not repurchased, you are purchased.
You have purchased it.
Yes, it's sufficient. No difficulty. I mean, we hold the mirror, nothing else.
That property admeasured about 10 acres, including Potkara.
Yes, yes.
Of that, 9 acres was bought. It was part by part buying.
I'm tracing it. That's the impression we got. But we'll have to analyze D7 and D28 are the 2 documents under which their vendor purchased it.
But they are referred to in the
2
documents that have been admitted to evidence and marked as exhibits.
But I know the document is forthcoming apart from this.
That's right.
Regarding the tracing of the title. Please examine the contents of D27 and D28, and my lords would find, I'm making 1-line submission, my lords would find that the flow of title from our family to the purchaser's family, to their vendor's family is not available. I'll repeat my submission. Recitals regarding tracing of title from our family qua a scheduled property is found in D27 and D28. I've carefully gone through that. And please.
Mr. Shankar submits that the claim of the appellant defendant that his predecessors in title have derived the title from by virtue of sale deeds as exhibit D27
and 28.
27 and 28.
From the ancestors of plaintiff.
Which they got executed at the hands of members of the joint family in question is not true. First off, there is absolutely no evidentiary material placed on record to vouch the derivation of the title to the subject property.
Then D7 and D28 are said to be executed by persons by one set of 4 families who have the same name. Not my evidence, his evidence. DW. Chinnanna, there are 4 Chinnannas in our village.
Chinnaya.
Chinnaya, Chinnanna, that he admits.
ಚಿಕ್ಕ
DW1.
ಚಿನ್ನಯ್ಯ ಅಂತ ಒಂದಿದೆಯಲ್ಲ, ಮೂರು ಹೆಸರ? ಚಿನ್ನಣ್ಣ, ಚಿನ್ನಯ್ಯ, ಚಿಕ್ಕ
ಚಿಕ್ಕ
ಚಿನ್ನಯ್ಯ.
ಚಿಕ್ಕನಣ್ಣ, ದೊಡ್ಡ ಚಿನ್ನಣ್ಣ, all the 4 names.
ದೊಡ್ಡ ಇಲ್ಲ.
ಹೌದು,
ಅದು
ದೊಡ್ಡ ಚಿನ್ನಣ್ಣ ಇದೆ.
ಇವರಿಗಿದೆ. ಕೃಷ್ಣಾರೆಡ್ಡಿ.
Krishnappa, son of,
ಕೃಷ್ಣಯ್ಯ, ಕೃಷ್ಣಾರೆಡ್ಡಿ.
and then Nanju Reddy is our father, grandfather. They make him the Dod Chinnanna. So there's no, that's the point I'm trying to make out. D27 and D28.
The Shankar submits that certain names under whom the property is said to have, title to property is said to have been derived by virtue of the sale deeds as exhibit D25 and 24 and 25 had alias. Those names had alias. And the proof of alias is not furnished. And therefore, identity of the executants cannot be just construed by the argument of Mr. Surana in the absence
Argument
of
at the appellate
evidentiary
stage.
material.
Argument at the, argument at the appellate
ಅಲ್ಲ,
stage.
ನಮ್ ಇದಕ್ಕೆ,
ಅಲ್ಲ.
ನಮ್ ನೋಟ್ಸಿಗೆ, these are notes. Not judgment. ನಮ್ ನೋಟ್ಸ್ ನಲ್ಲಿ ಯಾರ್ದು ಏನ್ ಹೇಳಿದ್ರು ಅಂತ ಗೊತ್ತಾಗ್ಲಿಕ್ಕೆ ಅಂತ. First, Mr. Surana interjected to tell us that it is not that title is derived from the ancestors of the clients of Mr. Shankar.
Mentioning the alleged earlier partition, on the basis for the alleged earlier partition.
On the basis of alleged earlier partition. Okay.
This is there. Then we'll have D27 and D28. I am attacking it on the ground of 32 class 5.
Bracket nalli ಚಿನ್ನಣ್ಣ, ಚಿನ್ನಯ್ಯ, ದೊಡ್ಡ
ಚಿಕ್ಕ ಚಿನ್ನಣ್ಣ, ದೊಡ್ಡ ಚಿನ್ನಣ್ಣ.
ಚಿನ್ನಣ್ಣ, ಒಂದೇ.
And then there are two.
ದೊಡ್ಡ ಚಿನ್ನಣ್ಣ. ಕೃಷ್ಣಯ್ಯ, ಕೃಷ್ಣಾರೆಡ್ಡಿ, ಕೃಷ್ಣಪ್ಪ. ಒಂದು ಬ್ರಾಕೆಟ್ ನ ಹಾಕಿ ಎಷ್ಟು ಗೊತ್ತಾಗುತ್ತೆ. All right, we have understood. We have made notes of it.
According to the appellant, the grandfather is Gurappa or Gureddy. According to our style, he is Nanjun Reddy.
He adds that.
ಅಲ್ಲ, D27, 28 ಬಂದ್ರೆ ಸರಿ ಇಲ್ವೇ? 24, 25 ಬಂತು ಡಿಕ್ಟೇಷನ್ ಲೀಡ್ ಕೇಳ್ತಾರೆ.
28 ಬರ್ಬೇಕಾ?
27,
28 D27, 28 ಮಾಡಿ.
ನಿಧಾನವಾಗಿ ಹೇಳ್ಬೇಕು, ಮಧ್ಯದಲ್ಲಿ ಹೇಳಿದ್ರು ಬೇಡಿಂದೆ. I'm attacking it on the ground of 32 class 5 of the Evidence Act, 65 and 90. D27 and D28 are attacked on the
32.5.
class 5, relationship of the dead person. Secondary evidence. The third, section 90, presumption is not available.
30-year presumption.
So the bar, irrespective of the interest that we have. The college drafted Evidence Act in the year.
Fitzgerald.
Yeah, I mean, average life was 27 years. The law took notice of this fact and said up to 30 years is the ancient document, causing 102, 105, 120. So therefore, what was good at one point of time, the time stipulation diluted and invalid in court. My submission on 3 occasions has held that what my lord would recall, rent fetching, utilize and not eviction petition was the law earlier. What was good at that time, 150 is diluted. Today we are not allowing 150 rupees. We'll do it. And legislature was commanded to amend it. Your lordship may kindly.
What happened to corresponding provision in the new Evidence Act? This argument you could have made in the new Evidence Act. This is altered.
60.
It is not altered in the new Evidence Act.
No, I think we can.
The Evidence Act has been amended number of times.
The wisdom of the parliament is one thing, or the want of it is another. The submission I make to the honorable court is, the submission up to the honorable court is, it is the pronouncements of the court that have.
Which is the, Mr. Mahalay, which is the corresponding provision to section 90?
I'll
the
check up
old
and
act?
tell. I'll check up and tell because I have
Just
not.
tell.
No, in two decisions,
Raghu, section 90 of the old act is corresponds to which new provision of the new evidence act?
New.
How many years they have made? As it retained, as it is altered?
One section before I
It is not our impression is 90-year, the 30-year rule is retained.
it's 60 years, because we allow it to 60 years. Allah, ತಾವು pronounce ಮಾಡಿದ್ರೆ ಅದು ನಮ್ಮ the busy parliamentarians will also get.
It takes already done. And now new evidence act has come.
No.
ಅದರಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು ನೀವು.
I think will in a minute time he will give, because he's at the computer. The evidence act number ಇದೆಯಲ್ಲ ಅದ್ರೊಳಗೆ corresponding provision ಇದೆ.
One or two sections difference
ಅಷ್ಟೇ.
ಜಾಸ್ತಿ ಆಗೋದಿಲ್ಲ.
So will I am
ನೀವು ಸಿವಿಲ್ ಲಾಯರ್ಸ್ ಅಲ್ಲ, ಉತ್ತರ ಕೊಡಿ. ಸಿವಿಲ್ ಲಾಯರ್ಸ್ ಅಲ್ಲ ನೀವು, ಶುಡ್ ಟೆಲ್ ಮರ್ಚ್ ಆಫ್ ಲಾ.
ಹೊಸ ತಂದಿಲ್ಲ.
1 minute or something. Then Motor Vehicles Act schedule was appended to say that the multiplier is 60 to 20. I mean, maximum multiplier is 60. Supreme Court made it 18 without legislation. 2, the minimum wages stipulated in the column, the various columns, is also enhanced 10 times. So it's the courts that have pronounced on this, and that I request your lordship to pronounce that this 30-year rule was relevant when the man died.
That depends upon what is the change of law brought about by the parliament now. If suppose if the parliament in its wisdom has retained the text as it is, then we cannot tinker that.
I thought
92 ಈಗ.
Huh?
ಈಗ 92.
How many years rule it is?
Evidence Act
30 years.
Yes.
It is retained as it is. Therefore, your argument has no basis. 30 years only.
30 years. Argument I'm making a request to the honorable court to observe this. A number of statutes have been, my lord would remember, the 197 of the Income Tax Act, the land acquisition compensation received was limited to a village consisting of 5,000 population. That is enhanced to 10,000 by reason of the pronouncement. So there are 7 cases where Supreme Court has held that this time, rather monetary limit is unreasonable. Please enhance it. Observe ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Monetary limit the presumption arising by virtue of 30 years of the document being.
30 years is like this now. Earlier 30 years, 20.
Even now, the new act, section 92 of the new evidence act enacts 30-year rule only.
ಅದು ತಪ್ಪು ಅಂತ ತಾವು ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ ನಾನು ಕೇಳ್ತದೆ ಅಷ್ಟೇ. That's not the argument for the case. I am requesting the honorable court, please observe. It's an occasion for this honorable court. There would not be another occasion for another few years. ಅದನ್ನ ಮಾಡಿ ಎನೌನ್ಸ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬೇಕು ತಾವು ಅಂತಷ್ಟೇ. That's the interest of the bar, I'm saying this. The interest of the society, I'm making this submission. It's a court officer, sir. Kindly take this. And copy. Sorry, Kutya.
Mr. Shankar submits that there being enormous improvement in the longevity. Come on. The 30-year rule enacted in section 90 of the Evidence Act 1872 needs to be made. Just to 60 years madhuka? 60-year rule. First off, he cites certain decisions of
instances and decisions. Instances
and decisions. ಯಾವ್ದು ಕೊಡಿ ಡಿಸ್ಟೆನ್ಸ್ ನೀವು ಹೇಳಿದ್ರೆ ಅದು ನೋಡ್ಕೊಂಡು ಮಾಡ್ತೇವೆ ನಾವು.
No, they are decisions attacking 27-28. Various pronouncements ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಸಾಕಷ್ಟು.
Pronouncements and so in support of his submission.
And request the court to observe ಅಂತ ಹೇಳಿದ್ರೆ ಸಾಕಷ್ಟು. ನಾವು ಮಾಡಬೇಕು. ಯಾರಾದ್ರೂ we are in the thick of the case, therefore I made this suggestion.
We are not inclined to accept the said submission. More particularly because the parliament, having reviewed the legislation, has brought up the new legislation wherein section 30 of the old act corresponds to section 92 of the new act, where again 30-year rule is retained in parliamentary wisdom. First off, court cannot run a race of opinion in matters like this with the lawmaker. Yes.
Yes. Now, my lord, kindly, it's a small note.
Yes. In proposition in.
One page only, one note. The exhibit D27 dated 31/8/96 is stated to be a deed of sale purported to have been executed by Krishnappa, son of Chinnanna, in favor of Venkatappa, son of Doddanna, conveying 1 acre 26 guntas of land in survey number 37/2. Recitals of D27 do not refer to any partition and sequential allotment of the land to vendor while narrating flow of title. It is set out that this land was exclusive property of vendor, so not partition. Name of the vendor differs from that of the father of the plaintiff or his grandfather. Efforts are being made to contend that family property was partitioned and this land in survey number 37/2 fell to the share of vendor of D27. Document D27 does not support this. Hence, it may not be considered. Further, D27 is certified copy. No plea or steps were taken to adduce secondary evidence. Admittedly, original of D27 must be with the vendor pursuant to the elite partition. Section 90, and this becomes a document of title. If it is a document of title with the appellant, he cannot say that presumption is there, I'll produce secondary evidence. It must be with me. The second condition for section 90 is, it must be an
from proper custody.
That title deed must be with the defendant. That is the word used in the section. So he's with him. This will be considered by your lordship. It must be by the vendor.
Clarity clear agilla naಮಗೆ ಏನು ಹೇಳ್ತಾ ಇದೀರಿ ಅಂತ.
The document.
Section 90 speaks of, Supreme Court interpreted it. I think.
No, 65. I'm talking 65.
65.
65.
For production of secondary evidence.
Secondary evidence. That original document must be destroyed, lost. It must be, and it must be with the defendant. Here, I can't summon them. Therefore, permit me to substitute it in certified copy is the provision of 65.
Next point. Learned counsel appearing for, S.P. Shankar appearing for the appellants in the cross objection argues that, contends that no case is made out for admitting additional evidence under Order 41, Rule 27, 27, more particular of CPC, read with section 65B of 65 of 1872 Act.
As demonstrably, the original of this is with the vendor.
Comma. Demonstrably original of
sale. Krishnappa bere, Krishnappa bere. Doddanna cannot become Nanjan Reddy.
Point adala. You are arguing that those documents must be with him. Adralli elliyadru one kade. It is referred in an admitted document. And this is referred in the admitted document. Whether that document mentions that the title deeds are handed to the buyer of the property in Tellara argument.
No, he claims title under that. Flow of title is traced to the partition. Partition deed must be there and his sale deed must be there. But now he cannot produce certified copy of D27 and D28, the original sub.
Partition deed, partition is always between too many people. One will be with one person.
You remember, my lords would remember that I relied on Supreme Court decision which approved the Calcutta edition, Justice Mukherjee justice. And there I have said, the minimum at counsel for defendant owes to the court is to put a suggestion that Krishnappa is your vendor.
No, that's all right. We'll come to that one.
No.
The point is,
ಈಗ
you
next
say
build up ಮಾಡ್ತಿದ್ದೀನಿ.
we should presume that the partition deed is with the buyer of the property.
Presumably, demonstrably better, presumably. My lord, your lordship's the cherished language is known to me. Therefore,
your
permit
language
me to
and
call
your
it.
far
Permit
superior
me
to
to call
us,
it, change
but
myself.
we are not able to.
Presumably,
catch the point.
presumably ಹೇಳಿ.
ನಿಮ್ಮ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಎಕ್ಸಿಬಿಟ್ D-27-28
ಯಾವುದು?
ಅದರಲ್ಲಿ ಈಗ ಪ್ರೊಡ್ಯೂಸ್ ಆದಂತ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ರೆಫರ್ ಆಗಿದೆ ಅನ್ನೋದು ಅವ್ರ ಕೇಸ್.
ಇಲ್ಲ
ಅಲ್ಲ ಅವ್ರ ಕೇಸ್.
ಅವ್ರ ಕೇಸು.
They have read that also. That document
Yes.
is referred to.
That is not there in D-27, D-28. Is the point I am making out. It should be presumably with him.
ಕೊಡಿ D-27-28 ಕೊಡಿ. ಯಾವ್ದು ಪೇಜ್ ಹೇಳಿ.
496.
Typed copy 490.
ಅದು 496 is typed copy.
Typed copy of 27. 496. Typed.
ಎಲ್ಲಿ ರೆಫರ್ ಆಗಿದೆ ಅದು?
ಆಗ್ಲಿಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತೇನೆ. That's why I am not the vendor. This case is that is there ಅಂತ. ಇಲ್ಲ ನಾನು ಕಂಡೆ 2 ಸಾರಿ ಓದಿದೆ. ಇದ್ರೊಳಗೂ ಇಲ್ಲ 28ಲೂ ಇಲ್ಲ. ಇದು ನನ್ನ ಸ್ವಂತ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳ್ತಾನ ಅವನು. Am I correct?
Yes. This is 37/2, 1 acre 26 ಗುಂಟಾಸ್ ಇದು.
ಹೌದು. ಅದು ನಾವು 10 ಎಕರೆ 10 ಗುಂಟೆ ಅವ್ರು ಮಾಡೋದು.
Mr. Surana, you said other day that the documents which you seek to produce by way of additional evidence under 4127, the certified copies of the sale deeds, these sale deeds are referred to.
Yes.
In the sale deeds admitted to evidence.
Exhibit D-18.
P-18.
D-18. ನಮ್ಮ ಸೇಲ್ ಇರೋದು D-18, ಆಮೇಲೆ D-33.
1 second.
D-33 ನಲ್ಲಿ ಇದೆ. Kindly go to page 523.
523.
ಇದು ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ.
ಅದು
D-33 ಇದು ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್.
That refers to the additional documents which now we have produced.
Kindly go to that.
D-33.
523
page.
523 page. From the bottom, 6th line.
September 65.
Yes.
At the bottom 4 lines, 5 lines.
ಈ ಜಮೀನು ನನ್ನ ಹೆಸರಿಗೆ ತಾರೀಕು 20/9/65 ರಿಜಿಸ್ಟ್ರೇಷನ್ ನಂಬರ್ 2907 ವಾಲ್ಯೂಮ್ 588 ಪೇಜ್ 62 ರಿಂದ ನರವರೆಗೂ ಅಖಾಡವಾಗಿ ಕ್ರಯಪತ್ರದ ಮೂಲಕ ನಂಜಪ್ಪನ ಹೆಂಡತಿ ಮುನಿಯಪ್ಪನವರಿಂದ ಬಂದಲಾಗಾಯಿತು ನನ್ನ ಅನುಭವದಲ್ಲಿದ್ದು ಈ ದಿನ
this document refers to my father's name as Dodgurappa. I am Krishna Reddy. This document is different from 27-28. Is the point I am making out. Page 523, line 6. ಸಾಮಸಂದ್ರ ವಾಸವಾಗಿರುವ ದೊಡ್ಡಗುರಪ್ಪ, ದೊಡ್ಡಿ ಅಲ್ಲ ದೊಡ್ಡಗುರಪ್ಪ, ಇವರ ಪಿದ್ದ ಸ್ವಾಮಿ ಮಗ ಸ್ವಾಮಿ 45 ವರ್ಷ ಕೃಷ್ಣ ರೆಡ್ಡಿ. These 3 persons are different from the D-27, D-28.
I'm sorry. The identity of persons now ಬೇರೆ treat ಮಾಡೋಣ. Whether this document is referred in the admitted document or not is the question before us. It is referred to in the admitted document.
ಯಾವುದು?
ಅದು sale deed of 20 September 1965. A certified copy of the same is now produced under 41 rule 27. ಅದಿಲ್ ರೆಫರ್ ಆಗಿದೆ ಅಂತ ಇವ್ರ ಕಂಟೆನ್ಷನ್. ಐಡೆಂಟಿಟಿ ನೋಡೋಣ. ಐಡೆಂಟಿಟಿ ಆಫ್ ದಿ ಪರ್ಸನ್ಸ್ ಸ್ವಲ್ಪ ಲಿಂಕ್ ಆಗಿದೆ. We understand that also.
No, identity of vendors, identity of the property, extent of property, they're all different. That's similar. Would your lordship saddle me with additional litigation by asking for allowing additional application for amendment? And that will be first question that will be posing myself. Number 2 is, where does this take us? If we go through the exercise again, we are not sure of the identity of the property, we are not sure of the identity of the vendors, At this stage, additional evidence, well, the decisions of the Honorable Supreme Court, both Constitution Bench and the three judges bench, is that you cannot write a particular judgment by taking additional evidence. My lord would remember, 65 Supreme Court, 1008. The second decision is Constitution Bench, which says it cannot accept additional evidence for filling up the gaps. Now there are too many gaps. Those gaps cannot be filled by taking additional evidence. This is the only objection I am raising for additional evidence.
Yes, sir.
Well, then the extent of land, the number is survey number 37/1, while the suit land is 37. The extent is 10 acres, the extent is 1 acre 20, page 524. Kindly turn to page 524. Fourth line from the bottom, survey number 37/1, extent 1 acre 20 guntas.
Mr. Shankar submits that there is highly contested identity of the executants of document dated 20 September 1965, which has been referred to in Exhibit D33,
34 and
PB 523. Persons are different.
The date of.
And property is also different.
Are there 65?
First off, property is described as survey number 37/1. And executant is said to be Krishna Reddy,
Son of
son of
Doddigurappa.
Swami.
While the appellant in the cross application is son of Nanjun Reddy.
Krishna Reddy is said to be son of Nanjunda Reddy.
Nanjun Reddy in the revenue documents and my.
Revenue.
Krishna Reddy.
No, ನೀವು ಉತ್ತರ ಕೊಡಂತೆ. I will give you opportunity for reply also. It's his case.
Chikkasinanna is son of Nanjun Reddy, son of Chikkasinanna is Krishna Reddy. ನನ್ನ ತಾತ ಎಂತ ದಿ ಗುರ್ರೆಡ್ಡಿ ಅಲ್ಲ ಯಾರೋ ನಂಜುನ್ ರೆಡ್ಡಿ. ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ಎಕ್ಸಿಬಿಟ್ D1 is the document. P1 ಅಪ್ಪ.
To substantiate
Page number.
this submission, he reads out document at Exhibit P1, which is genealogy of the family, which mentions ಅಜ್ಜನ ಹೆಸರೇನು? ನಂಜುಂಡ ರೆಡ್ಡಿ. Son is Chinnappa Reddy.
Page 224.
And
Nanjun Reddy.
Chinnappa Reddy son is
From plaintiff. Chinnappa Reddy is the Krishna Reddy.
Krishna Reddy. First, paper book.
Paper book, volume 2, page
224.
224. Okay.
And the extent of property is to 1 acre 20 guntas in all the. Now, my lord, I was on the point of, we went to Article 41, Rule 27. Depart from this. My lord, I request my lord's kind attention to para 3
of
this additional note, small note.
Just
Para 20, it's a para 2 and 3. ಇದಕ್ಕೆ ಇವಾಗ ಕೊಟ್ಟಿದ್ದಪ್ಪ. Exhibit D20 further, this exhibit D27 is certified copy. No plea or steps were taken to adduce secondary evidence. Admittedly, I'm talking of the trial court.
yes.
D27 is certified copy. No clear steps were taken to adduce secondary evidence. Admittedly.
All right. Next week.
Then with this, next is, my lord would notice, D28 is survey number 36/1, not scheduled property.
Yes, we have taken that off.
I thought. Then kindly now please turn to the citations. Page 3, my lord would get that decision. This is that Lucky Burwa case. Court's discretion in presumptions of genuineness of the documents 30 years old. The presumption is to be raised only if the impugned document is produced from proper custody. It's however within the discretion of the court whether to accept it or not to accept the presumption flowing from section 90. Of course, the judicial discretion of section 90 cannot be exercised arbitrarily and unreasonably. Presumption of genuineness not available to certified copies. Presumption under section 90 does not apply to a copy or a certified copy.
Yes, we have said that already. When he argued, we have referred to this judgment also. Another judgment we have referred. Presumption on 90 is confined to original documents, not certified copies of the originals. Even if the certified copies are more than 30-year old. The second one is coming from proper custody.
And that document must be with me. Up to the
That's
party.
what it's covered. Next point.
Then we'll have next decision. I think 65, this is 90. Kindly turn to page
Mr.
9.
Shankar
This is
repeats that. The application of section 70 of the 1872 Act is confined to production of certified copies.
violation.
We contradict you, we will look into.
ಖುಷಿ ಆಗತ್ತೆ ಬಗ್ಗೆ 65.
ಅಲ್ಲ ನಾವು ನಿಮ್ಮನ್ನು ಕಾಂಟ್ರಾಡಿಕ್ಟ್ ಇದು we are in full agreement with this ಅಂತ.
ನಮ್ಮ ಪ್ರಯತ್ನ ತಾವು ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡ್ಬೇಡ್ವೆ.
All right.
Page 9. 65. Before adducing secondary evidence, proper foundation has to be laid for ತಾವು ಹೇಳಿರೋದು ಶಬ್ದನೇ ಬೇರೆ ಏನಿಲ್ಲ. For not producing primary evidence. It is clear as a rule, documents must be proved by primary evidence. If the primary evidence is not available for the reasons set out in section 65, then only the second evidence is admissible. Therefore, before secondary evidence is adduced, a proper foundation is to be laid for not producing the primary evidence. Only after the non-production of the primary evidence is satisfactorily accounted for, the secondary evidence would be permitted to be adduced. But on the ground that the party proposes to adduce secondary evidence has not disclosed from the where which has got documents and whether the said documents are coming from proper custody. The document cannot be refused to be received in evidence and ಹೇಳ್ತಾರೆ. ಇದನ್ನ law is declared here. ನನ್ನ submission undre after reading this, neither in the High Court nor in the trial court a case was made out for production of certified copy D7, D28 and other documents. So they are not evidence received in accordance with law. Don't look into it. That's all. Then my lord, I will be requesting my lord's kind attention to the decision on 35(5), Supreme Court decision, page 12. This has not been referred to so far.
Sir, we have a small request. Request you to presume. We request you to presume that judges know the Evidence Act. Really, we know. With very humbly, humbly, I have read Droff and Amirali. I have read Rupert. Field on evidence. I have read Mitra on evidence. Maybe my brother has read. We only request you, presume that judges know the law. Because we are quoting section, we are quoting judgments. We will quote opinio juris also if required. Because very humbly we are saying this. Very humbly we are saying, because I have taught law of evidence for 5 years. Yes. This we should not say. Since you are saying that, we have to say this.
I repeat the honorable court to the contention, they could not have received either here nor there.
These are all, sir, these are all very elementary things in any, they are treated by any standard author on law of evidence.
A sinner has a chance to be pardoned.
No, not like that.
ಅಂದ್ರೆ ಬೇರೆ ಕಡೆ ನಾವು ಹೆಚ್ಚು ಪ್ರೊಡಕ್ಟಿವ್ ಆಗಿ we can spend. Of course, many youngsters will be benefited by our discussion. But yes,
Then kindly turn to PW1's evidence, page 78. Paragraph 6. The relief now claimed in the above suit is only in respect to the scheduled properties, and I reserve my right to seek necessary relief in respect to other properties. Then
yes, sir.
Page 81, paragraph 8. It is my specific case that the scheduled properties are the joint family properties of myself and defendants 1 to 3 are entitled to share in the property. Then kindly come to page 83. Huh? Huh. Yes, please.
Assuming.
Well,
assuming.
the senior counsel would say, 4 lines, 5 lines bottom from that paragraph 8, it's assuming my lord would notice.
Page number?
Page 81, paragraph 8, I read those sentences.
They're all joint family.
A oral partition as claimed by defendants number 1 and 2, defendants have to say what are the properties allotted in my favor and what are the properties in their favor. Contrary to this, the defendants have not produced any iota of evidence to prove that there is oral partition in the family unless and until the defendant. And on this, no cross-examination. Am I correct?
Never mentioned.
Yes. This has gone unchallenged.
Witnesses have to say the evidence, not the argument.
How I have been corrected, but that is what I found in the record. Yes. Citation, my lord is right. Citations, arguments, all these things are away from, apart from evidence. Wholly apart from evidence.
Proof of pleading gone.
We have one common ground between myself and Mr. Tulana. The advocates have taken liberty with the pleadings in this case.
ಎಲ್ಲರಿಗೂ ಹಂಗೆ ಬರ್ತಾ ಇದೆ.
ಯಾರು ಮೊಗ ಪ್ಲೀಡಿಂಗ್ಸ್, ಓಜರ್ಸ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಯಾರು ಓದ್ತಾರೆ? ಯಾರು ಓದಲ್ಲ, ಎಂತದಿಲ್ಲ. Many have not heard of ಓಜರ್ಸ್ pleadings at all. ಹಂಗಾಗಿ ಇಷ್ಟ ಟೈಮ್ ಎಲ್ಲ ಹೋಗ್ಬಿಡುತ್ತದೆ ನಮ್ದು ಇದರಲ್ಲೇ.
ರೂಲಿಂಗ್ ಹೇಳ್ತಾರೆ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳ್ತಾರೆ, ಲಾ ಹೇಳ್ತಾರೆ, ಎಲ್ಲವೂ ಹೇಳ್ತಾರೆ ಪ್ಲೀಡಿಂಗ್.
From paragraph 8, what you want to say, sir?
No, I'm submitting to the honorable court that, see, there he sets up oral partition. Does not.
To the evidence part only. In PW1.
My lord, the submission I make to the honorable court is in the alleged partition or earlier partition set up by defendant. There is no mention of what is allotted to me and what are the properties. This is submission I make.
Mr. Shankar draws our attention to para 8 of the WS Adu. Examination.
Evidence of PW1.
Examination in chief of PW1.
PW1 plaintiff.
Plaintiff. See PB 81 and 82. Yes.
And then evidence, I'll take the honorable court to evidence of DW1 now.
Yes.
It commences from page 9. Oh God, this further. Cross examination. DW1 cross examination. I am sweating. Paragraph. Page 93.
90.
Page 93. ಇದು ನೋಡಿ ಸಾಹೇಬ್ ನೋಡಿದ್ರೆ ಇದು ಪ್ರತಿ ಎವಿಡೆನ್ಸ್ ದಿವಸದ ಎವಿಡೆನ್ಸ್ಗೂ ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೊಸ ಪ್ಯಾರಾಗ್ರಾಫ್ ಬಂತು. ಕಂಟಿನ್ಯೂಷನ್ ಇಲ್ಲ. Page 93, paragraph 2, bottom. It is not true
to suggest.
that there was partition between my father and his brother prior to 1960. It is not true to suggest that plaint A schedule, B schedule property was allotted to my father's name. It is not true to suggest that the father has sold plaint number so and so and the sale deed at those are the 61 and 61 D 27 and 28. 20?
28 and 26.
28 and 29.
ಯಾವ್ದು 28 ಯಾವ 29?
16/12/1961 is D28. 1/4/1967 is exhibit D26.
16/12/61 is
28.
exhibit D28.
D28. 1/4/1967 is exhibit D26. 29/3/1967 is not produced.
Then para 3. It is not true to suggest that deceased first defendant has purchased survey number 3703 as his ancestral property. 3703 is not the subject matter of the suit. I have not produced, I have not seen survey number 37 after 1990. It is not true to suggest that entire survey number 37 is fully covered by buildings. Fourth defendant has constructed buildings. Then
this is evidence of
PW1. I think entire volume ಬರುತ್ತೆ no ಕಾಣ.
Well, in the admission, I have not seen signs, so it is not true to suggest that entire, not true to suggest. PW1.
Oh, no. ಆಮೇಲೆ ನಂತರ I request pray for the attention of the honorable court to paragraph 4 and 5, right hand side. Last 3 lines at para 5, bottom. My grandfather's father's name was Nanjun Reddy alias Nanjundappa. ಅವ್ರು ಗುರೆಡ್ಡಿ ಹೇಳ್ತಾರೆ ಅವರು. ಸೊ ಅದು ಎರಡು ಬೇರೆ ಫ್ಯಾಮಿಲಿ. ಇದು ನಾವು ಮಾಡಿಲ್ಲ ಅಂತ ಅದಕ್ಕೆ ದಿಸ್ ಇಸ್ ದಿ ಸಬ್ಮಿಷನ್ ಐ ಆಮ್ ಮೇಕಿಂಗ್. ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ದಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್.
One minute I will.
ಆಯ್ತು.
Next page, my lord would notice line. It is not true to suggest that after partition between my father and my father's brother, my father sold all the properties fallen to his share and to trouble defendant this present suit is filed. Next sentence. It is not true to suggest that except survey number 3702 and 3703, all the properties are acquired. This is the delay. Then
yes.
Page 160, 100, sorry, 100. But I have not been able to reconcile even now your lordship's observation that Evidence Act is familiar to us. No, that is, with all respect. ತಾವು ಹೇಳಿದ್ರಿ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ನೀನು ನಮ್ಗೆ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ನ ನೀನು ನಮಗೆ ಪದೇ ಹೇಳ್ಬೇಡ, ವಿ ನೋ ಇಟ್ ಅಂತ ಹೇಳಿ
ಹೇಳ್ಬೇಡಲ್ಲ. ನಾವೇನ್ ಹೇಳಿಲ್ಲ, ಅದು ರೂಲಿಂಗ್ ಓದ್ತಾ ಇದ್ರಲ್ಲ, ಅದೆಲ್ಲ ಬೇಸಿಕ್ಸ್ ವಿಚ್ ಹ್ಯಾವ್ ಬೀನ್ ಟಾಟ್ ಇನ್ ಸೆಕೆಂಡ್ ಇಯರ್ ಆಫ್ ಲಾ ಟು ಅಸ್.
ಅದು
ರಿಯಲಿ
ಅಲ್ಲ, ನನಗೆ ಇನ್ನೂ
ಯು ಕ್ಯಾನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಅಸ್. We will not do it, but you can cross examine us.
ದಯವಿಟ್ಟು ಮರ್ತ್ಬಿಡಿ.
Why we are saying this is,
that was not.
We come after reading, we have no other business except reading most of the standard books and classics. We have read.
I didn't say it, I didn't mean it. I didn't mean it. ತಾವು ದಯ ಮಾಡಿದ್ನ
ಇಲ್ಲ ಅದಲ್ಲ ಏನಾಗ್ತದೆ,
ಇಲ್ಲಿ ಓದಕ್ ಬಿಡ್ತಾ ಇಲ್ಲ.
ಪ್ರಪೋಸಿಷನ್ ಒಪ್ಪಿದಾಗೂ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಿರಲ್ಲ, ಸ್ವಲ್ಪ ನಮ್ಗೆ ಅಜಿಟೇಟ್ ಆಗ್ತೇವೆ. ನಾವು ಒಪ್ಪಲಿದ್ದಾಗ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು. When we are in full agreement with.
Maybe I'm influenced.
Not like that. But ಏನಾಗ್ತದೆ, ಇದೆಲ್ಲ ನಾವೆಲ್ಲ ಬಹಳ ರಿಯಲಿ, ನಾನು ಬಹಳ ಅಂಬಲಿ ಮತ್ತೊಂದ್ಸರಿ ಹೇಳ್ತೀನಿ, ಒಂದ್ಸರಿ ಕೈ ಮುಗಿದು ಹೇಳ್ತೀನಿ. ಸಾವಿರಾರು ಪುಸ್ತಕ ಓದಾಗಿದೆ ಈಗ ನಮ್ಗೆ. Very humbly we are saying this to you. You can cross examine us on that, any any standard book on law of evidence, even any law.
ನಾನು ಮತ್ತೆ
for
ಹೇಳಿಕ್
that matter.
ಮತ್ತೆ ಹೇಳಿದ್ ತಪ್ಪಾಗ್ತದೆ. ತಮಗೆ ಗೊತ್ತಿಲ್ಲದು ಎಲ್ಲೇ ಇಲ್ಲಿ
ಇಲ್ಲ
ವಿಷಯ
ಹಂಗಂತ ಹೇಳಲ್ಲ ನಾವು,
ಇಲ್ಲ.
ಬಟ್ ಸಿಕ್ಕಾಬಟ್ಟೆ ಓದೇವಿ ಅಂತ ಹೇಳ್ತೇನೆ. Very humbly, I assert to the bar that thousands of books I have read. Therefore, even if we agree with your proposition, we should not argue the matter because we are with you.
in the season of winter I am sweating.
Not like that. ಬಹಳ humbly ಹೇಳ್ತೇನೆ ನಾ ಇದನ್ನ, because you can cross-examine me in the open court. I will be perhaps able to answer your questions.
ಅಲ್ಲಿ next ಇದು
Yes.
ಇದು ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ತಾವು I think I should stop here by saying that the evidence on record is that there is no earlier partition and these are the joint family properties. The joint family properties ಇಲ್ಲದಿದ್ರೆ ನಮಗೆ partition ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳೋದಿಲ್ಲ ಅವರು. The presumption that behind the statement that we have effected partition and we have given what is your due is that it is a joint family property at one point of time earlier. And they say a partition agide anta heltare, and though partition is not proved, then this acquisition is also not in dispute. Then the second thing is, he says he was 28 years at the time of purchase of the property. He had no means of, he was not, had no avocation, and no, his means to purchase the property is not explained in evidence. I think that should do for me. And then please permit me to take the honorable court to ಇದು ಮತ್ತೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ at page 118.
That is DW. That's
Huh?
DW1.
Huh? DW1.
Yes, sir.
Page 119. Page 119, cross-examination by Sri UBG. I have studied
You have read it, that last 5 lines, 6 lines. It is correct, my paternal grandfather Chikka Chinna Reddy was already is my father and Krishna Reddy is my uncle. It is correct and correct. The plaintiff and defendant number 3 are the sons of my uncle Krishna Reddy.
So this squares off against the contents of D27 and D28, where different names are shown. That's the submission. Because his admission.
My friends
Paper book
permitted-
1 idu?
Yes.
First paper book.
Volume 1.
Page 119, volume 1. ಆ ಮುಂಚಿನ ಪ್ಯಾರನ್ನು ಓದ್ಬೇಡ ಲೈನ್
ಹಾ, ಓದಿ,
3
ಓದಿ.
ಲೈನ್ it is correct Krishna Reddy and Munsham Reddy are the sons of Chikkachinna Reddy.
Krishna Reddy and
It is not true to suggest that Chikkachinna Reddy was also being called as Chinnappa Reddy. It is not true to suggest that Chikkachinna Reddy was being called with 3 names, namely Chikkachinna, Chinnappa and Chinnappa Reddy.
Important.
This destroys their cross-examination as of my witness.
Yes, sir.
Then kindly come to paragraph 2, last 4 lines. I do not know whether my lords leave. Paragraph 2, page 120. I do not know whether my father, paternal grandfather, whether was any partition between my father and my uncle. I have not produced any document showing that there was partition between my father and uncle. Their case is that there was a partition. He admits that there's no document. Then last 4 lines, but I have not produced any document with respect to Schedule B to E property to show that they are also self-acquired properties of my father. Well, make this, after reading this, I'll make a small submission.
B2E.
Yes, Mila, E2, that is A is granted,
Correct.
B2E is declined, cross appeal is filed.
A and D.
Schedule A
A
is
and D,
37.
A and D are granted.
Alla. Schedule A is 37.
37.
37.
Only 37.
A is 37.
Alla, B2E, they have no claim whatsoever at all.
And their admission also is there ಅಂತ ತಮಗೆ submission ಮಾಡ್ತಾರೆ. In addition,
ನಿಮ್ಮ contention ಏನು ಅಂದ್ರೆ, since they have no claim whatsoever in respect of properties other than
A
37, that is
Yes,
A.
it should
In
be-
respect of
cross appeal
rest
should
of
be
the
allowed.
decree should have been granted.
cross appeal may be allowed, is the prayer. And there is no contest from any of the respondents. Sorry, appellants.
Why court below denied decree in respect of B to E?
ಅದು ಐ ಥಿಂಕ್ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು, ದಿ 24 ಐಟಮ್ಸ್ ಹಿಂದಿನ ಸೂಟಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೆ, ಆ 24 ಐಟಮ್ಸ್ ಯಾವ್ದು ಬರಲಿಲ್ಲ, ಇದ್ರ ಬಗ್ಗೆ ಯಾವ್ದು ಡೀಟೇಲ್ಸ್ ಕೊಡಲಿಲ್ಲ, ಅದನ್ನ ದಿ ಕಂಟೆಸ್ಟ್ ಇಸ್ ಓನ್ಲಿ ಒನ್ ಐಟಮ್ ಎ ಅಂಡ್ ಡಿ ಅದನ್ನ ಕೊಟ್ಟು ಬಾಕಿ ಮಾಡಿದ್ದಾರೆ. ಅದೊಂದು ಲಾಂಗ್ ಡಿಲೇ ಇಯರ್ಗೆ ಸಾಹೇಬ್ರು ಫಸ್ಟ್ ಟೈಮೇ ಅಬ್ಸರ್ವ್ ಮಾಡೋದು, ಲಾಂಗ್ ಡಿಲೇ, ಅದನ್ನ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಎಕ್ಸ್ಪ್ಲೈನ್ಡ್ ದೇರ್ ಇನ್ಕ್ಲೂಷನ್ ನೌ ಅಂಡ್ ದೇರ್ ಒಮಿಷನ್ ಅರ್ಲಿಯರ್ ಅಂತ, ಅದಕ್ಕೋಸ್ಕರ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ದೆನ್ ಮಿಲಡ್ ಇಲ್ಲಿ ಅವರು ಗುರಡ್ಡಿ ಚಿನ್ನ
B2E contest, only 37 alone is in contest. In respect of the decree after, but he has confined it to, now he has confined it to, but in lieu of that, we can find decree on respect of this. Order 812 or 12 a decree on admission.
Rule 6. 12 rule 6.
Huh?
Order 12 rule 6.
Order 12 rule.
Admission.
6.
Decree
on
on
admission.
decree and admission 12-6.
12-6. Now, he admitted that he has no claim whatsoever except in respect of 37. Can't it be a case of
12-6.
12-6,
12-6.
which is invocable, you have written in
but
your book,
there are
12-6 applies to appellate court also.
In its application, the question comes, an application should be filed, then he must admit it in the court, all this, but that, apart from
No, not like that.
statement on oath, this is a statement on oath.
No, that's not the law. The Supreme Court said there need not be separate application at all. Court should read the pleadings of the parties
Anytime.
without any application. This is how you have structured your book also. They have said, Supreme Court said, there need not be separate application at all for invoking order 12 rule 6.
The reason is order 10. Order 10 says, after completion of the pleadings, before issues are filed, the judges are usually put the witness, the plaintiff and defendant into the box and ask questions. Most of the time they say, "Kodbeku Swami, Kodtivi Swami." But the suit is contested by lawyers and not the parties.
Which is that famous
M.T.
judgment.
Ramayana, he wrote the judgment.
You have no claim whatsoever in respect of rest of the properties.
So they were fair, they said, yes, they don't have.
Huh? Claim illa.
ಇಲ್ಲ claim.
ಬೇರೆ ಯಾರಿಗಿದೆ? ಯಾರು contest ಮಾಡ್ತಾರಾ?
ಇಲ್ಲ ಯಾರು ಇಲ್ಲ.
But that stand you have taken before us.
Yes.
That will be sufficient for granted. No, not necessary. That applies even at the appellate stage. It appears you have written that way.
In fact, the word used judgment on admission.
Judgment on admission.
Admission.
Now, courts have equated it to decree. 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 Cour
Lahoti judgment ಇದ್ರಲ್ಲಿ ಇದು ಬರೆದ ಮೇಲೆ ಅಂತ ತಾವು ಹೇಳ್ತಾ ಅಲ್ಲಿದೆ.
No, there is a judgment
Application.
which says no application
Is
need be
necessary.
filed.
ಹೌದು, ಹೌದು.
Judges should simply read and if the admission occurs from the pleadings of the parties, enter the judgment.
A duty is cast on the to.
Court to
That's
do
what
that.
it is.
Court to do that. No, just we are thinking, since they have no claim whatsoever in respect of these properties,
Uncontested.
uncontested, that will be virtual admission only, because at this stage it happened. Though not at the court and stage
Submissions
of the
record
trial.
ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. Submissions record ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ ಇಲ್ಲಿ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ರೆಕಾರ್ಡೆಡ್. Everything is recorded. We will record again that one also.
Then Millard, please. ಇನ್ನು ಬಾಟಮ್ ನಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 8 ಬಾಟಮ್ 7 lines. This is crucial admission. May I read? I have not produced any document to show that Narayan Shetty had title over the property in order to sell the same in favor of the first defendant.
The evidence ಆಗಲ್ಲ. I have not produced no evidence ಆಗುದೇ ಅಲ್ಲ. Court should see whether it is produced or not. That will not be evidence ಅಂತ hold ಮಾಡಿದ್ದಾರೆ. Now other day I told.
I do not have ಅಂತ meaning ಬರುತ್ತೆ.
ಆ ರೀತಿ ಮಾಡಿದ್ರೆ ಬರ್ತಿತ್ತು ಎವಿಡೆನ್ಸ್ ಆಗ್ತಿತ್ತು. It would have partaken the character of evidence. But this is not a evidence at all.
This is a default in production of the document.
ಅಲ್ಲ, I have not produced ಅಂತ ಹೇಳಿದ ನಾವು. ಅದಕ್ಕೆ ನೀವು why you have not produced ಅಂತ ಹೇಳಿದ್ರೆ ಆಫರ್ ಮಾಡ್ತಾನೆ explanation. That becomes part of the evidence. If he says I have not produced the evidence, it is no evidence because it is ascertainable from the record whether he has produced or not.
I follow me. Then please come to page 125. I am reading this particular sentence to show that they filed a suit for injunction against me giving wrong address.
That ex parte decree.
Ex parte injunction. An injunction is not effective unless it is served on me. My lord would remember. Injunction is effective only it is served on me. You are injuncted. You are injuncted is the order.
Correct. But it's an ex parte decree.
Therefore,
as efficacious as a full-fledged.
No, see, in my humble submission, an order of injunction, how it is executed is order 21, rule 33, ಮುಗಿಟ್ಕೊಳ್ತಾರೆ, ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ. So ಅದಕ್ಕೆ ಮಾಡ್ಬೇಕಾದ್ರೆ a personal arrest of the body would result if there is an injunction granted and disobeyed. Injunction granted is against the individual and not ex parte agudilla. It's submission.
Enforcement of a decree of injunction is one thing. Efficacy of a decree is another. In appeal we are on efficacy.
No, there is all that they are saying is there's an order of injunction, it's in operation, therefore madakala. Other it's not operable, it's not operating, it is submission. It is no decide really. I should admit, no court has paid attention to this. Perhaps this was not a submission to be noticed. Sorry, kindly go to bottom portion of page 125. Plaintiff, what I have stated in the written statement that the plaintiff and the third defendant have already left the village is the correct statement. Our written statement ಅವರು ಹೇಳ್ತಾರೆ ನಾವು 30 ವರ್ಷದಿಂದ ಊರು ಬಿಟ್ಟು ಹೋಗಿದ್ವಿ ಅಂತ. ನಮ್ಮ ಮೇಲೆ ಡಿಗ್ರಿ ಆಗಿರೋದು ಈ ಸೂಟ್ ಸಮೀಪದಲ್ಲಿ. After I left the village.
Correct. After coming to know of the decree, you did not take any steps for vacating it.
So coming to know means only in the suit, in the present suit it was filed. ಅಲ್ಲಿ ತನಕ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. It is correct. It is correct while filing the said suit OS. The names of the defendants have been mentioned stating that they are residing at Madhura Nagar, Vartur, in case of third defendant here at this Som Sundar Apalya, Aralkunte village, in so far as the present plaintiff is concerned, it is correct. Survey number 37 mentioned here should be property stated at Aralkunte village. Yes, we are all. Yes, ಮಧುರಾ ನಗರದಲ್ಲಿ ನಾವು ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದು ತಾವು ನೋಟಿಸ್ ಮಾಡ್ಬೇಕು. ಯಾತಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀವಿ ಅಂದ್ರೆ ಇಂಜಂಕ್ಷನ್ ಈಸ್ ವುಡ್ ಆಪರೇಟ್ ಓನ್ಲಿ ವೆನ್ ಇಟ್ ಇಸ್ ಸರ್ವ್ಡ್ ಆನ್ ದಿ ಪರ್ಸನ್. Stay order is different because the court's order is state. Injunction is personal. It should be served on me, then only injunction becomes operative. This is what Nelson's law of injunction. Nelson's law of injunction.
That means if an ex parte decree of injunction is
Injunction,
granted,
yes.
court should not take cognizance of that.
No,
Hello, we want to know.
no,
What is
no.
the proposition?
No,
you are
it's not cognizance matter.
Therefore,
It
we
would not
say
operate. It's submission.
evidentiary value of a decree is one thing. Its enforceability is another, says Woodruff in his commentary
Yes, how to
from 42 to 44 of the
Yes.
Evidence Act.
When I went to library to read section 65, there were markings and I am definitely sure that it is by lot marking. ಅಲ್ಲಿ 65 ನಲ್ಲಿ mark ಮಾಡಿದಿರಿ ನಾವು.
Allah, evidentiary value of a document.
ಇಲ್ಲ.
The judgment's evidentiary value of judgment and orders is discussed by Fitzgerald in section 42, 43, 44, 41, 42, 43, 44
Yes.
of the Evidence Act.
Well,
This is inter parte decree.
ಅಲ್ಲ, is it REM or?
No, it's a personam only.
ಬೇಡ್ವಾ?
Always injunctive decrees are in personam.
Yes,
Therefore,
in
there's no
personam
problem
ಅಂದ್ರೆ
with
it
that.
should be served ಅಂತ ನನ್ನ ಕಂಟಿನ್ಯೂ ಅಷ್ಟೇ. That's the limited point. REM in personam.
It cannot be rem. Rem decree will arise only in 4 jurisdictions. Matrimonial, admiralty.
Adoption.
No,
No, adoption ಇದೆ.
no, one second. That matrimonial, insolvency, admiralty, and probate. These are the 4.
Razia
This
Begum.
one subject to 2 exceptions. One is adoption, another is declaration of law as being void by the constitutional courts. They operate as judgments in rem. These are the points. This injunctive decree, Nelson himself has said, it is a judgment in personam.
Razia Begum's case ಅಲ್ಲಿ, Fifth and Supreme Court 882, they have held that Order 1 Rule 10 of the application, I impede ಆಗ್ತೀನಿ ಅಂತ. Unless you have interest in the property ಬರೋಕ್ಕಾಗಲ್ಲ ಅಂತಾರೆ. ಅವಾಗ they hold the adoption status is applicable to the whole society.
Correct. Therefore, 2 exceptions.
Yes.
These are the 2 exceptions. Razia Begum was a case relating to proper and necessary parties.
Indeed.
58 Supreme Court.
Yes.
This in a different context. But this is the
That's also,
judgment
that
in.
is carved out as one of the instances of this universality, applicability, enforceability. Then kindly come to page 127.
Mr. Shankar submits that the injunctive decree in OS number 64
Ex
bar
parte
2000
injunction decree.
having been obtained ex parte, the cross objectors, comma, it cannot be looked into for any purpose, for the purpose of the case.
It should not be looked into for the purpose
purpose
of
of the
preventing
case.
from claiming the property. Should not be used to prevent me from claiming the property.
Lord, your lordship may add by giving false address. That is the most important thing, Lord. What I
As
wanted
much as the decree is secured by furnishing wrong address of
And
his
even
clients.
property is described.
His clients.
wrong address, even wrong address. How did it-
Yes. ಅಲ್ಲ injunctive decree ಇದ್ರು right to partition ಕೇಳಿಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
Ultimately, my lord would,
That's what.
the next submission make it. Allah, ಅದು ಹೇಳ್ತೀನಿ. Partition is a distribution of right.
Right to partition.
Yes.
Cannot be silenced by an injunctive decree.
My lord, partition does not create a right, but distributes a right.
Correct, that's what.
Therefore, I think that's the. It's a custom.
Yes.
Then my lord, I request my lord's attention to 127 ಓದುದ್ವಾ? 127, page 127. ಅದಾಯ್ತದು, ಆಯ್ತು, I think I read that.
128.
Then 130 ನೋಡ no demand, I think no demand ಮುಂಚೆನೆ ಓದಿದ್ದೀನಿ ಮತ್ತೆ reiteration ಅಷ್ಟೇ ಈಗ. Page 130.
All right, you have read that. We have made notes.
I think
of
that's
it.
sufficient.
Yes.
I'll not read it again and weary your lordship.
ಅಲ್ಲ ನಮ್ಗೆ only order 12 rule 6 ಯಾಕೆ invoke ಮಾಡಬಾರ್ದು ಅನ್ನೋದೊಂದು ಪ್ರಶ್ನೆ ಎದ್ದದೆ, which you have to answer. Where is your
Would your lordship recall Sarguja?
which one?
Sarguja transport. The first time the Supreme Court used the word bench hunting. In that case, the relief sought was, I had asked for a permit, a challenge, it was refused, I filed a writ petition. It came before honorable judge, and on finding and question and answer, he withdrew the petition.
Filed another petition.
Second,
Bench hunting.
successive. At that time, the honorable yes, judgment to do. That's what the honorable Supreme Court would say, that withdrawal does not debar his right to pursue, except in Article 20.
That's right. That is a
Public policy.
no. That is a Sheila Barse versus
Yes,
so and so.
yes.
Right to
Bhagavad
litigate
Gita.
includes right to withdraw the litigation, right to litigate unless the law otherwise prohibits it.
It's a related action. You have informed us. It's our domain. You have lost your jurisdiction. Yes, this is what Bhagavad
Justice
Gita.
Venkatachalaya.
Then, my lord, please turn to page 135.
135.
Paragraph 1. It is true in the document P45, the name shown is Chikkachinanna, who is my grandfather. I do not know whether Chikkachinanna had sold the property bearing number 13 to anybody. Question, whether Chikkachinanna has sold the property bearing number 13 to, I do not know. So this is the property which they claim now. A tracing of title. Yes, schedule. Kindly turn to paragraph 4 at page 136. There. Yes. I do not know when my father.
All right. Who is resisting your claim for a decree of partition in respect of B to E?
No, nobody. ತಾವು ಗಮನ ಕೊಡಲಿಲ್ಲ ಅದಕ್ಕೆ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು ನಿನ್ನ ಇವರ ಕಾಂಡಕ್ಟ್ ಡಿಸೈನ್ ಟೈಟಲ್ ಅಂತ ತಲೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು. ಈಗ ನಾನೊಂದು ಶಬ್ದ ತಪ್ಪು ಹೇಳಿದೆ, ತಾವು ಸಿಟ್ ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ ಕ್ಷಮಾ ಮಾಡಿದ್ರಿ, ಅಲ್ಲಿಗೆ ಮುಗಿಲಿಲ್ಲ ನೀವು ಅಲ್ಲ.
Nothing like that. Only very humbly we say these things.
Yes,
so that
I think that
save public time.
this is sufficient. Kindly come to page 142.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? ಸುಮ್ನೆ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? ಇವ್ರು ಯಾರು?
Paragraph 2. It is true, I have my lord's leave. Page 142, paragraph 2. It is true that all the suit scheduled properties were below.
Page number?
Page 142. ಇದು ಒಂದೇ ಒಂದು ಓದುವುದಷ್ಟೇ. Para 2. It is true that all the suit scheduled properties were belonged to Chinnappa and Chinnappa Reddy alias Chinnappa. More has bರುತ್ತೆ. It is true that after death of Chinnappa alias Chinna Reddy alias Chikkanna, suit scheduled properties had fallen to the share of his two sons. It is true that after death of Munswamappa and Krishna Reddy, these scheduled properties came to the plaintiffs and defendants 1 to 3, but partition was affected. I do not say the exact date of the partition or anything. And the real parties have said there's no partition deed of that. But the said partition has been effected in my house, in my presence. Oral evidence cannot be adduced in respect of document. They cannot now set up this case of earlier partition.
DW3 also says. DW3 at page 148.
No. ನಾನು ಮಾರ್ಕ್ ಮಾಡಿಲ್ಲ.
Third line. First line.
It is true that after death of Muniswamappa and Krishna Reddy, these suit schedule properties came to the plaintiffs and defendants 1 to 3. But the partition was effected subsequently, unearthed. I do not say that exact date, year, etc. So and so.
While the parties to the partition say that we don't have any document partition.
1 to 3 are defendants 1 to 3.
Is it
Defendant of 4, 5 are buyers of the property.
4, 5
Yes,
buyers.
4 and 5.
They are the purchasers of a
Purchasers
smaller
of the
extent,
property.
not this property. It's Shankar claiming the denying the partition.
No, 4, 5 bought property described in Schedule A.
Schedule A.
Yeah,
They purchased it from defendant number 2.
Yeah.
They say that between defendant number 1 and 2, there was a partition.
Page 148 is the last document related. Adela, in Avdilala. Page 148.
148.
Line 7 from bottom. I do not know whether a scheduled property was inherited by the father of Munsam Reddy and Krishna Reddy, but as far as my knowledge goes, defendants 1 to 3 are cultivating land in survey number 37. I do not know partition effected between Krishna Reddy and Munsam Reddy.
Defendant 1 to 3.
1 to 3.
Or cultivating land bearing number 37. 1 to 3. Your
They are not
Purana's
cultivating.
claim.
They are not cultivating.
3 also my claim. 3
No,
also.
no, 3 also
3 is my
must
claim.
be a typing mistake.
is
Lord,
the
it could be defendant 1 and 2.
One
Must
and
be a
2 are
typing
the
mistake. ಹೌದು.
Well, original note because
original note.
huh?
Anyway, it cannot be 3.
Cannot be.
It cannot be 3.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ ಸಹ 1 to 3 ಹೇಳ್ತಾರೆ. I know plaintiffs and his father and defendants 1 to 3 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
Correct.
Typing mistake.
It cannot be 3 at all. What he says is correct. 1 and 2 ಇರ್ಬೋದು.
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ನೋ ಇಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 3 ನಲ್ಲಿ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಇಟ್ ಇಸ್ ಫಾಲ್ಸ್ ಟು ಸಜೆಸ್ಟ್ ದಟ್ ಇನ್ ಆರ್ಡರ್ ಟು ಹೆಲ್ಪ್ ಡಿಫೆಂಡ್ಸ್ 1 to 3. ಥರ್ಡ್ ಡಿಫೆಂಡೆಂಟ್ ಇಸ್ ಪ್ಲೇಂಟಿಫ್ ಕೋ ಪ್ಲೇಂಟಿಫ್. ಅರ್ಲಿಯರ್ ಸೂಟ್ ಜಾಯಿಂಟ್ ಆಗಿ ಹಾಕಿದ್ರು, ಈ ಸೂಟ್ ನಲ್ಲಿ ಅವರು ಡಿಫೆಂಡೆಂಟ್ ಆಗಿ ಇಟ್ಟಿದ್ದಾರೆ. ಥರ್ಡ್ ಡಿಫೆಂಡೆಂಟ್ ಈಸ್ ದಿ ಬ್ರದರ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟಿಫ್ who is entitled, who is granted 1/4 share in the properties, 2 properties. Well, this is the reading of the evidence. Sakalapur.
In para 3 also, he says the same thing.
Yes, same
1 to
thing.
3.
ಅದು ಅಲ್ಲ ಅದು ಬರ್ಕೊಳ್ಳೋ ಎಲ್ಲ ಥ್ರೂ ಔಟ್ 1 to 3 ಮಾಡಿದೆ ಬಿಕಾಸ್ ಅವ್ರು ಕಂಟೆಸ್ಟಿಂಗ್ ಅಂತ ತಿಳ್ಕೊಂಡಿದ್ದಾರೆ ಅಷ್ಟೇ, ಇನ್ನೇನು. ಇಟ್ಸ್ ಅನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಬಲ್ ಎರರ್.
1 and 2 we cannot.
1, 2 ಮಾತ್ರ ಕಂಟೆಸ್ಟ್ ಮಾಡ್ತಿರೋದು. 3 is not contesting. 3 is Male's client.
Sailing with the plaintiff.
That's what.
The brother of the plaintiff.
Brother of the plaintiff.
Well, in sum, the suit for partition has to be treated differently than a commercial suit. The relationship and the personal law of Hindu law, the right given, this is still as a Shastrik Hindu law. The right to partition is a Shastrik Hindu law. It is not governed by any statute. The only remedy available in statute can suffer from Section 3 of the Limitation Act. Section 3 prescribes limitation only to statutory rights enforceable, rights, and not this. So the suit for partition, I am submitting that my earlier suit, the issue now was lost glance. And 68.
Understand. But you mean to say never it is legislative?
Partition Act of the pre the pre-constitution law,
Correct.
the one section which operates today is he who seeks partition shall not buy the property. That's the prohibition. That pre-constitution is there to say that he who comes to the court seeking partition throws the property, say, to the common part, and it is liable to be distributed. He can choose and he can't participate. That's the law declared. Otherwise, there is no other inhibition. And my suit is suit to partition. The Partition Act is post-decree the matter, and not pre-decree matter. That's the situation. Because the right to purchase comes
Right
only
to-
in
right-
final decree.
No, two things. Right to partition has two aspects which Duncan C. Direct says. Right to partition is a secular right where it arises because you are holding the property in commonalty.
Yeah.
Right to partition amongst Hindus is a misnomer. Right to partition of the family will give right to division of the estate.
Yes.
This is how he treats. There can be partition of a family which does not own any property at all. In fact, Raghavacharya discusses that. To partition a joint Hindu family, there need not be property. But if partition takes place in a joint Hindu family, resultantly, the division of estate would take place. All through Indian courts are treating.
Once and for all, irreversibly.
Yes, always. You have right to reunion, stronger evidence and other things.
Except for impartible estates.
That's impartible estates are
They are excluded.
excluded.
It's the situation. The plaintiff has made out a case for interference as far as the cross objections are concerned, and the plaintiff would fervently feel that his right cannot be jeopardized by a buyer of the property, citing reasons which are peculiar to Hindus and in brothers and sisters. Bloodfoot words.
ನಾ ಹಿಂಗ್ ಹೇಳ್ದೆ ಅಂತ ತಪ್ಪು ತಿಳ್ಕೊಬಾರ್ದು ನೀವು ಬಹಳ ಹಂಬಲ್ ಆಗಿ ನಾ ಹೇಳಿದ್ದೇನೆ ನನ್ನ ಅಸರ್ಷನ್ಸ್ ಎಲ್ಲ ಮತ್ ನಿಮ್ಗೆ ರೈಟ್ ಆಫ್ ಕ್ರಾಸ್
ಆ ಶಬ್ದ ನನ್ನಿಂದ ಬರಬೇಕು.
ನಿಮ್ಗೆ ರೈಟ್ ಆಫ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೊಟ್ಟೆ ಯು ಕ್ಯಾನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮೀ ಆನ್ ದ ಸಬ್ಜೆಕ್ಟ್ಸ್ ಆಲ್ಸೋ.
ನಾನು ಹೇಳಿದ್ದೇನೆ, ಕ್ಷಮಾ ಮಾಡಿ.
ಏನು ಯು ಆರ್ ಎ ಟಾಲ್ ಲಾಯರ್. ಯೆಸ್, ಮೆನಿ ಟೈಮ್ಸ್ you were advocate of our choice when we had the pleasure of being Surana. So far as A is concerned, Surana, so far as A recorded, you have no claim whatsoever.
So these are not the properties belong to joint. That is true, but there can't be a decree against me.
No, as against you very well, no issue.
They
Question
can
is-
take, if they say they are in joint position, we have no objections for them to enjoy. ಅಲ್ಲಲ್ಲ, ಇಲ್ಲ. See, they are, see, in D schedule property, there is a temple. Ganesha temple is there, now existing from last 35 years.
ಅದು ನಿಮ್ಗೆ ಏನ್ ಸಂಬಂಧ ಪಡ್ತದೆ?
ನಮ್ಗೇನ್ ಸಂಬಂಧ ಇಲ್ಲ.
ಬಿಡಿ ಮಾತು. 12-6 ಆಗುತ್ತೆ. Now we are thinking in terms of 12-6. Judgment on admission. ನೋಡ್ಕೊಂಬಂತ ಹೇಳಿ. Judgment in admission ಮಾಡಕ್ಕೆ in the sense, you may not suffer, but you will record that you have no claim whatsoever against these properties.
The question is whether the decree can be drawn in the midst of the matter. We are concerned, see, of the properties which does not belong to anybody of us.
Who are you?
Who
are you?
That is true.
Who are you?
Therefore, there can't be a decree for possession. They are not seeking.
You can't make a decree.
There can't be a decree for the partition of those properties. If they are in possession, let them enjoy it. We will not interfere with them. See, they are not seeking for a declaration of title. Partition can only be granted if it is joint family property and if I am the owner. When I am not at all concerned with the properties, the question of granting a decree for partition
As against you will not arise.
arises.
ಏನ್ ರಿಪ್ಲೈ?
Lord, I would need about half an hour to 40 minutes.
Half an hour. Do it tomorrow.
Yes, please. And anytime I repeat whatever Mr. Shankar has said, Lord, your lordship can stop.
That's what. He has poached every point now. I do
I
not know.
will-
Of course,
I-
you may have.
I would,
Till,
I will point out certain things, Lord.
you are D3.
Definitely.
D3.
But in a suit for partition, Lord, everybody.
Partition, therefore, it makes no difference. Or as between them, inter se, if they effect the partition, can you object to that?
That there be a decree against plaintiff and the defendant number 3 not made.
That's what. Therefore,
ಒಂದು ಎರಡನೇದು there is no proof that these properties are the joint family.
who are you to, you are Bill Clinton to the case. To use some name. Who are you? Anyway,
For the
you have
purpose of-
said you can only say,
Only submission, my submission.
I am
is-
alien to all
My
those.
submission is merely because the third parties who are owners of properties are not part of the record. Third party interest should not suffer because of this kind of the prayers before the court.
Who are the third parties?
So there are there, I will demonstrate.
Third parties?
The property belongs
purchased
to
from
somebody else.
defendant. Who purchases from defendant number?
Not the purchaser. The other properties are the one that does not, never belong to any of the family members.
Who are you to say this, Santa?
The
What
records
is
are
your
there.
no, not like that. What is your locus to take up this contention ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ?
No, that I am not saying, for a moment, I am not saying that way, my lord. But the question is,
Question 100 questions, 1000 questions may arise before the court. But some
I
right
will-
person.
I will give my
right
reply.
person brings
Very well, I
those
will give my
questions we will
reply.
entertain.
On that day. After my friend concludes it, I will give my reply.
Tomorrow, Lord.
Tomorrow,
Tomorrow, 2:30.
no issue. Alright, ಸ್ವಲ್ಪ complete.
From 15th onwards, for a week, I will not be.
Till
From 15th to 22nd, I would not be.
ನಾಳೆ
I'm leaving the shores of.
ನಾಳೆ ಮುಗಿಸೋಣ. ನಾಳೆ ಮುಗಿಸೋಣ.
Permission.
Ah.
Number 31. Lords have disposed the matter. I got instructions little late, my lord.
Huh?
I got instructions little late. My humble apology, my lord. The DPC which my lords have pointed out, that is not relevant to the petitioner, my lord.
Why?
My lord, his seniority, my lord, they are asking in par with other,
ಆಯ್ತು ನೀವು ರಿವ್ಯೂ ಹಾಕಿ. If that is so,
my lord.
file review.
My lord, his seniority will not come in 2020 DPC, my lord. In 2022 DPC, his seniority will come. My lord,
Yeah.
rule says that if there is,
Therefore, we have directed you to consider his case
I will,
on par with the rest of the people.
my lord, I will, it may be
It will be
taken
so.
tomorrow, my lord. My lord,
No.
it will-
We have dictated
Being
it in the
spoken
open
to.
court.
being spoken to.
No. Final, being spoken to is in the body of the order ನಲ್ಲಿ ಸಣ್ಣ ಮಿಸ್ಟೇಕ್ ಇದ್ರೆ ಅಷ್ಟೇ. ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ being spoken to ಇಲ್ಲ. ರಿವ್ಯೂ ಹಾಕೊಳ್ಳಿ.
Submission, Lord's permission. My lord had directed the central government to the DOPT to produce the file
Yes.
in serial number 36.
Have they brought that file, that IAS matter na? AAS to IAS, huh?
Yes, my lord.
You have brought the file?
Lord, that is an e-file, my lord, that has been sent.
Available.
That is available, my lord. I'll place it before your lordship.
ನಮ್ಗೊಂದು ಹಾರ್ಡ್ ಕಾಪಿ ಕೊಡಿ.
Please, my lord, it is there.
Call
I'll
this
place it.
matter tomorrow.
Lord, if we may be permitted to go through the file because it is an
Urgent
RTI,
report.
we had asked for, it's an open file.
Subject to your lordship directing us.
Learned DST submits that the file sought for by the order dated so and so is available in e-form.
That is sent to me in e-file, my lord. That is an
In
e-file.
form being sent to him from the quarters that be. First, learned DSG is instructed to share copy of the file with learned counsel, Mr. KT appearing for, learned counsel appearing for the petitioner on record.
For the respondent.
For the respondent. Learned counsel appearing for the respondent.
My lord will be posting it on
ಯಾವತ್ತು?
Nade.
ನಾಳೆ ಸ್ವಲ್ಪ ಡಿಫಿಕಲ್ಟ್ ಆಗ್ಬೋದು ಯಾಕಂದ್ರೆ ಇದೊಂದು ಆಲ್ರೆಡಿ ಇದೆ.
Because
some other
may I submit, my lord? Only 10 minutes will be required, not more, because what flows from there, some other direction will be required, my lord. It is still far away to start the hearing, my lord. May I humbly make that statement, my lord? After I am finished with DOPT, I will start with the petitioner, my lord. It is virtually a series of directions that will be required. No wastage of time of the court to hear the main matter. That is my humble submission. I will, of course, I am in the hands of my friends and my lords.
ನಾಳೆ ಹಾಕೊಂಡು ಲೆಟ್ ಅಸ್ ಟ್ರೈ. ನಾಳೆ ಪೋಸ್ಟ್ ಆಗಲಿ.
Please.
Let us take a chance.
Okay? Please.
Submission, my lords. I had moved this matter before the single judge. The matter was directed to be listed tomorrow. My tenant is under threat of dispossession. It's a matter arising out of challenge of DRAT. Therefore, the scrutiny branch told me that it will have to be moved before the division bench. There's urgency, there's urgent threat of dispossession. So I'm requesting for listing tomorrow at 2:30. I'm apologizing, I'm moving the matter now because there is threat, my lords.
2:30.
Tomorrow, my lords, or if morning also, because the file is under scrutiny now. If it can be.
But then actually, 1:30, 1:25. Huh? ನಾಳೆ ಮೂವ್ ಮಾಡಿ.
I'll be grateful.
ಸೀರಿಯಲ್ ಬೆಳಗ್ಗೆ ಯಾಕೆ ಇದು ತಗೊಳ್ಳಿ ಎಷ್ಟು ಸರಿ ಬರ್ಬೇಕು ಲಾಯರ್ಸ್ ಮೂವ್ ಮಾಡ್ಲಿಕ್ಕೆ.
I'll come to you.
But serial number 32 is pertaining to suspension. Last occasion, my lords had heard, but may I request Nick, short date, not suspension beyond 6 months. My only argument is, my lord, there cannot be suspension beyond 6 months in view of Rule 10(5)(b).
2 weeks ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟು.
34 covered by decision, my lord. Identical matters have been allowed, my lord.
34 next week ಹಾಕೊಳ್ಳಿ.
My lord, serial number 35, kindly have it draft to tomorrow, my lord.
ಇಷ್ಟು ಅರ್ಜೆನ್ಸಿ ಎಲ್ಲರಿಗೂ ಯಾಕೆ ಇಷ್ಟು ಅರ್ಜೆನ್ಸಿ?
ಅಲ್ಲ ಅದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಬರ್ತಾ ಇದೆ ಅದರಲ್ಲಿ.
ಯಾವತ್ತು ಬರ್ತಾ ಇದೆ ಎಕ್ಸಿಕ್ಯೂಷನ್?
25th of November ಇದೆ.
25th of November.
My lords, I appear for the respondents in 35, please, my lords. Kindly next Monday or Tuesday, please, my lords, if it is convenient.
It is not convenient to us.
I leave it to my lords.
Sir, 32 ಯಾವ ಡೇಟ್ ಕೊಟ್ರಿ ಸರ್? 32 ಒಂದ್ ಡೇಟ್ ಕೊಡಿ ಸರ್. ಒಂದ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ ತರ ಆದ್ರೆ ಕೊಡಿ ಸರ್.
28
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಎಲ್ಲಾರು ಒಂದು
ಸಾಹೇಬ್ರು 2 weeks ಆದ್ಮೇಲೆ ಅಂದ್ರು.
20
ನಿಮ್ದು 28th ಸರ್.
ಸರ್ 35 ಏನಾಯ್ತು?
Serial 35
30
Monday ಅಂತ ಹೇಳಿದ್ರು ಸರ್.
ನಿಮ್ ನೆಕ್ಸ್ಟ್ 35 ನಿಮ್ದು 20th ಸರ್. 35 28 36 ನಾಳೆ. ಇದು ನಾಟ್ ರೀಚ್ ಜಸ್ಟ್ 2 weeks ಅಷ್ಟೇ ಇದು. 38 ಮೇಡಮ್. ಹಾ ಮೆಮೋ ಕೊಡಿ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನಾಳೆ ಹಂಗಾಗಲ್ಲ ಸರ್. ಸರ್ ನಮ್ದು ನೋಡಿ ಇವಾಗೆಲ್ಲ ಡೇಟ್ ಕೊಟ್ರು ಅಷ್ಟೇ. 2 weeks ಅಷ್ಟೇ.
Sir, 36. Sir? List of 2.
ಎರಡು ವಾರ ಆಗೋಗಿದೆ. ನಾವು ಏನೋ ಇದ್ರಾಗ ಒಂದೇ ಎರಡು ಇರ್ತದೆ. ನನಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ನೀವು ಹೇಳಿದ್ರಲ್ಲ ವೀಕ್ ಅಂದ್ರೆ ನಮ್ಮ ಬಂದೇ ಬರ್ತಾರ. ಅಲ್ಲ ಇವತ್ತು 12 ತಾನೆ. ದಯವಿಟ್ಟು ಹೋಗ್ಲಿ 15 ಕಾಲ ಕೊಡ್ರಿ. ಏನೋ ನೀವು ಕೇಳ್ಕೊಂಬರ್ ನಮ್ಮ ಇದು ಎಲ್ಲ ಡೇಟು ಮೂಲ ಅದು ಡಿಫರೆನ್ಸ್ ಅಮೌಂಟ್ ಡೇಟ್
This done 28/11/2024, request of council for promotion. ಅದ್ಮೇಲೆ ಲೇಟ್ ಇದೆಯಾ? ಮುಂಚೆ ಹೇಗೆ ರೆಕಾರ್ಡ್ ಮಾಡ್ತೇನೆ. ಮಾಡ್ತಿದ್ರೆ
ಸರ್ ಅದಿಗೋ ಫೋನ್ ಮಾಡಿ ಸರ್ ಪೆಂಡಿಂಗ್ ಕೊಡ್ಬೇಕು. ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ಸರ್ ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಮಾತಾಡಿದೆ ಸರ್. ಸರ್ ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಮಾತಾಡಿದೆ ಮಂಡೇ ಅಂತೇಳಿ ನಾನು ನಿಮ್ಮ ಹತ್ರ ಮಾತಾಡಿ ತಗೊಂಡೆ ಸರ್. ಲಾಸ್ಟ್ ಮಂಡೇ ಫೈಲ್ ಮೂವ್ ಮಾಡಿದ್ದು ಮಂಡೇ. ಅಲ್ಲ ಸರ್ ನೀವು ಹೇಳಿದ್ದು ನನಗೆ ಡೈರೆಕ್ಟ್ ಆಗಿ ಮಂಡೇ ಮೂವ್ ಸರ್ ಅದು ಇಂಪಾರ್ಟೆಂಟ್ ಆಗಿಲ್ಲ ಸರ್. ಅವ್ರು ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ಅಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಅವ್ರು ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಕೊಂಡು ನಿಮ್ಗೆ ಬರೋಕ್ಕೆ ರೆಡಿ ಆಗಿಬಿಟ್ಟಿದೆ. ಅಲ್ಲ ಸರ್ ನಾನು ನಿಮ್ಮ ಜೊತೆ ಮಾತಾಡಿ ಮತ್ತೆ ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಮಾತಾಡಿ ಕನ್ಫರ್ಮ್ ಮಾಡಿ ಸರ್ ಅಷ್ಟೇ. ಡೇಟ್ ಕೊಡ್ತಿರ್ಲಿಲ್ಲ ಸರ್ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ. ನಾನು ಅವ್ರಿಗೆ ಅವ್ರು ಶೆಡ್ಯೂಲ್ ನೋಡ್ಕೊಂಡು ನಾವು ಬುಧವಾರ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ಮತ್ತೆ ಪೆಂಡಿಂಗ್ ಜೊತೆ ಮಾತಾಡಿ ಅದು ಮೆಮೋ ಅಲ್ಲೇ ಇತ್ತು ಸರ್. ಇಲ್ಲ ಮೆಮೋ ನೋಡ್ಕೊಂಡು ಅವ್ರಿಗೆ ಹೇಳಿ ತಪ್ಪಿಸಿಟ್ಟೆ ಹೋಗಿದ್ದೀನಿ ಸರ್. ಲಾಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಬಂದು ಮಂಡೇ. ಇಲ್ಲ ಸರ್ ಇಲ್ಲ, ನಾನು ಮಂಡೇ ಮೆಮೋ ಮಾಡಿದಾಗ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಬರುತ್ತೆ ಅಂತ ನೀವು ಹೇಳಿದ್ರಿ. ಅವಾಗ ಏನಾಯ್ತದು ಮಂಡೆಗೆ ಅವ್ರು ಬರ್ಲಿಲ್ಲ, ಬರೋಕ್ಕಾಗಲಿಲ್ಲ. ಅದಕ್ಕೆ ನಾವು ಬುಧವಾರ ಹಾಕ್ಸ್ಕೊಳ್ತೀನಿ ಬಿಡಿ ಅಂತೇಳಿ ಅವ್ರ ಜೊತೆ ಮಾತಾಡಿ ಫೈಲ್ ತೆಗೆದು ಕರೆಕ್ಟಾಗಿ ಇಟ್ಟರು. ಅವರು ಬೆಳಿಗ್ಗೆ ಹುಡುಕ್ತಾರ ಅವ್ರಿಗೆ ಫೈಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ. ಬೆಳಗ್ಗಿಂದ ಅದನ್ನೇ ಫಾಲೋ ಅಪ್ ಮಾಡ್ತಿದ್ದೀನಿ ನಾನು. ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್ ಸರ್. ಸಾರಿ ಸರ್. ಇಲ್ಲ ಸರ್ ಅದೇನು ಏನಂದ್ರೆ ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್ ಸರ್. ಪೆಂಡಿಂಗ್ ಸರ್ 23 ಪೆಂಡಿಂಗ್ ಇರೋ ಸರ್. ಸರ್ ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಅದೇ advocate. ಏನು? ಅಲ್ಲ ಒಂದ್ ಫೈಲ್ ಆಡ್ ಮಾಡಿದ್ದಾರೆ.
ಅದೇ ಚೆಕ್ ಮಾಡೋ ಯಾವ್ದಕ್ಕೆ ಅದು
ಇದಕ್ಕೆ ಹೇಗೆ
ಪೆನ್ಸಿಲ್ ಕೊಡಿ. ಹಾಗೆ ಸೆಕೆಂಡ್ ಪೇಜ್ ಪಿನ್ ಹಾಕಿಲ್ಲ ನಮ್ಗೆ.
ಅದೇ ಗೌರ್ಮೆಂಟ್ ಹೋಗಿತ್ತು ಅದು ಇತ್ತು ನಾಳೆ ನಾಡದಾಗೆ ಅಂತ ಹೇಳಿ ಈಗ 5 ಕಾಲ ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟು ಅವರು ಹೇಳ್ತಾರೆ ಕಳ್ಸಲ್ಲ ಅಂತ ಬೇಡ ಅಂತ. ಇದು ಅದು ಫೈನ್ ಇರಲ್ಲ ನೋಡಿ ಫೈನ್ ಇದೆ ಆಲ್ರೆಡಿ ಟೋಟಲ್ ಮೂವ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ಕೊಳ್ಳಿ ಕಾಣ್ತದೆ ಹಾಕಿದ್ರೆ ಈಗ ಇದ್ರೆ ಸಾಕು ಆಲ್ಮೋಸ್ಟ್ ಎಲ್ಲರೂ ಮೂವ್ ಮಾಡ್ತಾ ಇದಾರೆ ಬರೀ ಟೋಟಲ್ ಇರ್ಲಿಲ್ಲ ಅಂದಾಗ ಅಂತ ಹಾಕಿ ಮೈನರಿಂಗ್ ಯಾವ್ದು ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಇಲ್ಲ ಅಂತ ನೀವು ತಿಳ್ಕೊಂಡಿದ್ದೆ ಟೋಟಲ್ ಮೂಡೇ ಇಟ್ಕೊಂಡ್ರೆ ಮೈನರಿಂಗ್ ಲೈಫ್ ಮೇಲೆ ಇದ್ರೆ ಆ ಪಬ್ಲಿಕ್ ಒಂದು ಕಾಪಿ ಕಳಿಸಿದ್ರೆ ಬೇಗ ಅಂದ್ರೆ